I'll be on there.
Oh, it's... Right, good morning, everyone. Let's resume, please. Day 8 of the inquiry today, and we're continuing with planning witnesses, hearing first this morning from the witness for the Gurdwara. Before we get started, could I just raise a couple of matters? We're going to be having a session tomorrow on conditions and planning obligations, and they've been submitted to me. Are there any disagreements outstanding in relation to conditions and obligations, or is everything agreed in terms of compliance with the SIL regulations and the test for conditions?
Yes, I think everything is now agreed, and I had confirmation from our solicitors this morning that it's in an agreed form now.
Right, thank you. That's the appellant's understanding. Yes, good. All right, well, good. So that should cut down the amount of time that we'll need for those sessions. Just in terms of my planning for tomorrow, I just wondered whether advocates could give an indication of how long they think their closing submissions are going to take. So if we start with the council.
Good morning, sir. I would anticipate around an hour.
Thank you. Ms. Clutton?
Yes, the same, sir.
Ms. Malik? 15 minutes, thank you. And Mr. Strawn?
Might be an hour and a half if I'm covering everyone.
Right, thank you. Okay, are there any other matters then that anyone wants to raise this morning before we continue with the evidence? No.
Thank you. Well, good morning, sir. Good morning, everyone. I will call my final witness then, please. Good morning, Mr. Robinson.
Morning.
You are Paul Anthony Robinson, MRTPI.
That's correct.
You have, for 26 years, worked in development management roles, including 15 years in the public sector within various roles across London boroughs and elsewhere in the country.
That's correct.
You have a planning and landscape BA honours degree in town and country planning and a BPL Bachelor of Planning.
Yes, correct.
And since September 2012, you've primarily worked in the private sector at the head of your own consultancy, Orbis Planning.
Yes, with there's been some secondments to councils in that period, but primarily that's been my role.
Thank you. Subject to the errata sheet that you provided yesterday, are the contents of your proof true and reflect your true and professional opinions?
Yes.
Thank you. Now, you described the purpose of the work that you were commissioned to undertake at paragraph 1.2 of your proof, and I'm going to go through some of the output of that work, and I'm also going to ask you to respond to a number of points that have been made by the appellant's witnesses, both in their written evidence and in their evidence to the inquiry. First of all, you make clear in your proof that you do not address the council's reason for refusal 3 or the Perkins close aspects of reason for refusal 2, and you set out in your proof at paragraph 2.6 why that is. You explain you're focusing your evidence on the Gurdwara's concerns, and you say, in your view, if the inspector accepts those other arguments, they represent further reasons for refusal or additional adverse impacts to be weighed in the balance. But your assessment is that even without those points, planning permission should be refused. Can I just ask you, first of all, Mr. Robinson, in your view, is there any possibility that these matters, if resolved in the favour of the appellant, could give rise to planning benefits that you've missed out by not addressing?
No, I don't believe it would.
Now, you go on in section 4 of your proof to deal with the role and the significance of the Gurdwara in the community. And I want you to cast your mind back, please, to the first day of the inquiry and the evidence of Mr. Adan. With the exception of finances, which we'll come back to, do you recall there being any substantive challenge to the factual evidence presented by the Gurdwara?
No, I do not.
Later on in your proof, at paragraph 6.2.5, you refer to a lack of understanding on the part of the appellant about the day-to-day activities undertaken at the Gurdwara, and you make similar points elsewhere in your proof, for example at 8.3.1 and 9.2.6. You were here to hear the evidence of the scheme acoustician and the lead architect, weren't you?
Yes.
What was your understanding as to their understanding of the Gurdwara's activity at the pre-application stage?
From the evidence, well, from both really. Obviously, I've made a review of initially back in 2022 in March, where I've made a review of the documents, and that's covered in my proof. In regards to the evidence presented by the architect witness and others, it doesn't change that view that fundamentally the day-to-day activities and the wider use and complexity of the use of the Gurdwara and the spaces around it weren't they just weren't recognised. I can't put myself in their shoes, but it's on the basis of the evidence given that it didn't form a basis for their design approach. Not in the depth that we feel was required.
Okay. So I think you've sort of answered this question in your last one, but just so the inspector has a clear note, what's your view as to whether proper account can therefore have been taken of that wider use of the Gurdwara and the complexity of the uses in the design of the building?
I don't believe it can have been.
Okay. Now, in terms of the range of events that are held at the Gurdwara, and particularly those in the outdoor areas, the noise experts have focused on the impact of the playing of the Nagara. Can I ask you for your views, please, on the relevance of events other than the playing of the Nagara to your points about the amenity or privacy or the impacts on worshippers using the forecourt area?
Yes, I mean we have focused on this because on the Nagara has been, frankly, it's the loudest instrument. There are many other instruments as set out in Mr. Adan's proof. I can't quite remember the names and pronunciation of them all, but there's a section in there with the dole, etc. And they're played perhaps in a less ceremonious level, but they do take part in other ceremonies which involve significant day-to-day aspects such as weddings and funerals. And they obviously have a different nature to them, but there are weddings in particular are obviously quite joyous occasions, and can involve quite varying degrees of people as well as noise, etc.
I mean, I'm less focused here on the noise aspects of things that are going on, but more trying to understand from you how relevant or otherwise you say that events in that forecourt area or the frequency, what the frequency of events is in the outdoor areas that might be relevant to the reason for refusal too.
Right. Yes, I was kind of coming to that, but
Sorry.
there are a frequency of events. There's about 100 on average. It changes, and we've had COVID, so it has changed and what have you. But on average, there's about 100, between about 95 and I think the evidence was saying there was about between 55 and 116 weddings per annum. The lower one being the COVID period. So roughly about 100, and the same for funerals. So we've got about 200 events throughout the year there, where there is, as well as the festivals and what have you, which take place in that ceremonial area. We've talked about the Milne, for example, where wedding guests meet and they come in at the entrance of Alice Way and make their way up the car park ceremonial area and congregate there. So it's an important part of the Gurdwara's estate, its activities, and it happens in relative seclusion at present.
Well, we'll come on to that point in due course. In terms of the public benefit offered by the Gurdwara, both to the Sikh and the non-Sikh community, how much weight do you attach to that and its continuation?
Sorry, can you just repeat that?
Yes, in terms of the public benefits that are offered by the Gurdwara, both to the Sikh community and to the wider community, how much weight do you afford those and the continuation of those?
You attach significant weight to that. It's a very important part of obviously the local Sikh community, but the wider community as well. And I think it's recognised by the council as such. So I attach significant weight to that.
Thank you. Okay. Just turning then to the Gurdwara's finances and their relevance, the oral evidence given by Mr. Adan had suggested that the Gurdwara had around £8 million, what I'm going to describe as cash in the bank. And the position has been corrected in the note that was submitted to the inquiry yesterday morning. Can I just ask you to outline what that explains, please?
Yes, it's. I think at the time as you say, the response under questioning was under cross-examination was about £8 million. The note refers back to the end of year accounts, I think, from the end in 2022, and show that the majority of that is fixed assets such as the buildings and estate and what have you. And there's a confirmation there that the actual cash at the bank, as it were, the statement is there or thereabouts, about 500,000, but that varies.
Thank you. Now, there are 2 points arising out of that. Firstly, the relevance of the cash in the bank to viability, and the implication of what was put to Mr. Adan appeared to be that any reduction in attendance could be weathered by the Gurdwara because of their cash reserves. Can I ask, do you consider that suggestion to be a legitimate or fair one, if that is what's being suggested?
No, I don't think it's fair to put that onus on the Gurdwara. In a sense, it goes back to the agent of change principles, and which I'm sure we'll get onto, where it talks about the ongoing viability. But either way, even if you were to weather the storm for a period, that impacts themselves wouldn't go away, and therefore you'd end up with you kick the can down the road, as it were. So I don't think it's relevant to the consideration of it at all.
Thank you. Now, the second point then on this, it was also effectively put to the Gurdwara that, well, you've got £8 million in the bank, you should buy Block A, and then you can avoid the issues of concern to you. Again, do you consider that to be an answer to the Gurdwara's complaints?
No. Not in a practical sense.
Okay.
I should say not in a reasonable sense, put it that way.
Yes, in a practical sense it might work, but
Yeah.
Is it reasonable?
I don't think it's a form of good planning, put it that way.
You don't think what, sorry?
It's a form of good planning that we would expect people to kind of take over to remove impacts on them by occupying that land. It's
Yes.
just not reasonable.
Thank you. Okay. A consultation with the Gurdwara then, please. Mr. Adan's evidence raised the issue of the adequacy of the consultation, and it was put to him that the appellant was aware of the issues raised by the Gurdwara, but simply didn't agree with them. Now, we've already dealt with the position of the scheme acoustician and the scheme architect a moment ago, but just dealing with the application documentation, do we find support for that assertion anywhere in the application documentation?
Not from my reading of it, no, I don't find it.
Okay, we'll move on then, please, to noise impacts and agent of change. The inquiry is obviously heard extensively in relation to the substantive impacts, and I don't intend to go over those in any detail. There are just a few points that I do want to pick up. First of all, I understand that there's a factual point that you'd like to address relating to the occasion on which Sol Acoustics measured the Nagara noise on the balcony. Do you recall that? This is the November 22 measurement, I think. I forget the exact date.
I think it was April 14th.
It's the one that we see that we watched the video of in the inquiry. What's the factual point you wish to address?
Well, we saw the video of the Nagara being played on the balcony. There was discussion about whether the person playing it was restricted and what have you. And the noise witness for the appellant gave a view that he wasn't. This discussion was had that would to try to establish that for the inspector's benefit that was the most reliable. That coincided with the noise evidence on the sound power of the Nagara given in evidence. And that was the most reliable source of information that the inspector could rely on. We weren't aware until the video was shown, but it became apparent that the person playing the Nagara that day was in fact a 13-year-old boy. And there were three that day. There was two 13-year-olds, and then later there was an 18-year-old who also played. So the children of the Nagara, of the Gurdwara, were given that role, and the person in that video was a 13-year-old boy.
Okay. And what, if any, relevance, or what is the relevance that you say that has to the issues
well,
before the inspector?
I think the relevance would be that it would question whether the inspector can rely on that sound power output as being necessarily the most reliable sound power to go from. The implication being that an adult, because it's quite a physical process, may or could create a higher sound power level, which was evidenced in, I think, the appellate Mr. Duncan's sound power measurements, and also Mr. Shrivener's measurements of Linda Gara in a non-ceremonial situation.
Okay. So,
So just sorry.
I want to...
Excuse me. So it probably doesn't matter, because when you go back over the evidence, you'll see the sound power levels consistent with another noise reading when it was played in the courtyard. That was the point about the two matching up. But insofar as new evidence is now being admitted, not just on the penultimate day, but in circumstances where we started this inquiry many months ago, the video in question available, I think it formed part of Mr. Leach's evidence. There's no basis for this sort of attempt to introduce new evidence at this stage. I mean,
Yes,
it raises a question. I mean, the notion that a 13-year-old boy, you can judge by the size of the boy, somehow can't play the drum as loud as someone else, in circumstances where another 18-year-old boy then played it, all of which is captured in the reading. It's both not only hearsay in that sense, but it's obviously not been put to the relevant noise witnesses whether that would make a blind bit of difference.
I did put, actually, that point has been put. I made the point during the cross-examination of Mr. Leach that the fact that someone, there might be different people who were able to play at different levels, including, strong men. That point was put. That's why I'm content to deal with this point now. It seems to me that the points that my learned friend is making can be dealt with in submission.
Well,
Let me finish. Mr. Robinson is saying he's seen a video. He understands he's subsequently found out that this was a 13-year-old boy. That information has come to him late. He's made the point, so you can decide how you deal with that in your evidence. But the effects of that and what flows from that have been put to the noise witness. Mr. Leach is not in. You don't need a qualification to decide whether someone's a 13-year-old boy or not, and that's the factual point that Mr. Robinson has addressed. I suggest that this can just be dealt with in submissions, and that could be the end of it.
you can brush it under the carpet in that way, but you're the one seeking to introduce it.
Okay, well, I've heard what both parties have said about it. It does seem unfortunate that this is only being introduced at this stage when we've heard from the acoustic witnesses.
Yes, as I say, so no relevance to the acoustic witness specifically in terms of the facts, and the information didn't become available to now, so that's why it's come at this
I've
stage.
heard that, yes. I don't think that it's going to have too much significance in terms of the outcome of the case, but yes, you can both make submissions on that if you wish to do so.
Thank you. Now, let's then look at three areas in relation to event noise. Firstly, I just want to touch on a few policy matters. Then I want to just look at the impacts that you've taken into account in your planning assessment, and then what you consider that to mean in terms of policy compliance. I'll come on to deal separately with other nuisance type impacts to be taken into account, and also the latest proposals in relation to screening, talking about late submissions. Policy, then, please. You've set out your understanding of noise-related policy in your proof at 8.2. Obviously, we've also heard from Mr. Ringer on this, and so I don't want to spend too long on these, but just a couple of points to pick up. Firstly, in relation to D13, please. Just picking up on a point that was made yesterday, in your view, is the application of the agent of change principle limited to addressing significant adverse impacts?
No, I mean, it was covered quite a bit yesterday, but my opinion, my view on this is that no, it's not limited to just considering significant adverse impacts or significant impacts.
And are you able to give a brief reason as to why that is?
Yes, well, D13 itself, it doesn't actually mention significance at all, I believe. But it also, obviously, it's related to D14 too as well. But D13 on agent of change, it asks us to mitigate and minimise, which kind of corresponds back to it looks at a good practice way, in a sense, of minimising adverse impacts, not just significant impacts, but any adverse impacts.
Thank you.
I appreciate that, obviously, as per the discussion yesterday, that the NPPF at paragraph 187 does talk about significance, but within a London sense, policy D13 is the development plan, and that forms part of the policy that we have to relate it to. So it's relevant within the context of D13.
And I mean, just referring back to things like the noise policy statement for England, does that say that you only mitigate and minimise significant impacts?
No, it tells us to minimise them to where possible.
Okay. We've obviously also heard a lot at the inquiry to date about external amenity areas and the impacts on those. I just want to ask, what's your understanding as to the policy standards or objectives that are applied to private external amenity areas in the development plan or otherwise?
In terms of the quality, in respect to
Yes.
them, well, it's set out in both the Hounslow local plan and London plan and the housing SPG, where the housing standards in the SPG, as well as policy D6, set out the minimum standards, and it brings in the importance of external private space as well as internal private space, and kind of deals with it as a whole, in a sense, insofar as creating a place of refuge, I think the word is used, away from the hustle and bustle of London. I don't think it uses quite that phrase, but that's the gist of it. And it talks about that the amenity space should be used for its intended purposes, which is to provide a level of private amenity. Within that, there are minimum size positions and requiring them to be 1.5 meters deep, which allows a sense of movement and space within that. So the importance of amenity space is and the quality of it is set down in, I think, policy D6, housing SPG, paragraph 2331, and SC5 of the Hounslow local plan.
Thank you. Okay. Now, moving on to what you've taken into account, in paragraph 8.5.3 of your proof, you set out your understanding of Mr. Duncan's position that you had taken into account, in which you identified the fact that he said that the noise assessments concentrated on average noise levels, which ignored the character of the site. You thought there ought to be further mitigation. The failure to take into proper account external noise levels on balconies and other matters, and also reference to the SPD for concert noise, although that was subsequently the reference that's been used in the inquiries of the COP95. So you set those matters out and you say his view is that the appellant's proposals don't satisfy the relevant criteria for that. What's your understanding of the lie of the land post Mr. Duncan's oral evidence?
Yes, there's obviously extensive evidence given from all parties, but from Mr. Duncan's evidence, which obviously I'm relying on in my proof, the position was that there was my understanding is that in respect of British Standard 8233, that there was, I I don't know if the word is concession, but it was accepted that within certain scenarios of sound parallel outputs and the introduction of the enhanced air handling ventilation system, that within the units themselves, that the impacts using that standard 8233 would be I think removed or deemed to be acceptable, but it wouldn't necessarily deal with the outside space. And in terms of 8233, it wouldn't necessarily deal with the requirement within that to minimise to where possible. However, Mr. Duncan was still of the view that the 8233 wasn't the most appropriate method to assess the nature of the noise because of the methods used in 8233, that it's it smooths out over. It doesn't take into account the full character of the noise.
I mean, cutting to the chase on this, Mr. Robinson, do you consider the position of Mr. Duncan to have changed materially from that set out in 8.5.3 of your proof?
No.
No. Okay. And in those circumstances, do you consider that the conclusions that you drew in relation to that hold true?
Yes.
Now, in proof 8.5.4, you raised a point about the failure of the applicant to assess the noise impact of opening windows. Obviously, we've since had a revised ventilation strategy in relation to Block A. I think you just mentioned it a moment ago. How does that impact on your position set out in that paragraph of your proof?
Well, it makes a difference to it. Obviously, it's obviously considered an improvement because it takes away that issue of opening windows being not being able to be controlled after the development is taken, but it doesn't fundamentally change the overall position I set out previously in my previous answer.
Okay, thank you. All right. Dealing then with other nuisance type impacts, I just want to turn to one of the other issues raised by you in relation to agent of change, particularly lighting. Now, this is dealt with in 8.6 of your proof. And at 8.6.1, you make the point that the application was submitted with no reference to lighting impacts. Now, I just want to start by ensuring that we're clear about the nature of the lighting that gives rise to your concern. Is it the functional lighting, the festival lighting, or both?
It's both. It's all of it.
Okay. And in relation to the functional lighting, what's your understanding as to when that functional lighting is used?
I mean, there's functional lighting covers a variety of different things. There's security lighting. There's functional lighting insofar as I would class the flag is lit, for example.
I think really I'm talking about the flood lighting here.
Yeah, the flood lighting. It's all flood lighting, to be fair. It's constant. It's 24 hours a day.
Well, is it 24 hours a day? Is it used in the daylight hours?
Well, sorry, it's within nighttime periods, okay. dark periods.
Yeah. So but it's daily, is your
yes.
Is your point? I think. Okay. Now, have you seen the lighting yourself?
Yes.
And what's your perception of it?
I perceive it to be relatively bright, and at times it just varies because some are security lights which work on motion sensors as well. But I perceive it to be particularly bright.
Okay.
Within that setting.
Okay.
It's a very white light as well. It's a very sharp light.
Okay. Now, what's your understanding as to whether this issue has been addressed through the submission of any information in the appeal materials?
I don't think it's been addressed in any great degree at all. I think there's a comment from Mr. Tickle's evidence that that there's a note on it, but I don't think it goes into any degree. There's certainly been no detailed assessment of it in terms of a qualified lighting engineer
Thank you.
or its impacts.
And what are your concerns about that in the context of agent of change?
Well, it is covered within agent of change. It is the problem is that lighting can be a nuisance, and you know, I am not a lighting engineer, but I'm only dealing with it from a planning perspective. We just don't have the information there to determine whether there would be an impact, and therefore whether nuisance complaints or complaints would require an impact on the new residential flats proposed next to it, and whether that would then lead to changes or unreasonable changes to the Goodwar's lighting of its place, which, as I said, is for security, for religious purposes, and just it's the way they've operated. That's
And whose responsibility is it to provide that information?
It's the appellant, in my view.
And if they aren't able to demonstrate the assessment of no adverse impacts or acceptable impacts, what are the consequences of that in terms of policy D13?
I don't think you can say it complies with the agent of change in D13. It requires you to identify potential impacts and to provide enough information to deal with those, to consider them.
Thank you. Your proof in 8.2.9 also refers to policy EQ6 on lighting. Do you have any views about compliance with that policy in the context of this issue?
Yes, can I just bring up EQ6?
Of course.
Well?
Could I have the reference for that?
Yes, sorry,
please,
I'm
if you're
just
going
About to give it. It's CD 11.1.21. We all there?
Yes.
Yes, so EQ6 is a household local plan policy, specifically dealing with lighting. Obviously, everyone can read it, but it sets out the council's, albeit quite brief, policy to reduce light pollution impacts of development, assess the potential lighting impacts of development proposals. But within that, it does talk about the minimizing light pollution itself and requiring lighting assessment reports where necessary to mitigate the level of illumination, glare and spillage. Now, clearly in that respect, it's kind of tailored towards brand new development, but I don't see why it isn't relevant to consider the impacts of existing lighting on new development in terms of the general amenity of what one would set out. I think the same standards would be applicable when you bring it back to agent of change considerations.
So, Mr. Robinson, are you saying that there's some kind of conflict with this policy?
Yes.
Can you show me? Can you explain why?
I think at point C, where it talks about refusing proposals which result in an adverse impact on local and residential amenity. If a proposal was this is a residential proposal that could be subject to lighting impacts from a neighbouring site, then that would need to be taken into account and hasn't been. And provide adequate protection from glare and light spill and sensitive receptors.
And you mentioned a moment ago that lighting assessments are required where appropriate. do you consider this as a case where a lighting assessment that dealt with that point would have been appropriate?
I do, yes.
Okay. And is that a conflict with that aspect of this development plan policy?
I believe it is, yes.
Good. Okay. What, if anything, do you say about Mr. Tickle's claim that, well, existing residents haven't complained, so there's not a problem?
I think that's a common. I don't think it's relevant to where we consider an agent of change. But we are dealing with new residents in that respect, and they can have sensitivities which haven't so far been considered. You know, they're not there. So I don't think it's relevant to say that. But equally, looking at the nature of the site, where the lighting is predominantly in the ceremonial area car park, forecourt, the front of the building, the southern facade of the building. There aren't really any residents close by that would necessarily be affected, other than there's the 3 houses to the bottom, which is within the demise of the Goodwara estate. Beyond that, you have residents on the south side of Hanworth Road, but they're a lot further away than the proposed flats built fronting onto the car park and ceremonial area. So the impacts are likely to be greater, and therefore potentially generate complaints of nuisance.
Thank you. Now, there are just a short point. It was put to Mr. Ringer that the officer's report and the addendum addressed all issues that had been raised in this inquiry. As far as you're aware, has the impacts of lighting spill from the Goodwara been addressed in either?
Sorry, can you just repeat that start of that, please?
Yes. It was put to Mr. Ringer that the officer's report and the officer's report addendum, when read together, addressed all issues that had been raised in this inquiry. And I'm just asking you whether, as far as you're aware, lighting effects from the Goodwara that we're talking about now were addressed in those documents.
No, I don't believe they were addressed in those documents.
Okay, so have all issues raised in this
No.
inquiry been addressed in those? No. Okay. Moving on then to design, please. There are 3 aspects to the design issues. You've got the scale, massing, siting and form of Block A relative to the Goodwara. And we've got the impact on amenity of the ceremonial area for worship. And we've got the impact on 231 to 235 Hanworth Road. I'm just going to deal with those in turn. I just want to deal with the Block A issues briefly. We've set out your position in your proof. Can I just ask you, please, though, for the inspector's benefit, just to outline your position on the acceptability of the design approach to Block A relative to the Goodwara's boundary?
I think it's set out in my proof, but my view is that it doesn't. It's unacceptable. It brings with it a relationship which would be harmful to the setting of, when you look at the Goodwara as a whole, not just the building but the actual estate and the activities involved within it, then Block A is by far the largest building on the development, in terms not just height, but in terms of that's accentuated by its setting, its siting, and its width. And within that respect, it fronts up to the ceremonial area stroke car park, but there's not really a justification for it to do that. Sorry, can you just repeat the?
I just asked you to outline your position on
Yeah.
the acceptability of design approach, which I think you've done. How do you compare the approach to the treatment of the Goodwara boundary, so the boundary between Block A and the Goodwara, and the approach that's been taken to the treatment of other boundaries?
There's been a lot of, if you look back through the design and access statement, there's the chronology of the design approach, and it's set out to demonstrate the processes involved from the time in the previous consultants moved it, and then into the stage which then led to this appeal proposal. The it's clear within that there were various changes made and commentary made on impacts and things to take into account, such as the Hanworth road frontage was given particular detail, leading to the 3-story townhouses, for example. There was discussion on obviously significant discussion on the frontage to Clarence Street and Thompson Road, where to address that street in terms of its size and scale, and to enact an active frontage with as an entrance to the school, to improve the widths of the public realm, etc., and to a lesser degree, I would say, to the north, where Perkins Close is considered, where it's primarily a 4-story building. I know there's been discussions about that relative, but the point being is that there seems to have been adjustments made across the site, but not in regards to Block A, which has remained as a 5-story building, at 5 meters from about 5 meters from the party boundary with the Goodborough car park ceremonial area.
Now, I raised with Mr. Mannering the absence of any visualisations of Block A relative to the boundary. First of all, has the Gurdwara ever sought any from the appellant?
Yes, we have. It's not going back to the original. The time when we were first approached and then instructed to assist with the Gurdwara itself, which was March 22. The first process we did was to look through all of the documentation that was available on the council's website, which, as it turned out, it only had the core documents. It's another matter. Within that, there is a set of, I think, 4. Well, there's more CGIs from internally, but externally, there's CGI representations. Well, what I would say, the first thing was there was never a plan showing Block A in relation to the Gurdwara on the same plan. Yeah. It's shown in other respects, the Gurdwara, in relation to Block D, and but that's a lower building at that point. So that's one aspect, but there wasn't any visualizations. We asked, therefore, to understand and demonstrate I'm a chartered town planner. I work with planning applications all the time, as we all do in that respect. But I do find a CGI representation to be very useful for not just myself as a planner, but in terms of the wider public and committee members, etc. But there was nothing to show Block A from Alice Way, which I believed was a fundamental elevation, and it would have benefited from an understanding of that relationship as to how that mass would appear from Alice Way. And we asked for that in our original our first objection letter, which I think was
March 22. I think that. Is that the Mr. Basuta, or is that your own?
Well, I think we mentioned that was Mr. Basuta's. Our first one was I think it's 15th of May.
Yeah, that sounds right. Okay, so you asked for one. Now,
that was to the council.
Yes, before the opening of the inquiry, we've had the revised screening design for the balconies, and I believe that does show the relationship between Block A and the Gurdwara in the sense that they're on the same elevation view. Does that change any of your views about the acceptability or otherwise of the impact, having seen that visualization?
No, I don't have the CD reference of that, but it was. I think it was added last night, wasn't it?
Yeah, I don't think we need to go to it now. Just
it's the first time I've seen a plan showing the Gurdwara, that elevation with the Gurdwara and Block A included. I don't think it changes my view that the relationship is inappropriate to the
all right,
to the car park and forecourt. It doesn't.
That's fine. I think we can that's all we really need to know on that. Now, just a short point in relation to the London Plan guidance on optimising site capacity. I raised this again with Mr. Mannering about the need to avoid cliff edges or overly abrupt changes. And his view was that the 5-story building proposed in this case would not represent a cliff edge. He said 10 stories would be a cliff edge. Do you agree?
I don't think you can. I think it's relative, isn't it? You can't there's no definition of what a cliff edge is. So no, I don't agree. It's relative to the context within which you'd see it.
And in the context in which you see it, do you think this would be a cliff edge?
It's quite an emotive term, cliff edge. I would say
should we
it's
use
an
the other
abrupt
language, overly abrupt change?
Yeah, I would say it's an overly abrupt change relative to what's next to it, which is a ceremonial space, an open space.
Thank you. Now, impact on the use of the ceremonial area. I just want to pick up a point that's been raised. You've obviously set out the position in your proof as to what you say the policy basis for that is and why you consider there to be an unacceptable impact. The response of the appellant has been to say that the ceremonial area is already lacking in privacy and is overlooked by properties on Alice Way, such that the inspector doesn't need to be concerned with that as an issue. How would you respond to that?
I don't think you can compare. Well, you can compare, but I don't think they compare. I don't think you can add significant weight to that position because you have to come into the properties on Alice's Way itself. Refer to they're primarily the offices and light industrial units opposite, and they're about 25 metres or so away from the boundary. They're 2 stories. They're offices for a start. There are a line of, I think, silver birch, which are and a bit of a fence there that's about 1.5 metres high. That doesn't exclude views over and into that property, but it is such a distance that the difference between a 5-story block at 5 metres with their balconies is vastly different in terms of the introduction of a lowering of an increase in overlooking. There's an increase in overlooking from Block D, which is significantly worsened in the appeal proposal.
Thank you. Okay, well, I've come to the end of my time estimate. I think that's, oh, actually, sorry, there is one last point just to deal with, and it's just deals with the new screening that we've just mentioned a moment ago, that's been suggested by the appellant to deal with overlooking. What, if any, comment have you got about those proposals?
In terms of a screening, in terms of the intention to provide and mitigate from any overlooking, and I appreciate that it's done if the inspector was to see it as being necessary. My view is that it doesn't overcome the issues that we've raised I've raised in my proof as to regards to the overlooking of the ceremonial area with regards to the wider activities that take place there. And it can't. I would say, I would accept that it provides an additional level of screening towards the Goodwara building itself, particularly the closer you get to it, the angles will change and what have you. So I would accept that it improves the situation towards the Goodwara building, but it doesn't overcome the objections within. With respect to the amenity and privacy aspects, the general amenity aspects of the ceremonial area itself.
Good. All right. Thank you very much. Thank you very much. I'm sure there'll be some questions for you.
Right. Thank you. Just on that last point, can I just be clear? Are you suggesting that it would be your preference for a condition to require the screens or not?
I think if you were to determine that was that the application could go forward on that basis, then I would prefer that condition to be in. But I would say that I don't think it deals with it. Don't think it overcomes the issues that I've raised. So I don't think it makes it acceptable as a development with that condition attached. Does that make sense?
Yes, yeah. I think so. So you accept that there are some benefits to
there are benefits to it,
but it doesn't overcome your concern. Right, thank you. Right, Mr. Strawn, then your cross-examination, please.
Good morning, Mr. Robinson.
Good morning.
Penultimate witness. We've been through a lot of issues already with other witnesses, and I So again, with your permission, I'm not going to cross swords with Mr. Robinson on all the points in dispute. Not because we agree with you, Mr. Robinson, but it's going to be very tedious if I do everything again.
I understand
You're
that.
content with that. And unless you tell me I need to put everything again, I'm going to follow the same lead as I've got. So we've covered with others noise, indeed things like privacy through architectural witnesses, Mr. Barker, outlook and matters, and indeed policy to some degree. So apologies if I don't repeat everything with you, Mr. Robinson, but let me try and focus on issues that are specific to what you've just said. And first of all, again, I hope you don't mind me clarifying, but I think it's the case. You're not a qualified noise expert, are you?
No, that's correct.
And you're not an architect or urban designer.
I'm not.
And I was going to say you're not a sunlight daylight surveyor.
I haven't kept that up my sleeve. No, I'm not.
No, that's fair enough. I don't think you're raising any sunlight daylight issues at all.
No.
So that's good. And in relation to noise, you tell us you're instructed in March 2022. Yes?
Yes.
And you also help us by saying one of the things you advised the Gurdwara to do was to instruct noise experts, because you're not a noise expert.
Correct.
And that was what then led to the production of documents to the council from Clear Acoustic Design.
Yes.
And you may recall I asked Mr. Scrivener about that CD 4.4 and the presentation of the noise evidence in that document. Do you recall all of that?
I do recall that.
And
yes.
he accepted, Mr. Scrivener accepted that it was fundamentally misleading, the information that had been presented in that document that had gone to the council, because it made I was going to say school boy error, so school child error in equating 50-minute or 5-minute periods with 16-hour periods. Do you recall that?
I recall the discussion. I can't say with absolute clarity the exact concession, but if I do recall that, that aspect, that it was agreed by Mr. Scrivener.
Well, it was agreed by Mr. Scrivener and wasn't disputed by Mr. Duncan, was it?
I don't believe it was. No.
No. So the council, when they made their decision contrary to officer recommendation regarding the issues about noise, were presented with fundamentally misleading information, weren't they, by the Gurdwara's? It's not your fault, but by the Gurdwara's noise experts.
I'm sorry, I'm just going to say, I don't think it was put to Mr. Duncan that was fundamentally misleading.
I put it to Mr. Scrivener and he agreed. So, Mr.
Well, Mr.
Duncan,
Scrivener did, but that's Mr. Scrivener's evidence,
all
not
right.
Mr. Duncan's.
I'm not asking about Mr. Duncan's evidence. I'm asking about Mr. Scrivener's evidence. Mr. Duncan didn't.
He's not our witness.
Mr. Duncan did not disagree with the evidence that I had put.
Having not been asked,
okay,
he didn't disagree.
Yeah, he didn't disagree. It is fundamentally misleading, isn't it? Having heard the evidence, Mr.
I
Robinson.
don't think I'm in a position to say that it's fundamentally misleading. The purpose of that approach was to highlight that there was a noise issue which hadn't been. Well, that was my first understanding, was to instruct on someone to get an understanding of the noise situation, so that we could then decide whether we can raise this with the council.
I know that. We've dealt with that. You're just repeating the history. I've dealt with that. The document that was then produced by the people you instructed, Mr. Scrivener accepts, and I haven't heard anything to the contrary from anyone else, was fundamentally misleading. That's right, isn't it? You heard that evidence.
In the words of Mr. Scrivener.
Yes, Mr. Duncan didn't present any contrary words, did he?
I don't know how many times I have to say that point wasn't put to him.
I don't have to put it to him. If he wants to challenge it, he came afterwards. I think I made the point, so I wasn't putting every point as I made clear with this witness, each time to every new witness.
Yes,
But if-
well, I understand what's being said, that it wasn't specifically put, and also what has been said
And
by
I
Mr.
understand the
Strawn.
point that Mr. Strawn raised at the time, that he wasn't taking every point with each witness, but then you can't then say that it was a concession on the part of the witness because it wasn't ever put to them. I mean, that's just the way that it's a double-sided
I don't
coin.
think it's being suggested that there was a concession, simply that there was no contrary evidence put.
because we weren't dealing with every single issue. That's the frustration about this. So, and questions
right.
being put on that basis, it's not fair, and it happened yesterday.
Right. Just focus on the question, Mr. Robinson, and what we've explained. You commissioned noise experts to produce a report, yes?
Yes.
We've been through that. I went through that report with Mr. Scrivener. He agreed it was fundamentally misleading. Do you recall that?
I recall Mr. Scrivener, yes.
And do you recall the reasons why?
The ones you just outlaid to me, which,
Yes, which are sound, aren't they?
according to Mr. Scrivener.
Yes, well, you haven't heard anything from your own witnesses say they were unsound, have you?
But
Mr. Strawn, I heard the evidence of
Okay.
Mr. Scrivener. We'll all draw our own conclusions about what's been heard. I don't think we need Mr. Robinson to agree with that point.
Okay. Can we? I mean, I'm just dealing with what's in your proof about who you instructed. Those were the people you instructed. Clear?
Yes.
Yes, fine. Okay. And can we also agree? I think you made this clear actually in your evidence, Mr. Robinson. Whilst, and I put this point to Mr. Ringer, so I am putting it to you as well. But whilst we've heard an awful lot of representations, and you can read them in the various materials, many of them raise what would be properly regarded as non-planning considerations, which should be, in some cases, positively rejected, such as provision of affordable housing being somehow a problem.
sorry, can you? I'm not sure what the specific nature of the question is.
Many of the representations we've heard from either members of the public or congregation members of the Gurdwara have raised non-planning issues which should be rejected. And the example I gave you was the objection to, say, affordable housing.
In what context? Sorry, in what context is do you saying the objections on affordable side? I've been here and heard the objections.
Yes, well, a number of people were concerned about the provision of affordable housing, encouraging drug taking, I think.
This is a building announcement. The fire alarm system is about to be tested. No action is required. This is a building announcement. The fire alarm system
We were
is about to be
expecting this,
tested.
so we'll just wait for
No
it to
action
finish.
is required.
Attention, please. We are investigating an alarm in another part of the building. Please listen for further announcements. Attention, please. We are investigating an alarm in another part of the building. Please listen for further announcements. Attention, please. We are investigating an alarm in another part of the building. Please listen for further announcements. Attention, please. We are investigating an alarm.
Good to go.
It should be. It will provide confirmation that the test is done.
Yeah.
is a building announcement. Testing of the fire alarm is now complete. Please respond to any further alarms. This is a building announcement. Testing of the fire alarm is now complete. Please respond to any further alarms.
Right, okay, let's carry on.
Thank you.
Thank you.
So I'll try and
I understand. I recall the question.
Yeah.
In particular to that one particular chap that represented. I don't recall his name at the hand, but I do recall the conversation. I remember the inspector asking for clarification, and I would say that I do not. Well, yeah, the question is that a planning consideration? And the question of materiality is open to the decision maker, but I wouldn't attach any significant or any weight to that, to be perfectly honest, in this instance.
Well, it's positively and the opposite, isn't it? We should be encouraging affordable housing.
Well,
I
agree.
In fact, just to be fair to you, Mr. Robinson, you attach, I think, significant weight that this scheme does deliver affordable housing on this site.
I do. The answer to my question was in relation to that specific comment.
Yeah, well,
in respect of crime and other aspects, which clearly would find difficult to sit comfortably with any planning. But in terms of overall affordable housing, yes, I attach significant weight to that.
Yeah,
and it is
the same goes for the delivery of the school. You're not taking any issue with the specific proposal, the design of it, and its suitability as a school on this site,
no, I'm not.
and its interrelationship with the Gurdwara.
I personally am not. No,
No, well,
No,
you-
sorry,
personally,
professionally,
you're
I'm not.
here professionally representing the Gurdwara.
professionally, I'm not.
We've had a lot of people, including the Ruth Cadbury MP yesterday, questioning the suitability of the site for school. That's not your evidence,
It's
is it?
not part of my evidence.
Or
no.
the Gurdwara's.
There was concern initially for context, but my evidence is that it's not part of my evidence. That I don't have an issue with the school.
Well, you
se.
put it a bit more positively. Great weight should be attached to the delivery of this school
Well,
in
if
this location.
If I was to finish, I don't have an issue with it, and the provision of it, I would attach great weight to it.
Yeah, good. And just picking up on your proof, please. Paragraph 3.3 of your evidence.
Yes.
You identify the mixed character of the area, mix of uses.
Yes.
And you also go on to identify the PTAL scoring of the site at 6.
Yes.
And I think you're just recording some of the common ground, but it's right, as a matter of principle, having looked at the housing SPG, that's an important principle as to the design response to this site.
I agree, yes.
Yeah, because all other things being equal, and of course I emphasize that, Mr. Robinson, the design response should be to optimize, having got your school delivered, optimize the remainder of the site because it's previously developed land in a highly sustainable location.
In a design-led solution, yes.
Yes. And rather than, for example, not making optimum use of it, bearing in mind how valuable, I say in planning terms, these sorts of sites are for delivery of development in a sustainable way.
I agree. I agree that optimizing the site is a fundamental policy for us all to be taken into account, for the inspector to consider.
And you, 3.8, I don't know if this is something you've corrected, but I'm going to correct it for you. You identified the site's located approximately 170 meters to the south of Hounslow Town Centre. I think it's 270 meters, but whether it's 100 or 200 may not matter.
Yeah. If it's I suspect it is 270, but that's
yes. But the point that flows from that is it's a metropolitan centre as identified in the London plan, isn't it?
It is.
And again, all other things being equal, that reinforces the need to make best use of this land and optimize it for the allocated uses. To
make optimal use of it, yes.
Yeah, make best use. It's another well-established planning term.
I think I would prefer optimal just because that's what comes out of policy documents.
Well, all right. You have to
I don't think there's a
tell me
great
one day
I
what
don't
the
think we're
difference
in
between
disagreement.
optimum and best is.
I don't think we're in disagreement.
All right.
But the phrasing is normally optimal.
Oh, well, if we're not in disagreement, then it's probably easier just to agree with me. But if you want to take issue, that's fine. Optimal, I've said best. Optimal, you say is the same thing. Or is there a difference?
I just prefer to use
All right,
optimal
okay.
because it has a specific. I may be wrong. There may be elsewhere where best comes up, but to my recall, optimizing is the fundamental approach that is promoted by both the NPPF and more importantly the London Plan, and that's the parameters we're talking within.
And Mr. Robinson, the site's allocated for school and residential uses, isn't it?
It is.
And it has been for some considerable time.
Yes.
And the plan-led approach you refer to is one which therefore gives that allocation importance in the planning of the area.
Yes.
Your clients have never objected to that allocation, have they? In the history of
I recall the witness being asked this, and he's not a planner for a start, but I don't recall that they objected. I have seen no evidence that they've objected to the local plan allocation in a formal manner.
And insofar as your client, and we heard evidence from your clients through your other witness, was promoting its potential use as a car park, that would have been contrary to the development plan and its allocation for housing and residential.
It would have required significant material considerations to justify it against that policy.
Yeah, it would be contrary.
It would be contrary, yes.
Okay.
Yes.
And
I've moved a step ahead, sorry.
although the financial considerations are raised this morning as to how I put the case, in fact, the financial considerations arose because of your client's correspondence with various ministers seeking to purchase the site for car parking and then seeking to suggest they had sufficient money to pay market value for it. Do you recall that? That's how the issue,
I recall that discussion, yes.
Well, that's how the issue of money arose, wasn't it?
I wouldn't disagree with that. It came from that broader discussion, but then we moved into questions of why don't you buy the block and things.
No,
so
well, you say you moved. I'll come to that in a moment.
it's my recollection.
Well, fine, whatever your recollection is. But that's how the question of whether the Gurdwara had sufficient funds to make good on the correspondence offer that they were putting to the minister arose. Do you recall that?
Yes.
It was claimed that the Gurdwara, and they were frustrated because they said they claimed to be able to pay and were willing to pay market value for the site for its then allocated market value. Do you remember?
Yes, I remember that.
And it was claimed, therefore, that they had £4 million in the bank, or £8 million, I think.
I don't recall if they said it was in the bank, but they had access to, which isn't quite the same thing.
So, in fact, that's not the case, and your clients couldn't have bought the site at market value for its allocated use, which is how the issue arose.
I don't think I can answer that because the Gurdwara of the nature of the Gurdwara is that it has significant benefactors. At times when, or it has a fundraising, they could put things into place for fundraising. So I can't speak for the Gurdwara to say that they had or had not £4 million in the bank at that time.
Well,
it's not formed part of my evidence.
The opportunity for me to question Mr. Adan has somewhat passed on that issue now, so many months ago. Anyway, that's how the issue arose. As to buying Block A, I don't think I ever suggested that you could buy Block A. The issue was lack of additional accommodation for priests was raised by the Gurdwara, wasn't it?
That has been yes.
Yes, and there's no reason, and the point I put is that there's no reason why anyone, including the Gurdwara, or indeed any member of the community, including the Sikh community, can't purchase units in the appeal scheme.
Other than price.
Other than price, yeah. Market value.
Then.
Or if they qualify for affordable. Or if they qualify for affordable housing through affordable housing.
Well, there's no affordable housing in Block A, is there?
No, but on the scheme, I said appeal scheme.
Availability. Block A, but I mean, this is semantics in a sense. But yeah, right. In principle, there's no reason why someone couldn't, if they had the means, to either purchase or if they had the qualifying position to become a resident by virtue of other means in the affordable housing offer.
Fine. And can I just then take your proof, various statements that are made in your proof, and also in the accompanying, sorry, the application that was made in 2022, 4.2.1. You referred to the area in front of the Gurdwara, the ceremonial space. The car park also acts as a ceremonial space. Do you see that? It's laid out
Yep.
as a car park, also acts as a ceremonial space. In fact, this is later confirmed, 4.5.2. There was an application made for that space, wasn't there, in 2022? I'll come to the detail of that. But it's emphasized in 4.5.1, and this has been a feature of this inquiry, that the Gurdwara considers itself to have insufficient parking.
Correct.
Hence the attempt to purchase the appeal site for parking.
Yes.
And the one thing that's therefore not in doubt is the need for the car park area to be used for car parking.
Yes, I would suggest. I wouldn't disagree.
You wouldn't disagree. No, that is, as the inspector will see, and we can see from the plans how it's laid out. There are 30 spaces laid out for car parking.
Sorry?
That's how it's laid out.
The
area in front of
existing
Block
layout.
A is laid out for car parking.
For use, when it's used as car parking, is laid out
Yes.
with parking spaces, yes.
And far from wanting to lose car parking spaces, the Gurdwara wants to obtain more because of, as it's told, the number of people attending functions and the wish
The evidence
to park.
presented has shown that they want to acquire more parking spaces, yes.
Yes. And even the 2022 application that went in, which you referred to in 4.5.2, was intended to retain car parking in that area, albeit it was going to be in an undercroft building above.
Mhm.
Yes?
Yes.
So the Gurdwara's position was to keep the lower space for car parking and an undercroft area so you can process through it as necessary, but to have building above.
That's what's shown on the plans.
Yes, well, that represented what they wanted to proceed with.
Yes.
Right.
As an application, definitely.
Yeah, okay, good. Just dealing with the evidence we heard from Mr. Adan, he identified and he produced a plan, so you may recall, of the use of that area. He had a ceremonial stage area in front of the Gurdwara and distinguished that from the remainder of the car parking. Do you recall that?
Yes, I think it's in his state. It's where I think it's termed Sangat. Sorry, I think it's termed Sangat, isn't it? Which is the community of the Gurdwara.
Sorry, I'm talking about the plan he produced.
Yes, in his evidence.
Yes.
Proof. Yes.
Yes, and I'm pretty sure, Mr. Robinson, having trawled through all the evidence again, that is entirely consistent with all the evidence the inspector will have seen, that where ceremonial events do occur or gatherings of people, whatever, they occur in front of the Gurdwara, and the area behind, save for the processions, save for the procession, is almost always used for parking. You might want to show me any photograph to the contrary. I think maybe the flag raising ceremony.
I think.
Or
That's
fair, isn't it?
I think I think figure 5. I think it varies, doesn't it? Depending on the scale of things and the weather.
Figure 5.
Sorry, in Mr. Adan's proof.
Yes.
There's a photograph called Figure 5.
Yes.
Which clearly shows congregations It's on page 17 of his proof. I don't have the CD number to hand.
I'll give you, well, I'm not sure I've got the CD number, but. Which one are you looking at?
It's on
Yes.
page 17, figure 5.
Yeah, yeah. Back to my question. Save, as I said, for the processional ceremony. This doesn't actually show the car parking area behind, but
Well,
leave that aside. Save for the processional ceremony, and I also said the flag raising ceremony. The inspector's got videos you can see of both events. The plan he's produced is broadly speaking consistent with that principle, isn't it?
well, it's Mr. O'Dan's evidence that that's how the good Wirral operates, and can I just expand upon that, because I'm not trying to be evasive. I'm trying to answer the question. There's no doubt that the larger amount of ceremonies are focused on the front area because that's where the flag is, and the flag is of such significance. So if you have a larger if you have a smaller congregation, which was seen within the video that's been shown, and it does show parking towards the rear, and it was a wet day, there were perhaps less people there than it has been shown in other evidence within Mr. O'Dan's evidence. But ordinarily, it will spread out into that area, and there are a multitude of different events and occasions that occur within the good Wirral.
Well, it's something I put to Mr. O'Dan. I just want to be clear. So far as I'm aware, there aren't any photographs. I think this is the only one which shows the procession as a photograph, and I'll come to that in a moment, which show the area in question in front of Block A being used for anything other than parking and then access to the main area.
I think in the evidence, yes, that's probably the only one.
Which would be consistent with the broad thrust of what Mr. O'Dan described, that the gathering the main ceremonial areas in front of the good Wirral.
With the ceremonial area is more I think what it needs to be made clear.
Well, just answer my question first, Ms. Robinson.
Well, I think it has to be qualified by understanding that it does show on his plan. I'm trying to find the plan that he produced.
I think it's figure 1 that you're looking for.
Figure 1. Oh, sorry, I've said call it Sangar. It's Sevadar on here, where the ceremonial, it tends to occur closer to the building, but congregations happen further down as and when needed.
That's what I'm just putting to you, Mr. Robinson, that there's a sort of split there. It's not a formal split, obviously, on the ground, but he's pointing out the stage area insofar as there's a stage. I don't think there's a stage put in, but the stage area is in front of the Gurdwara. Sevadar area is referred to. There isn't I don't think, but you tell me if I'm wrong, for the inspector, a single photograph or identification of that area being used for ceremonial purposes beyond the procession, where the for example, the vehicles brought in.
I think that's at figure 12 on page 22 and 13. No, it depends whether you discuss
Figure
this within
12, sorry. Page what?
Page 22.
Yeah.
Figure 12 and 13. There's two different things there. There's the annual sponsored walk, but that obviously does have a congregation. But one more importantly would be figure 13, which is a wedding and the Milne happening on Alice Way as it approaches into the car park. So, and that is a ceremony. Right.
Okay. That's a ceremony. That's, as you say, coming down Alice Way
into the
from the public highway into the temple.
Yes, but they congregate at that end before moving back into the temple. So it's
Well,
not, it's a fluid thing, isn't it? That's the thing.
It is a fluid thing. But in relation to processions, and indeed the wedding celebration you're referring to, and any procession that occurs, they're taking place in public view, aren't they? That's the point of them. The main procession, it spends most of the day processing
goes-
around Hounslow, and the whole point is it's a very public event. That's fair, isn't it?
Yes, the main procession around town is a deliberately public event.
Yeah. So there can't be any concern about loss of privacy in respect to that, can there?
Not while it's proceeding around town, no.
Well, intrinsically, it's meant to be a publicly attended event.
Yes. I
So there
agree.
can't be a loss of concern about a loss of privacy from Block A in circumstances where the whole purpose of the ceremony not only to be public in the temple, but in the temple area, but then to lead the ceremony out and be as public as possible throughout most of Hounslow.
I think you would say that that's a celebratory event, but
Yeah, but just focus on so I can't deal with everything at the same.
No.
That's right, isn't it, Mr. Robinson?
in regards to that particular procession, I
Yes.
would agree. Yes.
Yes. And then weddings and celebrations that are processing through, insofar as they then come through the car park from Alice Way, similar principle. You can see that from figure 13. Understandably, as is probably the same in many religious cultures, weddings are intended to be celebratory, and people, in this case, there's a horse. In many cases, there are bridal cars, and they're not intrinsically private, are they?
Well, there's degrees of privacy, though, isn't it? Once it changes throughout the process of the procession and of the event. I mean, that's one particular photograph.
Yeah. Well,
not all weddings start with a dance in Alice Way.
No, except I'm sure that's right, but I'm just dealing with the principle, and there isn't any intrinsically private ceremony that I've seen evidence of that occurs in the area over which Block A will look. Is there?
I don't think there's necessarily any written evidence to that effect, other than what Mr. O'Dan has said and the witnesses have said that that area is. There is a degree of privacy and amenity that the residents there, or the Sanghat, the people who go to the occupier, have become used to and value.
Well, Mr. Robinson, we can't agree on everything. We disagree. I just wanted to make sure I haven't overlooked some piece of evidence.
I think Mr. O'Dan was probably best placed to give us this sort of information, and we've heard from him. So.
Yeah. Well, I'm suggesting, Mr. Robinson, it's consistent with what he has produced, but that's fine. So, Mr. Robinson, then going back then to the three events, we dealt with the processional event, and as I discussed with Mr. O'Dan, the same is true of the flag raising ceremony. Do you recall, I put to Mr. O'Dan, that's very much a public event. The flag is intended to draw people into the Gurdwara, hence why it's raised and refreshed. It's a public event, isn't it?
It's a public event, but it's specifically directed at the Sikh community.
Yes, fine. Okay.
There's no restriction on the nature of the Gurdwara itself, from my understanding and from the evidence, is that it is a wholly open place.
That was my next question to you. It's something you make in the point you make in your evidence. It's not only this Gurdwara, all Gurdwaras are intended to draw people in, and this one prides itself on being interfaith, for example.
Yes,
interfaith marriages.
There's a difference between, and speaking from this from my understanding and my perspective as a planning consultant, that there's a difference between being an openly charitable organization, a spiritual organization, to having one which would then attract people who may decide that I am going to go to the Gurdwara today because it's something I want to be interested in. There's a difference between that and having. I know you haven't actually asked me this question yet. I'm sure we'll get to it, but there is a fundamental difference in my view, in terms of privacy or the sense of safety and privacy within that procession amongst yourselves, as opposed to coming into an area which is overlooked by X number of flats at 5 stories. And I think that there is a fundamental difference in that perception of privacy.
So differences in judgment.
There isn't a solely private. Sorry, it is not absolutely private as present. I would agree with that.
Yes, well, I was going to come on to that. It's not absolutely private. There are views from the public highway, from the existing buildings, obviously differences of degree, but it's not intended to be an intrinsically private space. Indeed, predominantly, for most of the year, it's used as car park and access to the remainder of the temple.
Its function as a car park operates. If people are going to the temple, they tend to park there. Yes.
Thank you. And as to the relative degrees of overlooking privacy, yes, of course, the Block A, in principle, places a building there with those levels of balconies and windows that look into that space. As views can already be taken from Alice Way and the business park. The judgment, I call it the business park, but I think it's called the
It's called Alice Way Business Park.
It is called the business park. And we're going to differ on I'm sure, on the judgment. So I'm not going to question you about that. The inspector can come to his own view. But can I just focus on what you've raised, which may be different? First of all, the application in 2022, CD 13-8A.
Sorry, what?
CD 13-8. I think it's called 8A. I'm not quite sure why it's 8A, but that is the
planning statement for the.
Yes.
That's not my document, though, is it? But yes, it's the good.
Well, it's a document from your client. At the time you were instructed. Maybe you didn't write
it, though. I wasn't instructed on this.
Okay.
I'm so sorry, I've missed the reference.
13-8A.
Thank you.
You've seen it, though, haven't you?
Yes.
Yeah. Is the information contained in it correct?
When I think I would say when I've seen it, I'm aware of it, but I don't think I've scrutinised it. I'm not aware of every single perspective. So perhaps if you could point me to the issues where you want me to
well, I'm going to, but if you thought it was inaccurate, I would have thought you would have said him since it's put forward by your client.
Mr. Strawn, it's a 24-page document, so if Mr. Robinson's not familiar with it, maybe
all
we
right.
need to focus on what your query is.
Let me just point out some things. First of all, it's emphasising something you've already emphasised. We've touched on the nature of the Gurdwara being its charitable activities, etc.
Yep.
Serving the Langar, offering all these facilities to the community at large. Yes?
Yes.
People will access the Gurdwara to come to access various different forms of activity for a community use, as well as with a religious underpinning. Correct?
Yes.
The buildings on Hanworth Road, if you look at I think you refer to them as the priests' houses, are identified as, if you look at, sorry, It doesn't have paragraph numbers, which doesn't help. But if you look under site and surroundings, first paragraph,
Sorry, I'm lost. It's quite slow.
site and surroundings on the first page, first paragraph.
No, it's just when I scroll back up, I lose it. So.
You got that?
Yes.
They're proposed for redevelopment in the future.
Sorry, which part is
The
that?
last sentence of paragraph 1 of site and surroundings. The 3 dwellings fronting onto Hanworth Road are proposed for redevelopment by your client. Have you got the last 2 sentences?
In site and surroundings on the first
Yeah,
page.
first paragraph of site and surroundings.
sorry, I was looking at the
everyone's
last-
struggling to find it. But
Sorry, I was looking at. I think I maybe misheard you. I thought you said the last paragraph.
there are 3 dwellings fronting onto Hanworth Road within the land on the south side, edge blue on the location plan. These are in the demise of Gurdwara, currently occupied by Gurdwara staff. This land is intended to be developed in the
Yes,
future.
I can see that.
And that point is made again later on. If you want to just turn to page 4, top of it. The proposed 4-storey block, that's what they were proposing on the car park area, would have a footprint of 290 square meters, etc. And then read towards the end. On the south side, there are 3 houses under the ownership of the applicant. The houses are in a state of disrepair, and it's the intention of the applicant to develop this land in the future as an extension to the proposed block to meet the growing community needs of the Sikh community.
Yes.
Is that accurate?
It's as accurate as it says in this document. I don't have evidence I don't have information to dispute that.
No. Okay. Well, it's come from your client, hasn't it?
Yes, but it hasn't come to me because I wasn't directly involved in this
No.
application.
Okay. I just want to know if it's accurate. So far as you're aware,
Well,
you've got no reason to believe that that's not an accurate statement put to the local planning authority by your client.
It's written in the application put to the planning authority, so
Yeah.
therefore one would assume that that's an accurate view at that
Fine.
moment in time.
And if we go in this document, I'll have to do it by a negative. There is reference to the application proposal that the inspector is currently considering, but there isn't any reference to its allocated use. It's allocated use for housing and education.
In this application.
Yeah.
I'm again, I'd have to read through it. If you're saying that, I wouldn't have the means to disagree. So unless I can read the whole document
All right.
in detail.
And just so you can see what's proposed, you've seen the plans, I know. It's a 4-storey building.
Yeah.
About just over 1 meter away from the boundary.
I think it's
with the
1.5, isn't it?
1.5, thank
Yeah.
you. 1.5 meters, so you can see that from the plan form P1. And in elevation form, it's 4 stories high, isn't it?
Yeah. Equivalent, because I think it's got a double height hall, hasn't it, within?
Yeah. So maybe taller. I don't know. You can
No,
see,
I think it's
you can
equivalent
see
to
from
4.
elevation.
I mean, compare it with the building behind. I think there's an elevation, isn't there? The blockade
Right,
behind.
there's an elevation 01 if you want to see it.
Yeah.
And the line, just looking at the line of the building that's proposed, it's, if you look at any of the plan forms, so doesn't matter which one you take, the footprint, the line of the building, you can get it from any of the drawings. The line of the building, broadly speaking, aligns with the line of the proposed appeals scheme at the northern edge.
Parallel, I would say.
Parallel.
Oh, the northern edge, yes.
The northern, where it stops.
Yes, so it's
in front of the
19 meters.
Gurdwara.
Yes.
Yes. So is that clear? Yeah, sorry. And the position about it's described in the document as a substantial gap between that building and the Gurdwara of 4 stories, isn't it?
On the plan or in the?
No, in the description.
So we go back to the proposed development. Is that?
Yeah, the planning statement.
Yeah, I'm sorry. It's just when I scroll, I lose everything above it. So it's. I have to-
Okay, sorry, well, I can't do anything about that, but page 4, second paragraph. The main Gurdwara building is on the north side of the block. There would be a substantial gap between the proposed block and the Gurdwara.
Yes. it
Be
says
no material
substantial gap.
impact. You agree with that?
I agree. It says that.
Well, it's a fair description.
I don't agree. Well, I agree. I would agree that it says that in black and white, it says there would be a substantial gap between the proposed building and the Goodwell. But in terms of my view of whether that's substantial or not, I don't think I would use that phrase.
All right. And the substantial gap between the proposed block and the business units. Next paragraph.
It says that. I think my view would be I would hopefully be more descriptive of that and more.
Well,
but I didn't write this, so
no, I know you say. And the relationship with the neighbouring priest houses to the south was not said to give rise to any difficulty, outlook or otherwise. You can see the plan form, 4-storey building.
Yeah, no.
Directly behind the priest houses.
And the question?
It's not identified, and it's indeed pointed out that there isn't a difficulty in that relationship.
In this statement, that's stated, yes.
Yes.
The council obviously deemed otherwise, I believe, didn't they? So.
Well, I don't think they did on that ground. They were concerned about prejudice to the adjoining site
There's 4 or 5
and the
reasons,
streetscape, the townscape views, and the reasons for refusal, amongst other things. But that represents a building in that location represents what your client wanted to do on the car park area.
Within their land, yes. I mean,
Yes.
I wouldn't agree necessarily that there's if one was to take it from the perspective of if from the houses to the rear, and we have to bear in mind that they are houses.
Well, they're proposed for redevelopment, aren't they?
But they're within their demise and they're within their ownership. Then if they are to be redeveloped, then one could perhaps accommodate that within that. But that would be their decision and subject to many, many different reasons.
Yeah, I'm just trying to understand.
Because you want to do something doesn't necessarily mean it will happen, does it?
Well, I'm just trying to understand your client's view as to what's acceptable for the
I would suggest
on the car
perhaps
park
you
area.
would have asked that client, but I.
Well, no, it's here in writing.
No, but I didn't write this document, so.
I know, but it's written on behalf of your client, isn't it?
Yes, I would
Right,
say.
that's why I'm saying it's your client's proposal. What they
Yes, it's
stated.
their
Yes,
it's their
fine,
proposal.
good. Okay, well, that's fine. So when we get to your question, because one of the points you make in your proof is that the appeal scheme will prejudice, it's not something you raised in chief, but it will prejudice the proposed redevelopment of the car park. Do you recall that?
I do.
Yeah. I don't know whether you're still pursuing it because you didn't raise it in chief, but it's in your written evidence why I'm going to tackle it. In fact, Mr. Robinson, the correct approach to any issue on that front is that this land in question, the car park and ceremonial land, is not allocated for any additional development, is it?
It's not allocated, but it's within development limits, so there's no reason why something couldn't be developed there if it was deemed to be acceptable.
Yes, but in terms of prejudice, the land to the east is allocated by contrast for residential and educational use, correct?
It is, yeah, it is allocated for those. Yes, I
agree. And that for development plan purposes and talking about prejudice raises a different consideration. It's right that the car park use shouldn't, or proposals on the car park shouldn't prejudice the bringing forward of residential and educational because it's allocated. That's right, isn't it?
Shouldn't prejudice the delivery of that allocation.
Yes.
It doesn't necessarily mean it shouldn't, that one particular design or site layout.
No, I'm not saying, I wasn't
No,
saying.
no, but I'm adding that. But yes, there would be a concern if it prejudiced the delivery of that site allocation.
Yes. And
as
the
a
only,
whole.
and the proposal that your client was putting forward was deemed to prejudice that, because not least it proposes building up at 1.5 meters to the site boundary, something that Block A, even though it's allocated, doesn't do on the equivalent side.
But if we're talking about
Is that right,
specific-
Mr. Robinson?
We're talking about specific development building relationships, and I don't necessarily agree that development would prejudice the delivery of the site allocation per se. What I would say is it wouldn't lead to a beneficial scenario to Block A in this particular design, and that's that there are different things. But I would agree that there is a difference in prejudice between how one approaches a site allocation and how I've presented it within regards to just good planning in terms of being able to develop a site.
In terms of good planning, Mr. Robinson.
There is a difference, yes.
In terms of good planning, we know there's a difference. We got the development plan, a plan-led system, and this site, which is required for parking, it's in-car parking use, amongst ceremonial use as well, which doesn't have any allocation for development, does it?
It's not allocated for development, no.
Right. And so there's a difference in principle, but taking
Yes.
that point a little bit further, this proposal was proposing development 1.5 meters away from the boundary. In contrast, Block A is 5.3 meters away.
Oh, it's factual, yes, I agree with
Yeah,
that.
yeah. Right. Can we just go back to your proof, please, then?
So I'm just noting we've been going for an hour and 45 minutes now. I wonder if that's an appropriate point for a comfort break this morning.
I was hoping to.
Are we just moving on to a new topic?
Well, if it's convenient for everyone, yes, we are. I'm going to go back to the proof, yes. I was
Okay.
hoping to get finished, but
How long do you think you've
but
got
I
left,
don't want
Mr.
to. Well,
Strawn?
I'm going to allow everyone to have a comfort break, so I don't want to have that hanging over me as a.
Well,
as
it's
a-
very good of you.
as a-
How long do you think you've got left of your cross-examination?
I think I got no more than half an hour.
Right. Okay. We'll take a break now then until 11:30, please. Mr. Strom.
Thank you. Mr. Robinson, your proof, please. Section 6. You got it there.
Yes.
And just to confirm, you set out various things that are not in dispute about the proposal. If we go through to 6.3 of section 6.
Yes.
A proposal in line with an allocation, bring back a vacant site into use, allocated brownfield land, etc.,
Yep.
and the economic and employment opportunities. You then go on to explain to the inspector at 6.3.2 that in terms of design and scale and addressing street frontages, you also don't have an issue, save in relation to Block A. Is that right?
I think broadly speaking, yes. I thought I wouldn't. It wasn't. This is within the context of my approach. I know I have to look at the whole scheme as a whole to consider the merits and the benefits. So I would say that I haven't forensically analysed every single aspect that doesn't necessarily affect the Goodwar's interests in that respect. But broadly speaking, yes, the approach, as it says there, I would stay with that.
Well, it's just this, you say, if this urban site is deemed to be a suitable location in principle for a new SEMH school. Well, it is, isn't it?
Yeah, and I'd say, well, it's acceptable if this is, so I agree.
Sorry, it's the word if. This site is deemed to be a suitable.
I agree.
So there's no if about it, so far as your evidence is concerned.
I think my perspective is that I don't disagree, but I think it's the decisions for that are, in my perspective, my view, there are better placed people to determine if this site is relevant for a SEND school. So in that respect, I agree.
Do you mean by that the local planning authority and the Children's Services Department, both of which are presented,
and the Department for Education? I
Right.
think they have the expertise in this, certainly more than I do in that respect.
Yes, you're identifying it as an urban site in this paragraph.
Yes.
That's a fair description, isn't it?
I think it's a descriptive element for myself that it is urbanized.
Right. That's good.
No, it's not meant specifically in respect of the housing SPG, etc., etc.
All right, fair enough. You're not going to enter into that debate.
Well, I could, but I just want to clarify. It is my previously in my I call it it's suburban in character, which I know you've not picked up on, but they are descriptive experiences that I have seen from a professional perspective. But here, it's the context is meant in that it is within an urbanized area.
Right, and the as I was saying, the height that's being proposed, save your comments about Block A, acceptable, and also the design, considerate to local circumstances. That's your professional view.
Yes, I think that the design for 4 stories can be achieved here without with the broad design of this scheme.
Yeah,
in terms of its
fine.
massing is safe for Block A.
Yeah, that's how I'd understood you to say. So, and then importantly, you also, I say importantly, but just so we know what the issue and dispute is, it's accepted in 6.3.3 that there will be no material harm to the immunity of users of the Gurdwara inside the facilities, the complex of buildings themselves.
Yes.
Yeah.
Yeah. That wasn't contested, so I agree.
No, and the same about the school in the same paragraph.
Within yes.
There are other things that you mention here which then don't get picked up in your planning balance, but let's just be clear. I mean, I'm not going to spend a lot of time on them, but for example, 6.3.5, you're identifying sorry, 6.3.4, you're identifying enhancement to pedestrian and cycle movements within and around the surrounding site, which you see as a positive.
Yes.
Yeah, they're not mentioned later on. It's just, I'm not sure it
I
matters
think I might-
particularly, but just to be clear that that is.
I may have broadly rolled it in with public realm improvements, but
All right.
it is a
And
benefit. that I
It is a
agree to.
benefit,
Yeah.
as is the potential use for the Gurdwara of parking spaces at the school in outside hours and the community facilities, which you've identified in your proof.
It is a benefit, but as you know, I don't attach quite so significant as weight to that
No,
as,
that's
as others.
Understand that. Right, then just on aspects of concern to the Gurdwara, we've already touched on some of these, and I'm not going to spend a lot of time going through them. Bearing in mind we obviously we know we disagree in key respects, but first of all, just in relation to the car park and ceremony area you refer to, 7.2, you deal with noise, which I'm going to leave for others because you're relying upon the evidence of others in that respect, correct?
Yes.
On the question of overlooking and privacy concerns, can I just, again, it's probably not going to be helpful to trade blows about that, just help though, it's a matter of principle. If you've got ST8 and ST13 to hand, Mr. Tickle's appendices. ST8 is, I mean, so you'll go and see this. I just want to agree certain distances. ST8 is a series of views coming up Alice Way, and culminating in a plan with some measurements.
Yes.
Yeah. And you can see Mr. Tickle's drawn on their plan there a distance of 18 meters to the building on the appeal site at Block A to a line in the car park, centre line of the car park.
Yes, correct.
It's about 18 meters, I think, 16.5 meters to the balcony.
Yes, I can see that.
Let's see, yes, and then corresponding other distances. Can we just put that in context for, he's drawn it to the center line, but ST 13, and we're talking about use of that area, for example, if people were coming into the car park to get to the temple in its ordinary
Sorry,
use.
I don't seem to have ST13.
Last page of ST13.
I think it's with the rebuttal rather than the main proof, isn't it?
Yes, it's a continuation of the numbers, but if you've got them in separately, there's a picture of the car park.
Yes, got that now.
The way the car park's laid out in terms of entranceway and cobbling down to the Gurdwara, it's not actually in the center, it's off to the left or the west, isn't it?
The south. That obviously this isn't north south.
Sorry,
is it?
south, yes, southwest.
The entrance to the off Alice Way into the Gurdwara car park.
No,
area.
I know the entrance is to the south. Sorry, the center line of the car park. The way it's laid out, the inspector would see put the two together. In fact, it's further away. If you are traveling into the Gurdwara to get to a wedding or an event, the car parking is predominantly on the right-hand side. It's about 4 layers of car parking spaces. You can see them on the photograph.
Yeah.
And the main entranceway and the processional route to the Gurdwara is on, I was going to say the left-hand side, but you
it's
call it
running north-south, more or less.
and it's shown in the paving itself.
In the beige paving, right, as opposed to the red.
Yes,
pavement.
exactly
Yeah.
right. Exactly right. So the distances from the edge of the building are more than 18 meters away from the edge of the building for the main route down to the Gurdwara, aren't they? As a matter of fact.
I don't think necessarily. I mean, that's the. I see what you're saying, and
Well, I'm just trying to agree the facts, Mr. Robinson. That's right, though, isn't
yeah,
it?
I understand that completely. I would say the principal reason for that is as it's a 6 meter wide parking and manoeuvring space. It does lead up to the main entrance of the Gurdwara, and
Yeah. So
it provides a route through, but I don't think it's designated as a processional route as such.
well, it's the direct route through. If there's any parking in that area, that's the route
You wouldn't expect there to be a car park there. Yes, I would agree with that. So you would approach, and when we do go, you would approach up that route. Yes.
Yes. Whenever there's parking on the building, on the car parking area, that is the line shown to the temple.
Yes.
And all I was trying to agree with you is it's more than 18 meters. I don't.
From the edge of the.
Yes.
Factually, yes, I agree.
Yeah.
I agree. I agree that the distance to that area is 18 or so meters.
Yes.
Yeah.
And I'm just dealing with sort of privacy distances and things of that kind. There isn't any standard for, or indeed direct policy, which sets out guideline distances for buildings overlooking religious buildings, car park areas, or even areas such as this, which sometimes combine car parking and ceremonial areas, is there?
There's no specific distance assigned to it. It's within the judgment of the decision maker.
Yes, insofar as there are any guideline yardsticks that have been referred to in the inquiry in terms of privacy, those are relate to housing, where 18 to 21 meters, where people can see directly face to face into each other's rooms in a private environment, your house, your habitable room. 18 to 21 is the sort of yardstick,
Yes.
as it's referred to.
And then we've yes.
Thank you. And 7.4.12, I think you pick up on this. The way you put it is you accept that consideration of privacy with respect to users of that area would be different to that of privacy afforded to an existing residential amenity area, which is a fair comment, Mr. Robinson, because people would expect a greater degree of privacy inside their house and through a window than a car park ceremonial area of this kind, wouldn't they?
I would agree. Not just within their house, but within their
habitable room.
Within a in regards to a habitable room, in regards to their amenity space, but the yes,
yeah,
there is a far higher degree of weight set down in policy, and so we have the figures that you've just mentioned.
Yes.
And the
to protect a greater level of expectation of privacy than in relation
it's
to
a
this
far
area.
more common occurrence, so it's bound to have more.
Yes, but a greater level of expectation of privacy in one's own habitable room than in a ceremonial area which is used as car park and ceremonial area.
I think
well, that's what you're saying in 7.4.12. I'm not saying it's discounted, because you say you shouldn't discount it, but it's a different order.
It's a different approach to it. It's
right.
It's a different consideration that you would take into account, because the privacy of a group used religious space, and I know we debate on that, but my position is obviously that it is used as a religious space as well as a car park, that the considerations for that are different in nature. as opposed to the more understood and well used and well documented approach to considering privacy between dwellings and inhabitable rooms, etc.
Yes, I've got that, and we've had a debate about how you use them in an urban area or even a suburban
Absolutely,
area as a
yeah.
yardstick only. Fine. So I've dealt with also under this heading the question of future development. So I'm not going to ask you more questions about that. Just in terms of the impact on the priest houses, this is something you appear to raise. That's not something raised by the I'm not sure if it was raised by the local planning authority or not, but in any event, it's dealt with by Mr. Mannering. And again, we can let the inspector judge the result, but you don't dispute the distances he's plotted in his main proof of evidence, if you need to turn it up, page 34 of 51.
I'm familiar with that plan. I would say that.
Well, yeah, I know you may be familiar with the plan, but I'm just
I
trying
was
to
going
record your evidence.
I was going to assist you with.
Okay.
I'm anticipating slightly, but with regards to the evidence presented, and I can consider that in further detail in terms of the amenity impacts to the rooms within 231 to 235, and bearing in mind Mr. Tickle's evidence that I would accept, and perhaps we might have picked this up in chief, but I would accept that the privacy aspects are not as strong as perhaps worded within my proof. So I would change my position to a point on that in terms of privacy to those rooms because of the angles and the distances as set out.
Well, not as strong. They're not a reason for refusing the scheme, are they?
I think the outlook is still a question, but I on that alone, I think that would be a difficult. No, I don't think that the privacy to the houses themselves, I think it's been dealt with.
And the same to the amenity space, insofar as that's raised as an issue. I don't think I'm not sure if it's raised by others, but the distances we're dealing with, as set out, are, if you take a back-to-back relationship contemplated in the housing SPG, it's dealing with specifically window to window 18 to 21 meters. Necessarily, there would be overlooking of gardens. They frequently back onto each other when one can have a shorter distance without causing an undue problem.
Yes, but you have to phrase it. You have to consider it within the nature of development and the relationship between the buildings and it's not been touched upon. Well, it has been discussed in terms of 4-story buildings elsewhere, but common approach would be if you had a 6-story building facing a 6-story building, or a 2-story of 6 versus a 2, then that distance might have to be larger to reflect some degree of privacy. But in the broad context of this, I agree. Yes.
Okay. So you've got the distances, so we can make judgment about that, right? And then,
but sorry. That was about the amenity space of the
yeah,
houses
I'm dealing
in
with. I'm trying to deal. I'm really trying to agree the ground rules as principle and the distances. I'm not going to trade blows with you about the judgments, Mr. Robinson, because we disagree with you.
Well, I think as I set out, I mean, the amenity spaces, there's 2 in particular, but 1 in particular is 231, is directly underneath. As a correct terminology, it's not directly vertically underneath, but it is well below. It's the first thing you would come to with regards to the southern end balconies within Block A. So there's direct overlooking into that. There's not a 18 to 20 meter. I can see a bit over the fence. This is looking straight down.
You'll be aware from the housing SPG that the 18 to 21 meter yardstick is specifically and expressly only concerned with window to window, and it excludes, doesn't it, balconies in the housing SPG itself. It expressly makes that point.
It does, but it's elsewhere covered in the housing SPG and the housing standards, and I think policy SC5 of the local plan, where we're talking about balconies not overlooking existing amenity areas.
Well, it doesn't prohibit that at all, does it? There's a judgment to be made.
Well, there's adjustment to be made, but it just states in
Right.
SC5, I believe, that it shouldn't result in a loss of privacy to nearby. Is it SC5? It's a consideration elsewhere in the plan about the.
I
the
agree.
impacts.
Loss of privacy, I agree, is a consideration, if that's the point, but then there's a judgment to
There
be
is a
made.
judgment to be
Right,
made, I
fine,
would agree,
I'll
yes.
leave it. Okay, good. Then the two other factors you've raised. First of all, lighting.
Yes.
That's not an issue of concern for the council, is it?
It hasn't been stated as a reason, no.
Or raised in
raised at the
evidence?
appeal. No,
I mean,
raised in
there
evidence.
have been additional things raised in evidence.
Yes, I agree.
Yes, but lighting is clearly not a concern either to the officers who presented the scheme or indeed Mr. Ringer, who's now appearing to defend the member's position.
It hasn't been raised by them, no.
No. And you asserted that there's a conflict with policy EQ6.
Yes.
And I'm just going to suggest to you that that is clearly not the case. Policy EQ6, always wary about questioning people about policy because its interpretation is a matter of law, but it's obviously directed about the lighting impacts from new development, isn't it?
Can I just pull it up? Well, the title, I would agree that the predominant narrative of that is directed towards proposed new development, but it doesn't exclude consideration of how existing development would. I know you can't read it by what's not written.
Well, I'm just reading out the obvious sense
But it
of
talks
it, but
about-
that's going to be a matter of law, actually, its interpretation. But anyway, I
Well,
put the point to you, Mr. Robinson, since you're raising it. You're the only person who's articulated it in that way, aren't you?
In what way, sorry?
In the way you're suggesting that it relates to light from the good wear on the new residential scheme. You're the only person to suggest that.
Yes.
Yes, fine. I'll leave that for submission, but just in terms of what's actually then said, lighting assessments, if I'm right, would be about the lighting impacts of the scheme and an assessment of those impacts on the area, wouldn't they? If I'm right.
If you're dealing with an application which had lighting proposals amongst it, which needed to be assessed.
Yes, and then the other
there's
point
no
is
debate that the proposal here presents lighting issues which would impact on neighbouring properties. It's the lighting impact of the Goodwares lighting on the residential amenity of the new residents.
yes, I
Well,
know.
I think
That
that's
there's a
fairly clear,
difference
isn't it?
between us on what this policy is directed at. If I'm right, then its lighting impacts are about the light spill from the development on existing residential amenity.
If you're right, yes.
Yes. And in that respect, the officer's report does deal with policy EQ6 and identify why there wasn't a concern generally about the scheme.
It doesn't go into detail, or does it?
Well, it does, yeah. CD 6.1, using the interpretation of the policy I've just put to you, it's CD 6.1. It's an officer consideration of that very issue. I'll give you the reference, paragraph 8.2.8.235. Use of curtains, identifies the policy, use of curtains and blinds will mitigate light spill from residential properties, deals with the effect on the school.
Sorry, paragraph
8.235, 8.236, 8.237, 8.238. No conflict with EQ6.
I'm looking at 8.23, but there's no.
8.235. I think that's what I said.
Sorry.
Apologies if it.
I apologise again. I'm back to the scroll, the slow scroll.
If it assists, there's no issue taken or no suggestion made that light spill from the new development wasn't taken into account. That's certainly no part of our case. It's about light spill from the Gurdwara.
Have you got it yet, Mr. Robbins?
Yeah, nothing. So that does consider lighting from outside the site under EQ6, but it doesn't go into detail. It just it generally looks at the lighting from other properties. And
let's try and So with difference on interpretation of EQ6, got that. The inspector can make up his own mind about that. But just as far as you're raising an objection on lighting, it's not a concern from any other officers, and the reason for that, Mr. Robinson, is maybe back to the question of what constitutes a significant adverse impact. But the agent of change principle would only apply if there was going to be a significant adverse impact under the plan, MPPF.
But not quite so much when you discuss it within D13.
Well, that's a dispute between us. So what constitutes a nuisance? But it would have to constitute a nuisance, wouldn't it?
I would say yes, but
right.
But can I just say that what constitutes a nuisance in lighting, and I'm not a lighting engineer, that lighting can lighting can constitute a nuisance if it leads to change to neighbouring properties.
Right. So you say, Mr. Robinson, both the appellant and the council are satisfied there isn't a problem there, but back to the test, whether it's significant adverse impact or nuisance, it would have to reach that threshold, wouldn't it?
I think it would have to. I think broadly speaking, it would have to reach a threshold of nuisance for the council to then act upon it.
Yes.
Or a private case to be made, which
Fine.
can happen in a lighting nuisance.
And there's no evidence I've seen from you as to why the Gurdwara being floodlit would actually constitute a nuisance or a significant adverse impact on Block A.
But I don't think, first and foremost, I don't think it's necessary for us, for me or the Gurdwara, to demonstrate necessarily why it causes nuisance. It's the policy of D13 is for the appellant.
Right, you made that point. Can you answer my question? There's
well,
no evidence.
That's the first point.
Well, can you answer my question?
Yeah, okay.
There's no evidence put forward by the Gurdwara that the lighting of the car park, and the inspector will be able to see where the floodlights are, is going to cause any significant adverse impact or noise nuisance to Block A, is there?
Well, you've added on noise nuisance there, but
well, only because there's a dispute as to sorry, I say noise, I say light. Sorry, noise, light nuisance. I apologise for my fault. Nuisance or whatever the test is, that there's going to be a problem for Block A.
In the first instance, we have raised it as a matter for the inspector to take into account.
I know that.
However, what the first aspect is this is based on. My position on this is based on the discussions. First and foremost, it's discussions with my clients.
I'm not interested in that. I'm just interested.
I think it's relevant.
Question.
I think it's relevant to get to the point of the question.
No, I'm not interested in the point of the question. I'm interested in an answer to the question.
Well, can you repeat the question then, please?
There's no evidence from you that the existing lighting from the Gurdwara in its car parks, the inspector will be able to see that, will cause a significant adverse impact or a light nuisance to Block A, is there?
We haven't provided specific evidence, but I do need to caveat that, or at least qualify that. The reason the policy D13 looks at whether there is to understand if there would be a lighting impact, and that hasn't been carried. In my opinion, that hasn't been carried out by the appellant. There is experiential evidence, or the experience, and the inspector will see this if he visits in the evening, maybe already has, that there is lighting within the Gurdwara of various natures, which could be deemed to. I mean, and I'm not.
Well, we disagree, but that's the point. There isn't any evidence for why it would cause a nuisance or a significant adverse impact to Block A.
Well, if we haven't presented any, but I think if we were to go to I think it's within Thomas Leach's.
I think I've got the point. You haven't provided any evidence.
Okay.
You expect the appellant should
Yes.
have and hasn't.
And on expecting us to, even if policy EQ6 is interpreted in the way you suggest, it's a lighting assessment where necessary. There has to be a judgment that it's necessary.
There
in
has
a
to be a
particular-
judgment
yeah,
where it's necessary.
Right. Back to that. And neither the appellant nor the council do consider it necessary.
I'd like to give as straight answers as possible. They haven't demonstrated that. Yes, they haven't raised it as an issue.
Right. Okay. And
But they haven't
then
demonstrated
the
that they've looked at it.
second part of the test, which you overlook, of course, is even if your client were to change the lighting or do something different or considered to create a problem, the agent of change principle is only dealing with unreasonable restrictions, isn't it?
Yes, unreasonable restrictions is set out in the MPPF. Yes.
Yes. So if your client were to decide to shine a spotlight on the business park or Block A, and it was considered to create a significant adverse impact, it wouldn't be unreasonable for it to not shine such a spotlight.
Yeah, it's fact and degree, but yes.
Yes, right. Okay. So if the current situation is known, but if your client were to change it and it were to result in significant adverse impact, requiring them, if there were a nuisance created, to adjust it wouldn't be unreasonable, would it?
If they were to then change it from what they operate from now,
Yes.
that would be a judgment to be made as to whether that's unreasonable.
Yes, it's not necessarily unreasonable.
But we don't know what they would change, do we? We don't know how they
No,
would change.
there isn't a proposal to change it, is there?
At the moment, no.
No. Okay, good. Right, and then odour mentioned in your proof.
It's mentioned. I don't think we've.
Do you want to abandon that, Mr. Robinson? It's not a good point.
It's not been raised by anyone.
It's a bad point, isn't it, Mr. Robinson? There's no evidence whatsoever of anyone concerned about odour.
No assessment.
And they're in much closer properties or as close properties, existing residential properties in relation to the various vents from the kitchens currently.
In terms of odour, it potentially could have been an issue. I want to just qualify it, but we don't. I don't pursue it. So if you want to call it abandoned, then. But you know.
Finally, Mr. Robinson, this complaint about visualizations of Block A with the Gurdwara, and I'm not sure where it takes one. The inspector's able to understand the relationship from all of the drawings, isn't he?
Well, that's for the inspector to decide. I mean, I think it would have been helpful to understand when I talk about a visualization, there is a difference between. I would anticipate a chartered town planner to be able to. My experience is people see plans in different ways, but when it's your stock in trade, then yes, you would normally understand it.
The design and access statement 1.3 CD 1.3.2. I mean, in addition to all of the elevational drawings that form part of the application. Just turn to page 31 or 37, referring to consultation material, for example.
Sorry, page 31.
31
Yeah.
or 37 or both.
Is this the
37 might
isometric
be-
drawing?
37 might be it. Yeah.
My screen's jammed. I've got a copy.
37.
Yeah, hang on. Is it I'll get to it before I comment. (37) Yes, the isometric drawing.
Yeah, there are drawings that show Block A in
Yes, but I don't-
conjunction with the, just wait for the questions to
Go on.
answer. You
Yes.
made these various claims, people have made them in the past, that there are no drawings which show Block A in relationship with Gurdwara. Leave aside the normal drawings and the way they can be interpreted. It's just not right, is it? Or are you just ignoring these ones?
No, I'm not ignoring them. But we don't. You wouldn't grant planning permission based on an isometric drawing, would you?
No, but that's why I said that there's plenty of other drawings the inspector has. He's got the plan drawings. But your point was no one's able to see the relationship of Block A with the Gurdwara. Gurdwara never appears on any plans, is what you said. And it's just wrong.
It's wrong in other than I didn't say it doesn't appear in any plans. I said it doesn't appear in any plans, and by that I mean the one-dimensional plans in relation to Block A, as far as I'm aware. But it does appear. I accept it. It appears on the asymmetric drawing, which was one of the drawings. It's part of the appeal. It was used in the public consultation detail. It provides a useful. I know you haven't asked me this, but I'll offer my view. It provides a useful understanding of the site layout, massing, and what have you. But it doesn't provide the level of detail that I would have wanted to see. Understood by it's not. I mean, let's face it. At the end of the day, this is when we first made the request. This was at the planning application stage, and it was to understand the relationships. Now, there's a danger, obviously, in relying too heavily on a CGI, but CGI is I think it's become of more importance as in the present day than it ever has been, because it gives a perspective, one's experience of it, and that isn't shown. So we requested it. I mean, you can't refuse something based on the lack of it, but it would have been useful to have.
Thank you. Ms. Clutton, any re-examination, please?
Sir, thank you. I just want to go back to the part of your evidence where you were dealing with public versus private events, and I just want to ask you a few questions about that, please. Point was put to you about the procession being a public event, and that was accepted for understandable reasons. Now, firstly, there was a suggestion that weddings were only processing through the site. Do you recall that?
Yes.
In your understanding, is Milne something that just processes through the site?
No. My understanding is that there's no set ceremonial procedure for it, but it happens and it occurs, and people stay outside at that end of the southern end of the ceremonial area.
Thank you. Would you regard a wedding as a public ceremony?
Broadly speaking, no.
And what about funerals? Would you regard a funeral as a public ceremony?
In broader concepts, it can be, but normally not.
No. And what's your assessment as to how people would reasonably feel having their funeral overlooked by X number of balconies and windows?
Well, my assessment is based on the responses received and the evidence given by various people, is that it's seen as a very negative impact on their obviously emotive moment within the passing of a friend or relative, or etc.
Yes. Thank you. Now, it was also said that for the most part, this is an area that's used as a car park. If there are 200 or so weddings or funerals a year, is that would you regard that as a minor use of this area?
No.
Thank you. Now, you were also asked about relative degrees of privacy, or you made the point that there are relative degrees of privacy. And of course, that's true in all cases. So, for example, when we are thinking about, say, impacts on residential gardens, we're looking at the degree to which privacy has been respected and whether an acceptable balance has been struck. Can I ask you, please, just to confirm, what's your judgment as to whether the balance has been correctly struck here?
In regards to the amenity space of the houses that I'm concerned with.
In regard to the relationship. So I used, sorry, it's my fault. I used the example of a residential garden there as an example, just to say that there are obviously relative degrees of privacy. but I'm asking you about your judgment as to whether the balance has been correctly struck in relationship to the relationship, in respect of the relationship between Block A and the ceremonial area and the extent of overlooking.
It's been struck very poorly and prejudicial to the privacy and amenity experience of the Goodwara ceremonial area.
Thank you. Now, you were also asked some questions, quite a lot of questions, about the Goodwara's planning application. First of all, in your view, does the question of whether the Goodwara's proposal is acceptable in planning terms have any bearing at all on whether the appellant's application is acceptable in planning terms?
Sorry, apologies, can you repeat that, please?
Of course. Does the question of whether the Goodwara's proposal is acceptable in planning terms have any bearing at all on whether the appellant's application is acceptable in planning terms?
In their independent merits, no.
No. Thank you. And just can I ask you please to take up CD 13.10, which will be you should find the decision notice for the Goodwara's planning application. Do you have that?
I've got two documents, but
Yeah, you want the one that starts 9E9.
sorry, it's not opening. For some reason, it's not opening on my
Okay, well,
laptop.
let me just read to you reason for refusal 3, which I was going to ask you to read, which says, this is in relation to the Goodwara's application.
Yes.
The proposed development has failed to demonstrate that it would not result in unacceptable impacts upon the existing occupiers of neighbouring properties in terms of daylight and sunlight, outlook and noise disturbance. And then it goes on to make the point about sterilisation of the adjacent site allocation by virtue of its scale and siting. Having regard to that reason for refusal, not whatever the planning consultant on behalf of the Goodwara thought, did the local planning authority consider that proposal to have an acceptable relationship to neighbouring development?
No.
Thank you. Okay. You were then asked some questions about the access route through. You were showing the images in ST13. Do you recall that?
Yeah.
And it was put to you that, well, that route is more than 18 metres away from the boundary. Firstly, in your understanding, is that access route solely where people stand during weddings and funerals and the like?
From my understanding, no, it's not.
No. And what's your view as to whether residential separation distances to the access route are relevant in this case?
I couldn't see the particular relevance. So I didn't see the relevance of it in terms of, I don't think we got to the point of it, but
No, me
I
neither.
think it demonstrates that there is a distance to that route, but
Thank you. Now, then turning to the priest houses, please, and the impact on amenity, you referred to SC policy SC5, which I think if we just have that up, please, it's 11.1.6.
Yep.
Yeah. And you referred to the fact that proposals shouldn't result in a loss of privacy, and you said there's needed to be a judgment that was made. Part G of that policy, if we can just look at that, please.
Yep.
That makes the point, it talks about the size of the provision of private outdoor space, and it talks about balconies, And it says balconies should be designed as an integral part of the building's elevation to maximise a beneficial aspect and avoid positions that result in unacceptable overlooking and loss of privacy. And it talks about 2 other units or existing nearby dwellings.
Mhm.
Can I ask you, we've obviously heard that we have heard from the members of the public who spoke that the priests were concerned about the impacts on their properties. What's your judgment as to the impact of the balconies on the amenity space, the gardens of those properties? Because you said there's a judgment to be made. What is that judgment in your view?
My judgment is the impacts would be severe. Yes, there would be severe because the degree, proximity, and relationship of Block A and the balconies to that property. There would be numerous properties and balconies which would be perceived to be. You wouldn't have a sense of privacy within that garden.
Thank you. And then if I can just ask you then some questions, please, about policy EQ6. I won't ask you about the interpretation of that. We can make submissions on that. But you were asked about whether the officer's report deals with light spill from the development, and I had asked you about whether it dealt with light spill from the Gurdwara. Can I ask you just to look at 8.235 and 8.236 of the officer's report, please, which I think was CD 6.1. And can I just ask you, please, to read?
Sorry,
Oh yeah, sorry. It's page 57 of the PDF.
Yep.
Can I just ask you to read to yourself the first 2 paragraphs, 8235 and 8236?
Apologies. Yes. So the first 2 paragraphs.
Yeah, if you can just read those to yourself, please. Just read them to yourself. Just and tell me when you're done.
Yes, done.
Do those paragraphs address light spill from the Gurdwara's flood lighting or festive lighting?
Not expressly, no.
Or do they deal with them implicitly?
No.
Okay. Now, what do they say about flood lighting from the school or the Muga?
It says there won't be any flood lighting on the Muga.
Okay. Now, can we look at CD 11.1.21, please, which is policy EQ6?
Sorry, what was the CD reference again? I know I just had it open.
No, I've also I've just closed it by accident. It's CD 11.1.21. And it's the supporting text to the policy that I'm interested in. It's 9.13 on page 2. There it says, it talks about excessive light. It says lighting can provide opportunities for evening and nighttime activities, increase perceptions of safety and security, and add vitality to streetscapes by highlighting landmarks. However, excessive light can have a negative impact on health and well-being, as well as biodiversity and the environment. In the borough, sources of complaint include street lights, floodlights at sports fields, and lighting of advertisements. Do you see that?
Yep.
Okay. So first of all, as a matter of principle, what's your understanding as to whether floodlighting has the potential to give rise to nuisance or sources of complaint?
It certainly has the potential to.
Okay. Now, has there been, in your understanding, any technical assessment of whether floodlighting from the Gurdwara's car park and ceremonial area might cause complaint or nuisance in this case?
No.
Okay. And is there any evidence of any active consideration having been given to this point by a professional lighting specialist in relation to the Gurdwara signs?
No, there hasn't.
No. Okay. You were also asked about what the Gurdwara might have to do, and it was suggested that it wouldn't be unreasonable for them to have to change their lighting. 3 points on that, please. Firstly,
That's not what I said.
you said, well,
That's not what I said.
what did you say?
I said if they were to shine a light, change their lighting in a way which was adverse, then if it created a significant adverse impact, it wouldn't be unreasonable to, for example, not shine it at the neighbouring
Right.
building.
Well, we're not talking about changing our lighting.
Well, then that's not the question I asked. So
Okay. Well, that's helpful clarification in any event then. So no questions were put to you about the reasonableness or otherwise of changing the existing lighting. I can move on from that. I think I don't need to put those points in that instance. Last thing, just a short point in relation to the isometric drawing, please, Mr. Robinson.
Yeah.
Bird's eye view. Are we concerned about how the relationship between the buildings will be experienced by birds?
By birds?
Yeah, or other people? in the
No,
position
but it's
of
on
a
the
bird?
flight path, so they might have a view.
Okay.
No, I don't think so.
No. So how helpful or otherwise is that in understanding the relationship on the ground between Block A and the Gurdwara?
I can't deny that it has an understanding, but the question being on the ground, it assists in one's understanding of its position within the wider area, but it's not. It's one of the many tools. I don't think you would rely on it. So it has limited. It has. I would, like I think I responded. You could not grant planning permission based on an isometric drawing. I think that's the test at hand. Is that we need to have scalable, measurable drawings to understand the relationships between buildings and other features of importance, and that's why we have plans. I always get confused if it's 1D or 2D, but we have flat plans and other visualization tools.
I think it's
Sorry?
2D, isn't it?
I think it's
When they're
2D.
flat, yeah. All right. Thank you very much, Mr. Robinson. That's everything. Thank you, sir.
Right, thank you for that, Mr. Robinson. Right, that brings us then to the appellant's witness. Mr. Strawn, do you have any views about whether we begin examination in chief before lunch or whether we take a slightly earlier lunch break?
I'm perfectly happy to take a earlier lunch break, because otherwise we might have to split the evidence in chief, and we
Yes.
started a bit earlier, so we're probably at the equivalent of 1 o'clock.
I'm
in
quite
real
hungry.
Right, okay.
That's really relevant.
Yeah,
Fair
you're
enough.
hungry. Okay.
Yes,
so
we'll do that then, rather than breaking up the evidence in chief. So I think it's about 25 past 12 now, so we'll adjourn until 25 past 1, please. Mr. Strawn, if you'd like to introduce your last witness, please.
Thank you very much, sir. You should have a copy of his proof available, sir, and various appendices and the rebuttal proof of evidence as well. It's got some further appendices, if that's convenient. And I will introduce Mr. Tickle. Your name is Sean Tickle.
Yes.
You're a member of the Royal Town Planning Institute and a director of Rolf Judd Planning Limited, a town planning consultancy.
Yes, I am.
You qualified in 1996 as a member of the RTPI, with having done a degree in town planning and a diploma. And you were initially employed at Doncaster Borough Council between 1986 to 88 in the planning department, then at TP Bennett from 1988 to 2001 before becoming an associate of the partnership. And you joined Rolf Judd in 2001 and then became a director in 2005. And as a result of all of that experience, you've specialised in town planning, advising on all sorts of development proposals throughout London and the home counties, but the majority of experience in London and our major urban development and regeneration projects.
Yes, I have. Yeah.
And you've got over 30 years of experience in that respect. You also explained to the inspector in 1.3 of your proof your involvement in the appeal scheme throughout the Rolf Judd planning acting throughout the application and appeal, and you've been party to various negotiations and discussions on statement of common ground, which the inspector now has. And then you provided this proof of evidence and indeed your rebuttal, which the inspector has before him. Is that correct?
That is correct, sir.
Thank you. So I'm going to take the proof and rebuttal as read, and just going to, if I may, just ask you some questions based on those documents, Mr. Tickle. First of all, you identify in your evidence the various development plan policies that are in issue and have been considered for the purposes of the scheme. And you explain, I think your position is that the development plan should be read as a whole. Is that correct?
Yes, absolutely. There are both policies in the London plan and the Hounslow local plan. There's a significant number of policies which relate to this site, and only a small number of those are contention in regards to the reasons for refusal.
You might need to move the microphone closer because you've got a relatively soft voice.
Apologies, sir. I'll talk a bit louder.
Yeah, thank you. Thank you. And you have covered not just development plan policies, but also national policy and various parts of government guidance and other guidance, including the policy statement on schools development, CD 9.2. Is that correct?
That is correct, and I think that's a very important aspect for the scheme, particularly given the statement from the government minister at the time that there was a presumption in favour, and that has then led into the great weight that is given through the MPPF policy 95.
And so, without, I don't think going through it all now, but I think in ST1 and ST14, Mr. Tickle, you provided an assessment for the inspector, or identification and assessment of the relevant policies, including those additionally raised by Mr. Ringer. Is that right?
That's correct. There's a significant number of policies. I don't intend to go through them at this stage, but there are a significant number of policies which I've referred to, sir, in relation to matters such as affordable housing, sustainability, the principle of the use, transport, and other key aspects of the scheme, which the scheme is in compliance with and not contention by the council.
And you mentioned a moment ago the issue about school development, which is covered in paragraph 4.2 of your proof of evidence.
Yes.
And you've just mentioned the policy statement in paragraph 95 of the National Planning Policy Framework and the significance of that for this
scheme. I'm not sure we need to turn them up necessarily, but it's right, isn't it, that in your attached to your proof of evidence at ST4 and also at ST3. ST3 and ST4 are letters from both the local authority in terms of its education and child's department,
Yes.
from the proposed school operator and the Department of Education located.
Yes. I mean, there is a letter from the Department of Education at ST3, which demonstrates the support for the school and what the school will actually do, which will be deliver the first specialist educational school to be delivered in Hounslow for 10 years, providing much needed school places for children and young adults between 11 and 19 with severe social, emotional and mental health needs.
And although we've had much debate about specific things like privacy distances or overlooking of the car park area, which we'll come back to in a moment, just putting that issue of delivery of the school in context, appended to the statement of case for the appeal statement of case, were again 2 letters, I think, one of which dealt with on the part of the developer, the Department of Education, the correlation between the school and the housing development. Can you just briefly summarize the position, Mr. Tickle?
Yes, I think I raised that in apologies, just looking for the reference. Sorry. So I'm just going to pick up the policy. The importance of this is that the school will be delivering, as I mentioned before, one of the most important SEMH facilities for the borough, and the development is in partnership with Located and with A2 Dominion, where the delivery of the housing will assist the delivery of the school.
And reported in the officer's report, and we haven't needed to go to this because I don't think it's contentious, but reported and accepted in the officer's report is the principle that there is a viability assessment was completed in relation to the housing element, which in turn supports the school, and that the maximum amount of affordable housing is provided as part of the scheme. The maximum viable amount is provided as part of the scheme.
Yes.
In this situation.
Yeah, the scheme will provide 35% by unit, 39% by habitable room, and that is the maximum provision that is possible in line with the fact that we're delivering this 90-place SEMH school.
You cover in your evidence the benefits of the scheme. We'll come back to those at the very end. But you've identified the significant benefits with that 90-place special educational needs secondary school. Is that right?
Yes.
And the 124 new homes with that 35% of affordability. But you also identify other benefits, which in part are seen to be accepted, in terms of recreational community activities, both from the school itself and outside school hours, as well as highway and public realm improvements. Is that correct?
I do, and I have summarised those in the planning balance section of my proof. But there's which I can perhaps come to a bit later.
Thank you. And then just turning to some topics that have cropped up along the way, without detracting from the whole thrust of your evidence. But Mr. Tickle, first of all, the character of the site area, and there has been a debate raised by Mr. Ringer as to whether this is a urban or suburban character for the purposes of the Mayor's Housing SPG. Do you recall that?
I do, and Mr. Ringer does seem to be in a minority of one, because most of the consultants who've appeared have identified it primarily as being an urban area. That Mr. Barker and Ms. Cook, who appeared on behalf of Magnolia Park, certainly have identified it as being an urban area. And looking at the Mayor's Housing SPG, which we referenced in Mr. Ringer's evidence yesterday, which is CD 10.2.4, sir, which is page 44 of that document.
So it might be 10.2.9. I think.
2.9,
I
apologies.
think I put it.
Yeah.
Yeah.
There is the definitions of what constitutes central, urban and suburban. And I don't want to dwell too much on this because we certainly went through it in quite a bit yesterday. But certainly urban, the definition of urban is an area with predominantly dense development, such as, for example, terraced housing, mansion blocks, a mix of different uses, medium building footprints, and typically buildings of 2 to 4 stories located within 800 metres walking distance of a district centre or along a main arterial route. The appeal site is within 270 metres of a metropolitan centre, which is the second highest category of town centre in the London Plan. It has an area which is of mixed character and mixed use. There is the Gurdwara, there is Hounslow Business Centre, there is Thompson Road Industrial Estate. There are medium building footprints in terms of some of those buildings I've just mentioned, as well as Perkin Close. And it's within it's typically buildings of 2 to 4 stories. Now, our scheme is primarily a 2, 3 and 4 story buildings with an element of 5 stories as well. So we're wholly within that character definition of being an urban location.
Yesterday, I think it was suggested in re-examination that the accompanying text to the housing SPG, paragraphs 1.3.10, 1.3.16, 23, 32 and 33 for the inspector's note, we may not need to turn them up, somehow weren't in issue because Mr. Ringer wasn't taking any issue about the density of the scheme. Do you recall that?
I do.
Can I just get your view, Mr. Tickle, as to whether those paragraphs explaining the approach to be taken to developments of site in an urban area or one with a high PTAL score such as this are of more relevance than simply in relation to density?
I do believe they are related to density because the PTAL score here is a 6A. It's a highly accessible location. It's also on a main arterial route, which is one of the other definitions in the urban definition. But it's a PTAL 6A, which is one of the highest accessibilities you can have. And looking at perhaps paragraph 1.316, which is page, PDF page 46, apologies. It talked about high densities, which assume a whole lower number of habitable rooms will be more suitable for households without children. High density housing can be particularly suitable in town centre and edge of centre locations in areas with good public transport accessibility, an element of mixed use developments where open space and car parking may be limited.
How does, what do you say is that of relevance to questions such as those the inspector has to tackle in relation to acceptable outlook, acceptable privacy relationships or amenity space or relationships with adjoining uses such as the Gurdwara?
I think in urban areas, you need to be flexible with regards to the application of certain standards and certain guidance. In urban areas, there is a general acceptance that overlooking distances, as we will probably come to, can be less than previously determined figures. There is an acceptance in terms of daylight and sunlight in urban areas that there would be more transgressions of the BRE or perhaps lower figures achieved because of the nature of the typology of the buildings that exist in that area. There would just be a general understanding that in order to achieve higher densities, you would need to achieve a greater mass of building, and that will have an effect upon the compliance or otherwise of certain guidance.
The other thing that you've covered, and we may not need to turn it up now, but you've covered the latest character assessment for Hounslow in terms of SPD, CD 11.5.7. We went to it with Mr. Ringer yesterday. Do you recall that?
I do, yes.
And I think you've covered this in a note to the inspector or the inquiry, CD 1421, he says hesitantly.
Yes.
Is that CD 1421?
I believe so.
Yes.
Yeah.
And can I just, I wasn't going to get you to go through it all, but can I just get you to confirm that you've provided commentary on that document, the character appraisal and its significance for this scheme in that document?
Yes, I've assessed this, and I had previously assessed the earlier 2014 document as well. My assessment of the document is that it clearly demonstrates that the site is in an urban area. The site is in an area highlighted as being an urban terrace, but also within areas close to the obviously metropolitan centre. And in the document, there is highlighting that the typology of the central Hounslow area, which is made up of 3 different areas, we are within the Hounslow town part of that, and that is very clearly an urban location. The typologies which are indicated in the document quite clearly show that this is more of an urban location. It also identifies in the central Hounslow section the appeal site as being a site suitable for a mid-rise development.
Thank you. With all of that in mind and the other parts of your proof about how to approach the remaining issues, can I just turn to in effect, the reasons for refusal and any other remaining issues? The first is reason for refusal 1 and the agent of change. And as I understand it, perhaps Mr. Tickle, you can help me, the agent of change principle that's been invoked is solely a concern in relation to the interrelationship between Block A and the Gurdwara.
That's absolutely correct. There is no other aspects of the scheme which are being challenged, albeit that we are close to an industrial estate on Thompson Road. That would also potentially have been an issue for the agent of change, but it's only solely related to the area to the west of Block A, which is a car park and part ceremonial area.
And we'll come to that. And I know you've set out your evidence as to why you consider there not to be an issue, drawing on the evidence of others, but we'll come back to that in a moment. Just in terms of the relevant policy, the relevant policies that are cited in the reason for refusal are policy D13 and D14 of the London plan and policy EQ5 of the Hounslow local plan, as I understand it.
The EQ5 wasn't actually referred to in the decision notice, but we have accepted that the council made an error in terms of not including that on the decision notice.
Thank you. And just briefly, because I know you've covered this in much more detail in your proof, policy D13 and taking with it policy D14, there's been a debate about the meaning of that policy. And just to be clear, Mr. Tickle, what's your understanding of D13, D14 and its interrelationship with paragraph 187 of the framework?
If I go to paragraph 187 of the framework, which is CD 9.1, It's probably the second part of the paragraph, where the operation of an existing business or community facility could have a significant adverse effect on a new development, including changes of use in its vicinity. The applicant or agent of change should be required to provide suitable mitigation before the development has been completed. In Mr. Ringer's evidence yesterday, he referenced that D13 did not reference the significant adverse effect. However, it does reference the MPPF in the policy wording, I believe. And then D14, I could go to D14. Apologies. That also says avoiding significant adverse noise impacts on health and quality of life. And it then references back to agent of change principle in D13. So it seems to me that there is clear evidence in D13, which is referenced back to 187, paragraph 187, that it's a significant adverse effect. And in D14, it references significant adverse effect. It would seem illogical to me that D13 wouldn't also apply a similar test of significant adverse effect, albeit that it's not referenced in the policy.
And just asking you, Mr. Tickle, as you explained, you're a very experienced planner in London, and we're dealing here with the London Plan Policy and the interrelationship with the framework. Are you aware of any intention signalled by the Mayor of London through that introduction of the London Plan or otherwise that there was an intention to introduce a different agent of change or even stricter agent of change principle for London as compared with the rest of the country or any other urban area?
I'm not aware of that, and the paragraph has remained in parallel with the adoption of the London Plan.
There's reference to, in D13, noise nuisance.
Apologies. Yes. Yeah.
And as I put to Mr. Ringer, the identification of noise nuisance involving significant adverse impacts rather than insignificant ones. Just in relation to the question of how one assesses noise and its impacts, is that a matter for you or for those others dealing with noise?
It would certainly be for others. I'm not a noise expert, as have neither of the other planning witnesses been. And there is quite detailed, as we've heard in the early part of this inquiry, quite detailed evidence that you need to go through and understand the technical aspects of that.
Thank you. However, in your evidence, you've looked at the agent of change policies and principles of location, assessment, design, and mitigation.
Yes.
And can I just get you just briefly to comment on, I know there's a lot more evidence in there, but just each of those four topics. First of all, the location of the appeal site.
Yes, I mean, looking at how you break down the assessment of agent of change, I've broken it down into location, assessment, design, and mitigation. Location is identifying whether this is an appropriate location for noise sensitive use, both the school and the residential noise sensitive uses, as you'd be aware. This site has been allocated as a residential and school since the local plan was adopted. It was also identified in the council's SPSS document in 2014 as being an appropriate location for a school as part of a mixed use scheme. So this is by definition of the assessment that must have been carried out for those analysis, this is an appropriate location for noise sensitive uses.
And just then, turning to the more detailed assessment, you've explained that's ultimately a matter for other noise evidence. But can I just, a point made by Mr. Leach, I think, in the question of design, what other noises are present on this site relevant to any such assessment and its interrelationship with the Gurdwara?
I mean, when we look at sites such as this, the initial assessment, which is possibly carried out with the architect, with the planning consultant and others, is to assess what the context around the site is, to assess what the issues may be. As I mentioned before, Thompson Road is an industrial estate, and that has agents of change issues on other sites. We have Hanworth Road, which is an incredibly busy arterial route, which runs directly past the site, and it is a very significant noise generator. We have the almost constant air traffic coming into Heathrow, and this site sits within the 63 dB noise contour. And then we have the Gurdwara and the activities that occur in the Gurdwara, and particularly in the car park and ceremonial space.
And we'll come to the assessment of the only bit that's in dispute in a moment about that, the Gurdwara. Just then, the other aspect, design, you mentioned.
Yes, in terms of design, assessment and mitigation, I think, go together as part of a holistic process. Ideally, you look at them together in order to be able to assess the key aspects of the scheme. But certainly, one of the key aspects for design is to seek to mitigate through design and layout, and which is what the scheme has done. The scheme design developed through the process with the council over 6 pre-application meetings over a number of years, identified some of those key noise generating issues and sites, and therefore was mindful of those going forward in terms of the design, but also was mindful of the need to deliver a school which met BB 104 and met the needs of the SMH pupils that would be attending it. And that was being another key driver, as are the key drivers of good urban design, good communal space, good provision of amenity space, and other aspects of a scheme that go into the design of a scheme such as this. So design was a key aspect, and we certainly have sought to separate where possible from noise generating uses, including the Gurdwara, but not exclusively the Gurdwara, but also Hanworth Road and Thompson Road. However, in order to be able to achieve good quality urban design, make effective use of the land, and deliver a high quality school, the development has provided to the perimeter of the development, which means that there is a separation with those areas, but it's not a complete separation, because you couldn't keep separating, you'd have no site left. Yeah, at different times you have to make an objective judgment as to when you stop the separation, and then you begin to look at mitigation.
And just on that, there's been obviously not so far as the council officers are concerned, because we see what they say in the pre-app and the committee report, but subsequently from Mr. Ringer, and appears from the Gurdwara, criticisms that the appellant didn't understand the Gurdwara and its operations. You recall that?
I do. Yes, I do.
First of all, just 2 points on that. First of all, do you accept that as a valid criticism of the appeal scheme?
No, we were aware of the Gurdwara, or clearly aware of the Gurdwara through all stages of the application. Since I can comment is since myself and my team have been involved. We've been aware of the activities of the Gurdwara and how they utilise their spaces, particularly the car park stroke ceremonial area to the west of Block A.
There's a specific criticism about the use of the Nagara in ceremonies. And I'm going to suggest, but you tell me if I'm wrong, Stigl, that's a matter that was covered by Mr. Leach in terms of the time at which that was assessed and in relation.
Yeah, well, when we brought the application forward, there was no activities in terms of the three major events on site, and I don't believe there was the GATCA as well because of the lockdown. We assessed the scheme in accordance with what was on site at the time, but we were aware that there were activities into that space. But also aware of the other mitigations that we had to apply to the scheme, including the very significant mitigation required for aviation noise to the site.
Well, that's the second point I want to ask you. Yesterday, although we can spend a lot of time on going through the process again, and there's lots of evidence about that, but Mr. Ringer accepted in relation to process that ultimately, if the scheme, the end result of the scheme is acceptable, then that's not a basis for refusing planning permission if there's some criticism about the design process. Do you recall that?
I do.
Do you agree with him?
I do, and I agree that process is important, and that is clearly important in terms of how the policy is worded. But what is essential for this appeal and for the determination of appeal is what the appeal scheme is, what is the outcome of all of that work, and how that has been assessed, and whether there will be any significant effects upon the operation of the Gurdwara because of the presence of Block A to the east of it. And I think that the clear evidence that Mr. Leach provided and was, I think, supported by the cross-examination of Mr. Scrivener was that there would not be a significant effect upon the operation of the Gurdwara by the presence of the Block A apartments in relation to agent of change.
That's tackling noise. And what about the comments made about the use of the car park and the ceremony area? Have you heard anything or knew about the use of that or its use which would, from your perspective, change your view as to the overall acceptability of what's proposed?
No, we were clearly aware as a faith establishment, as a Sikh temple, there would be other activities undergoing. It's quite clear from the website. There are funerals, there are weddings. Those activities do occur. However, we do not believe that, given the separation of Block A and the distance to those activities, and also how that space is actually operated, primarily as a car park, that there would be a significant adverse effect upon the operation of the Gurdwara. Certainly, my experience of the space and my understanding of how that space is used is that it is almost exclusively used as a car park, even during events such as weddings and funerals, and certainly even some of the major events as well.
I'll come to the question of privacy in a moment. Can I just finish on the topic of noise, the noise assessments, and Mr. Leach and Mr. Scrivener in relation to this agent of change? Mr. Leach obviously gave his evidence that there wasn't a problem. Mr. Scrivener agreed that the use of or playing of the GATCA in the courtyard, which was raised when assessed against.
Sorry, so it's the Nagara played in the.
Sorry,
it's
GATCA. Yeah. Nagara played in the GATCA ceremony,
yes,
or the GATCA martial arts type ceremony, or practicing, wouldn't create a difficulty for any of the living conditions, both in the balconies or flats in Block A. Do you recall that?
Yes, I do.
And Mr. Scrivener agreed based on the assessment under British Standard 8233.
He did, yes.
And he then referred to COP95, and he also agreed that it complied with that as well.
He did, yes.
And then he was asked about BS 4142, and he agreed that an assessment on that basis would be contrary to BS 4142's own terms, 2 paragraphs in particular. One, that it's music, and the second, that there's alternative standards.
Yes.
Yeah.
I think he agreed it wouldn't be useful, it wouldn't be appropriate for ceremonial events as well.
And it wouldn't be appropriate to the 3 ceremonial. So
Yeah.
the inspector's got a note of all of that evidence. And but just standing back from that, if that summary is right, Mr. Tickle, has Mr. Scrivener or the council identified any unacceptable relationship in terms of noise between Block A or the balconies and the Gurdwara's noise generating activities?
I don't believe they have. There is no noise nuisance, and there's certainly no significant adverse effects as identified in 187.
Can I just ask you to leave aside the technical aspects, just stand back and consider that in the as in the way Mr. Leach did also, and I think Mr. Scrivener did ultimately, the question of what we're talking about here. 1 hour, I think, once a month for the Gatka
Yes.
practice in the courtyard, and then 3 ceremonial events where the Nagara is played in the area in front of the Gurdwara temple.
Yes. I mean, it's,
do the conclusions that were reached by way of technical assessment surprise you when you consider it in the context of the volume, sorry, the quantum of activity we're talking about?
when you consider that the Gurdwara is open every day of the year, and it's open from 4 a.m. till 8 a.m. The 3 events and the monthly events are a small, very small part of that operation, and therefore, standing back and looking at it, I don't believe that there is a significant conflict between our scheme and particularly Block A and the operations of the Gurdwara.
Other matters on agent of change raised by, I think, the Gurdwara. You've covered odour, but I'm going to leave that because Mr. Robinson's made clear he's not pursuing that, and I don't think that it was never a point raised by the council. So we can park unless you want to hear anything from Mr. Tickle on that. So then there was the question of floodlighting. Do you recall that?
Yes, I do.
And Mr. Tickle, first of all, there was a debate about whether policy EQ6 is engaged by the question of floodlighting from the Gurdwara on the appeal scheme. Can you just assist the inspector with your view as to whether EQ6 is concerned with that issue on its own terms?
The wording of EQ6 is clearly relevant to lighting that is being introduced by a scheme. It is not an agent of change policy. It is not an agent of change principle. It is solely to do with where lighting is being introduced through a scheme, and therefore I don't believe EQ6 is relevant. There was reference in re-examination to the wording related to floodlighting to sports facilities, but however, I think the difference between floodlighting to a sports facility and the security lighting that is present on the Gurdwara car park is extremely different. It's chalk and cheese. Floodlighting for a sports facility is very tall and very, very light, and has a very, very significant impact on a much wider area. The security lighting that is present on the site at the moment is, in my view, lower level. It's the sort of lighting appropriate in a car park, and it would be the sort of lighting that would be located in car parks next to other residential buildings. I think I recognised in my rebuttal Feltham Station, for example, which has a station car park next to a residential property. No significant effects have been identified in relation to the security lighting or indeed events lighting in the car park. We have not been, whilst it's been referenced by Mr. Robinson as being an agent of change principle, no significant effects have been identified. And certainly were not identified in the design assessment. And agent of change issues would only apply where there was an identified nuisance. And as no identified nuisance has been recognised by the appellant to the council, then I don't believe the lighting is an agent of change issue, and therefore it's not relevant to D13, or in that respect, paragraph 187.
Just there appeared to be some suggestion you need to instruct a lighting specialist to make a judgment of that kind, Mr. Tickle. Can I just get your comment on that? As a planner, do you need to be assisted by a lighting specialist to make a judgment of that kind about the lighting that's present on the car park at the Gurdwara?
No, I don't believe we would do. It's low level security lighting for the car park. Anecdotally, we understand from talking to security that sometimes the flood lighting is not on in the evenings, and the Gurdwara is closed from 8 o'clock. However, assuming that it is used all through the night, albeit that it's not clear what the security lighting would be for. If it is used for the whole night, I don't believe it would have an adverse effect upon the neighbouring Block A.
Thank you. And then just on the other aspect, I think it's repeatedly said, well, so far as designing the buildings are concerned, one needs to, even if there's any adverse impact, one needs to go back to the process of redesigning the location of the buildings rather than considering mitigation. Do you recall that sort of line of questioning, for example, in relation to noise?
I do.
Can I just get you to comment on that? In terms of the Block A and the buildings and the design, I think Mr. Leach explained that the glazing and the design is already there to address a different source of noise, namely aviation. Is that correct?
It is, and EQ5 is very specific about the issues related to aviation noise, which is the biggest concern for the borough. We are within the 63 dB contour, which I think Miss Cadbury mentioned yesterday, albeit it's perfectly acceptable. However, in that contour, you have to design for mitigation to address the noise from airplanes. You can't separate that. You can't change the layout. You have to look at mitigation, and that is why mitigation and design go hand in hand. And then additionally, in addition to that, we then look at the potential for mitigation where there is potential harm to a neighbouring property. And whilst we don't consider there is any harm given the very high specification glazing, we have introduced other measures such as triple glazing, screening to the balconies, increasing the screening to the balconies, and introducing MVHR with peak lopping, which means that you don't have to open a window if it gets to a certain temperature, which is 26 degrees. Sir. And that will be dealt with through condition 15 on the consent. So there'll be further details required for that. And there's also a community liaison plan, which is condition 44, to identify if there is any further outstanding issues between neighbours and the Gurdwara.
Thank you. And you've given a precedent where that's been used in another case.
Yes. The Eileen House scheme in Elephant Castle it's the genesis of Agent of Change. It is the site. It was 5 years in planning with the mayor, and from that became the Agent of Change principles, particularly enshrined in the London Plan. And within that, there are identified mitigation measures which are introduced through conditions, which I've appended as evidence to my proof. There is also information that is submitted to residents to make sure that they are aware that they are living next to a very noisy environment. In that particular case, it is the Ministry of Sound nightclub, which operates, I think, 4 days a week from 8 a.m. till 6 a.m. Sorry, 8 p.m. till 6 a.m. And has one of the loudest clubs in London. So that is a very different kettle of fish, shall we say, from the very minor issues related to 3 events at the Gurdwara, plus the playing of the Gatka once a month for an hour.
Thank you. You deal with policy SC5 and CC2, which have been raised by Mr. Ringer in relation to the agent of change principle. And you've explained, I think, in your evidence that neither were referred to in the officers.
No,
in the reasons for refusal.
They weren't in the committee report in the section on agent of change at all.
Yeah.
And in the minutes, there was no reference to policy SC5 or to CC2. Policy SC5 is about ensuring suitable internal and external space. It's not a design policy in that regard. It's more an amenity policy. And looking at the wording of that, and obviously within my ST1 and ST14, I've gone into detail about how we comply with all of the, I think there's 8 aspects of the scheme of the policy, 8 subsections of the policy. But I don't believe that we are not in compliance with any of those, and it's very difficult to see how that policy relates specifically to the agent of change principle.
I think the same applies to your analysis in relation to other policies raised by Mr. Ringer, subsequently CI1 of the Hounslow Plan, D3, D6 and GG2 of the London Plan. Don't ask you to go through those, but you've covered them all off, even though they weren't raised as issues by the council.
Yeah, again, we've covered, CC1, CI1, apologies, is a policy related to community infrastructure, and actually the provision of a SEMH school is strongly supported in that policy. And it's the wording of that policy actually refers to the loss of community facilities where a development site would involve that loss of that facility. It doesn't apply to community facilities adjoining. It's certainly, in terms of the positive aspect of that policy, it certainly supports the provision of a school. I think it's useful to look at GG2 because Mr. Ringer took us to that policy yesterday, and I don't intend to go through all of the policies, sir, but I would say that there are eight criterion in that policy, A to H, and all of those criterion are strongly encourage the type of development that we are bringing forward, including the development of brownfield land, on surplus public sector land, on the edge of town centres, prioritise sites which are well connected to public transport, intensify the use of land to support additional homes, promoting higher density development in locations which are well connected to jobs, services and infrastructure, applying the design-led approach, which is clearly in the evidence Mr. Mannering gave, understanding the value of the existing places, but also making this a catalyst for growth, renewal and placemaking, which is something which is identified in the character study, and also providing for effectively car-free development in a highly accessible location, and also maximising provision for infrastructure. All of that policy is hugely supportive towards our scheme, and I don't believe the points Mr. Ringer made are valid.
Thank you. Reason for refusal 2, please. The relevant policies there that were cited, SC4 and and CC2. I don't ask you to go through those again, but there was also reference to paragraph 130 of the framework, which I think was an incorrect reference there, but you've dealt with that in your proof, haven't you?
I did. I mean, the council in its statement of case conflated two aspects of paragraph 130, which I've highlighted in my proof.
Of the constituent elements of reason for refusal to, one is privacy and the overlooking in relation to Perkin Close, and that's been the subject already of evidence from Mr. Mannering in his proof as to the way the scheme had been evolved, and of course wasn't a matter of concern for the officers reporting on the scheme. And just a couple of comments which have emerged since, because you've covered this in your proof. But first of all, I think the suggestions put that there's a different privacy standard between windows within a scheme as opposed to a development and an existing residential development. Do you recall that line of questioning?
Yes, I do. And it's a point that Mr. Ringer made yesterday, and I didn't recognise it from the policy at all. And if I go to SC4, which is CD 11.1.5, I think it's subsection D, which says meet the design standards in building regulations, local planning, and expanded upon which then detailed supplementary guidance, but not limited to demonstrating compliance with prevailing daylighting standards and habitable room window separation distance or guidance. There is no reference in that guidance to the difference between an existing window to a proposed window and a proposed window to a proposed window. One would expect in good design to apply exactly the same standards to a future relationship than to an existing and proposed relationship. I think there is no difference in policy, and I certainly think there's no difference in design. You should be looking for the future high quality of development.
I think there was a point made to suggest, well, someone's got a choice. Is that necessarily true when you're designing affordable housing as to whether people have a choice to live there?
No, obviously with social rented housing, we've got 29 LAR units and 3 social rented units in our scheme. The choice is very limited for people moving into those. They would be given very limited opportunity to reject the scheme, even if it was a very small window to window distance.
And there was also an issue raised about the amenity area in Perkin Close, and you've addressed that, I think, in your evidence. Just as a matter of general principle, the appellant, and I think you, Mr. Tickle, have identified that you don't think there is an issue in relation to these relationships, but there is a condition dealing with window treatment and any other treatment along that facade, which is capable of addressing actual overlooking. Do you recall that?
I do. Is that in relation to Perkin Close?
Perkin Close, yeah.
Yeah. Yes, we have a condition 12, which allows for introduction of balcony details, obscure glazing, etc. In fact, the council strengthened that condition. Apologies, strengthened that condition in their input into the draft conditions, which are in front of the inspector.
Are you aware of any issue in relation to the relationship with Perkin Close on privacy, or either to windows or amenity, which can't be, if the inspector thinks there's an issue, can't be dealt with by that condition?
No, I don't, and I think even without the privacy, I think there is a perfectly good relationship between what are there's 9 windows which are facing towards Perkin Close. 6 of which face towards the car park area of 13 to 28 Perkin Close, and have a very oblique relationship with 13 to 28. And the 3 windows which are within a dual aspect unit, and which are the bedroom windows of that unit facing towards 29 to 44. However, Mr. Ringer, I believe, accepted that there was no overlooking concern with that, and his only concern related to the amenity space for that particular development.
Sunlight and daylight, Mr. Tickle, you've covered in your evidence, drawing on the evidence of Mr. Kidd. I don't think we need to go over that. But just to be clear, your evidence also covers an issue that was raised, but hasn't subsequently been articulated, about potential overshadowing of the Gurdwara car park. That's covered in your proof, isn't it?
It was covered in my proof, and there's an appendix to my proof which shows the what's called the shock analysis and transient analysis, which is sun hours on ground and transient analysis for the car park. I believe Mr. Kidd actually went into significant detail on that in his evidence.
And the same for 231 and 235 Hounds, so
Mr.
Hanworth Road.
Yeah, although that would not have any sun considerations because it's within 90 degrees of north.
Yep. In Exhibit ST2 to your proof, you've given a number of examples that relate to privacy distances and how they've been applied by the council. We looked at those briefly yesterday. I don't want you to go through them all, but can I just, in a sentence or two, just explain why they're relevant for the inspector?
All of these schemes are recent schemes. All of these schemes, including Manderson House, which went to committee on the 11th of June of this year, so just two months before the start of the inquiry. And they all demonstrate that the council has taken a flexible approach, as it should do in urban areas, to the overlooking privacy distances between window to windows. It's demonstrated, I think, there's 4 examples. We could have continued to go, but we think we've shown 4 fairly relevant examples. I think the Manderson House one is extremely relevant because there is clear face-to-face distances there, and there's no obliqueness, and also balconies which are actually even closer to windows, so creating an even more significant overlooking and privacy. Again, those were accepted by the council, and all of those schemes were approved.
And then just turning back to the west-hand side of the site and reason for refusal 2 and the effect on the Gurdwara car park area and ceremonial space in terms of overlooking and privacy. You understand that that's obviously a concern raised by Gurdwara in particular and the council. And can I just get you to kind of, again, you cover this in your proof, but just comment on the evidence that's been given to date, Mr. Tickle, as to your understanding of that evidence and the use of the car park, and why you're satisfied the relationship is an acceptable one.
The area which we described as a car park and has also been described as a ceremonial area was designed, I think, in the original consent, 1986, as a car park. It was referenced in the 2003 Phase 2 application as a car park. It has been used almost exclusively as a car park. Every time I've visited the site, which is about 6 or 7 times now, it has been used as a car park. Colleagues have visited it, and we've spoken to. I've had a conversation with the security guards for the appeal site. Everyone's seen at all times that space has been used primarily, well, as a car park. The areas which we just discussed earlier about where the majority of people on a daily basis will pass through the car park to get to the main entrance to the temple is via the access way, which we described earlier in relation to my exhibits ST8 and with the photographs from ST13.
We had those on screen earlier, but it's showing on the ground there's a marked out, in effect, parking area and a route through a pathway, or however you want to describe it. Is that ST13? Is that what you're referring to, Mr.
Yes, I
Tickle?
was. Yes.
Yeah.
Yeah.
Sorry.
I can go to that evidence if you think that's useful, Mr.
So it's ST13 was the photograph towards the end we had in, I think he's describing. And the ST8, you had some distances, I think, didn't you, from the...
Yes, I can.
Yeah.
I've-
Sorry, I interrupt you.
yes.
So you're referring to the predominant use of it. Then there's evidence from Mr. Adan about the stage area and the Sadar area. And there's reference to use of 200 weddings and funerals occurring per year, Mr. Tickle. There's reference to wedding parties, for example, using that area to meet and greet as part of the Milne process. And there's some photographs of, for example, someone coming through, processing through from Alice Way. And there's even a picture of a hearse in the courtyard area. So putting all of that evidence together and what's been said, do you have any concerns about the relationship between Block A and the balconies and how that space is used currently and will continue to be used?
It's my understanding that even during weddings and funerals and other events that the car park continues to be used, and it would make sense for it to be used, because one of the concerns raised by Mr. Adan and by Mr. Robinson in his proof is the lack of car parking on the site and the need to provide car parking for events. There's no reason why wedding guests attending a wedding would not park their cars both in the phase 1 and the phase 2 car park. And then through Milne, meeting at the gates and walking up the access way to what would be the main ceremonial space, which is the area in front of the main temple where the flag is, which has I think it's no car parking in that particular area. That is to the north of where we have Block A, and I think we can see that on site, sir. Which we can describe that very carefully. That is a space which I have described as not being a private space. It is private land, but it is not private in the sense of it's easily viewable from public street, which is Alice Way. Or Alice Way is a private road, but it's still a public street. There's no prohibition to use it, and there are a number of businesses which use the Hounslow Business Centre. So there is clear there's lack of privacy to that space. Conversely, the distance from Block A across where the car parking is, as shown on ST13, would be a distance of circa 18 metres, which would be, I think, sufficient to provide some degree of separation between the majority of people who use it. And certainly when I visited, everybody who's walked by foot has walked to the left-hand side of the car park, with the western side of the car park, to the entrance. Nobody has walked through the car park other than somebody parking their car and then walking to the gate. So I think that the status of that piece of land, whilst it is, I recognise Mr. Adan's evidence, it's not the evidence that I've seen on the ground, and I've seen no other evidence to convince me that that is not an important facility for the Gurdwara, albeit that facility is a car park.
If reference is made to, I think in a moment ago, and Mr. Adan, and you talked about wedding parties, say a funeral taking place at the Gurdwara, and again, Mr. Tickle, so far as the car park area is used for parking, or people, or even a funeral cortege coming through to the Gurdwara, do you have any concerns about the Block A looking onto that area in terms of loss of privacy or respect for such events?
The funeral party would travel, I assume, on public roads to get to Alice Way. Alice, as I've mentioned before, Alice Way is not a private, whilst it's a private road, it is not a private space. clearly public and there's lots of people using that space, there would be no understanding, I think it's probably the wrong word, of privacy in that particular space. I believe from the photographs set out in Mr. Arden's evidence that the funeral cortege would use the courtyard, which is a private space and is away from other people, and would be a wholly appropriate location if there was concerns about privacy. But I don't think there is a degree of privacy that is present currently in the car park that has been expressed by the Gurdwara or by the council.
Thank you. There's a lot more evidence, obviously, before the inquiry about that. So, but just by way of summary. So back then to just reason for refusal 3, introducing reason for refusal 3, but linked to reason for refusal 2. I think there's a complaint about the approach to the design of the overall scheme, which then feeds through into the question about amenity space. But just before we get on to the levels of amenity space, there isn't any criticism of the design per se, as I've understood it, Mr. Tickle, of the block arrangement, save for the relationship with Block A, heights of buildings, save for, of course, the relationship with Block A and the Gurdwara, or the sort of general disposition. Is that correct?
That is correct. From the evidence I've heard at this inquiry, the council and the Gurdwara have not expressed any concerns about the overall design of the development other than Block A, apart from the concerns related to overlooking to Perkin Close.
Can we turn to amenity then, reason for refusal 3?
Yes.
And again, you've got some quite detailed evidence about that. Let's just see if we can summarize the position in light of the evidence yesterday. The relevant policies for amenity, I think, have been identified by you in your evidence for assessment of what space is required. It's common ground, isn't it, that the more private amenity space is provided than is required?
That is correct. Yes, we are providing the private amenity space is substantially above what we need to provide, and I can maybe bring to the inspector's attention. Apologies, that's going to. On paragraph 4.7.20, I've listed a table below that paragraph, which provides an indication of private amenity space and the required amount of communal amenity space.
Thank you.
And as you can see, we're providing substantially more private amenity space, and that is therefore able to discount some of the communal amenity space.
Yep. And then I don't mind which way order we do it, but let's deal with the question of play space. There's an agreed policy requirement of play space of, I think it's around 489 square meters, correct?
490 square meters,
Sorry,
I believe. Yeah.
Well, yeah. And then a requirement for communal space that only comes from the Hounslow requirement, doesn't it, rather than from the London plan?
The London plan doesn't have any specific requirement for communal amenity space. It only has requirements for private amenity space.
And so your table 4.720 identifies the areas. There's a debate between you. I just want to see if we can summarize it as to how you calculate amenity space and the play space. Do you recall that?
I do, sir.
We've got, so you've got the document CD, with the two diagrams, CD
It's
16.
additional 16.
0.6. Lost it now.
Yeah, it's
16.7.
16.7. Yeah.
And can I just see if you can help the inspector where the differences are, and what the judgments are to be made? Your calculation, I think you've explained, if you look at CD 16.7, you've measured those areas which are communal amenity space in a sort of darker, sorry, a sort of slightly lighter green, but not fluorescent green.
Yes.
Fluorescent green is more private amenity. And then there's a darker green, which is the play space areas.
That's correct, yeah.
And you've come up with, from the two areas, your figures, which are shown in the table.
Yep.
You've not included any inclusion of public realm, such as that's created on the Clarence Terrace side of the scheme at Block B.
No, and the diagram which has been produced by the architect has in a light grey colour, a light grey wash, an indication of what public realm is, and you will see to the right or east of Block C that there is an area of public realm. If you scroll to the bottom next to Block B and along Hanworth Road, you will see there is a further area of public realm. None of that has been included in the amenity space.
Okay. And then if we turn down the page, we get Mr. Ringer's alternative calculation.
Yep.
And the inspector just need to know what's going on in terms of difference. Mr. Ringer's excluded parts of the areas that you'd included. So if you look at the Block C and Block D area, he's excluded the part on the right-hand side by Block C, which takes you out towards Thompson Road.
He has, yes.
He's excluded areas around the edge of the communal space.
Yes.
Around Block C from his calculations. He just shaded them out.
Which is baffling, because the areas that he's excluded around the green space are actually areas of planting, which are clearly areas that would be included in an amenity space. And it's within his own evidence, he included a diagram from the Housing Standards LPG, which clearly showed planting and such areas as being part of a high quality shared amenity space.
And he's done the same for the Block A, Block B area.
He has.
Well.
It's quite a large area actually. He's excluded.
Yeah.
To the north, next to the wall with the car park for the school. There's some areas to the bottom which are within the private amenity space of Block B, but certainly the areas adjacent to the car park are clearly communal amenity space. And then the area between Block C and Wings Academy, he has excluded, albeit that I've demonstrated examples, including the Charlton House example, where an almost identical area was included, and it's difficult to see why this area would be excluded from being communal amenity space. It is gated and private. It's safe. Children could play in that space. They could use trolley scooters. They could kick a ball if necessary. They weren't told off. There's lots of uses for that space. Similarly, the space between Block A and Block B, the bottom part of the site, again, a large area of planting has been excluded, and areas which would be social areas, communal areas, has been excluded. Again, similar, the precedents which I've set out in ST9,
ST9, I think it is, yeah.
Clearly show that such areas are not excluded in a number of examples across the borough.
Yeah.
And we've sought to maintain consistency, as we should do in planning, between the use of such standards as amenity.
Yeah. So I hope that's sufficient for the differences that you can see. I mean, the areas of planting, I'm just looking at Block A and Block B. You can see where he's drawn his green lines and red lines. They just exclude all of the areas that are shown as planted up on the west, north, and east side of that communal space in his drawing, don't they?
Yes, yes.
Have you ever seen that done in relation to communal space, that you exclude planted areas?
No. I mean, communal amenity is not just somewhere where someone can stand or walk. It is something that is an amenity space for the enjoyment of the residents. And again, in my rebuttal evidence, I have replicated the diagram that Mr. Ringer had in his, it's 02122, paragraph 02122 of my rebuttal evidence, which, apologies, is sorry, it's CD 14.12.
Yeah.
There is a paragraph, sorry, there is a diagram which is an extract from the London Housing LPG, describing well-designed shared amenity space. And as you can see, there's clearly planting. In fact, it references planting. It references growing. It references the circulation. It clearly indicates the circulation spaces, and it includes storage as well. There is a bike store and a bin store which is in Block C. They will not have an impact on the usability of that space as a communal amenity space for residents to walk about.
The second big difference, I think, is in relation to what's called double counting. Your calculations don't double count,
No.
i.e. you've measured separately play space and communal space to get to your figures.
Yes.
However, Mr. Ringer has explained that his approach is to use double counting, i.e., and just so you're clear about double counting, correct me if I'm wrong, Mr. Tickle, what Mr. Ringer does is he's taken off lots of the area of space you've used, but then he's double counted areas so that the play space is measured as a subset of the communal space.
Yes, if I take you to CD 16.7 for his figures, he's got, for example, it's simpler to use the southern courtyard. He's indicated 518 square meters of communal amenity space, and that includes 107 square meters of play space.
Right. If you apply the principle he's applied to your calculations, if the inspector adds back in those areas we say are legitimate communal space, but you take account of double counting, Mr. Tickle, you do what Mr. Ringer's done, is there a shortfall in play space provision, for example?
No, there's not.
Just help the inspector with why that's the case.
So if I just take you to the plans with 16.7 and the first one, we have communal amenity space of 915. That's the total between the two blocks, and we have 383 square meters of play. That totals to 1,298 square meters. So that's the total open space between the two blocks.
If you're double counting.
No, that's
the total space.
Total open space.
And then if you double count in the way Mr. Ringer's done, you add in the
490 of that 1,298 would be, the 490 is the requirement. We've provided 383, which is why we've got a shortfall of play. But if we met the requirement of 490, that would be within that 1,298. We would then have a shortfall of communal amenity space of 410 square meters, because the communal amenity space would also be 1,298 square meters, and we've got a requirement for 1,708. So there's a shortfall of 410.
And just that Mr. Ringer says that's the approach he's adopting. That is the approach that's been adopted by the council in other schemes, as you've identified in ST9, which is to recognise some double counting.
Including Manderson House, which went to committee in June, where they had a number of different areas. They had 3 roof areas, a sort of podium play space in the middle, which included the play facility. They also included contrary to what Mr. Ringer said, they included the green amenity roof, which had no access to residents at all, and is actually used for PVs. That space, that development met its play space standards because it double counted. If we do the same, we do not have a shortfall of play, and we have a smaller communal amenities shortfall.
So that being the case, is there a reason why you haven't followed the same approach that the council uses?
Because we felt that it was appropriate to, and we on other such schemes in other boroughs, we have been encouraged to separate those out. However, in the London plan, in the MERS SPG, housing SPG, it talks about multifunctional spaces, and multifunctional spaces can be shared communal amenity spaces and play spaces. However, we took a purist approach, and we separated the spaces.
I suppose in practice it may be the difference between whether an adult supervising a child in a play space is in turn enjoying some communal space that's part of a recreation
Absolutely.
area or not. I suppose that's the difference in essence. Yeah. But so far as the London Borough of Hounslow is concerned, it has a specified requirement for communal space, which is not part of the London plan, the specification, but it's quite a significant amount that's required. But it
has a requirement for communal amenity space that is substantially higher than most boroughs in London. In fact, possibly all boroughs in London.
But it appears that it balanced, Mr. Tickle, that by allowing the double counting that Mr. Ringer's advocating. Is that
which is the approach that they have taken on a variety of different projects?
Right. Can I,
before we move on from that, if I'm understanding correctly, can you put a note together which tells me, using the double counting approach that the council advocates, what the provision is, and you say that would then meet the standard, and if the council can have a look at that and agree that that's the approach that it would take. I understand that there's still differences between the parties, but on the double counting approach, as we're calling it, whether the standard would be met.
I'm sure we can do that. So there'll be a difference of the type we've gone through before, which is which areas you discount from, but I'm sure we could agree the principle that, subject to that debate, what is double counted and what's not. Yes, just.
To be honest, to be fair, sir, yesterday was the first time that we had been told by the council that they would accept double counting, because in Mr. Ringer's proof of evidence, I think he actually criticises for for double counting when we weren't.
Right. That I just want to try and finish as quick as I can. I would have another 10 minutes for my estimate. Right. Whatever the figure is, Mr. Tickle, let's assume it's the higher figure of deficiency that's claimed by Mr. Ringer, and not the lower figure. Let's just assume, and let's assume we're looking for the 107 or 14 square meters of 12 plus play space off-site.
Yes.
And is it 790 square
793 communal amenity
communal
space.
Yeah. First of all, as a matter of principle, the council seem to accept, and I think you agree, that those deficiencies can in principle be met off-site through contributions in appropriate locations. Do you agree?
For communal amenity space, yes. Yeah.
And for play space?
For play space, subject to the accessibility.
Yeah, as I said, appropriate locations.
Yeah.
And on the question of appropriate locations, first of all, the school multi-use games area has been referred to in the evidence, and there's some guidance on that in the Mayor's SPG.
And I think Mr. Ringer accepted in principle that was relevant to an assessment, but he didn't regard it as making a contribution because it would be subject to a fee. Do you recall that?
I do.
Yeah.
I think there was a misunderstanding about the difference between what is multifunctional space and what is school provision, because the reference to the paragraph that Mr. Ringer made was in reference to multifunctional space, which in the glossary, which is PDF page 8 of the MERS SPG, which is CD 10.2, 23, sorry, CD 10.23. I don't have a page number for that, but I think it's PDF page 8, it's glossary. There is a definition of multifunctional space. And
Yep.
this says multifunctional space is a shared public space or communal space which offers a range of leisure and recreation opportunities for users of all age. Multifunctional spaces for all ages should be the optimum. I think there was then reference to a paragraph in the plan, sorry, in the SPG related to the fact that space should be free for all. And I might go to paragraph 4.16 of the SPG, which is, sorry, sorry, just managed to lose my spot. Yeah, the bottom part of that paragraph, we talked about existing national standards. It's the bottom part of the paragraph says standards for play provision are in addition to the quantitative standards for open space provision applied in open space strategies, although opportunities for the multifunctional use of open space should be optimised. That goes to the principle of double counting. There's then a further reference to in 4.41, which I will try and find very quickly, a bit quicker than last time. No, sorry, 4.40, apologies. No, sorry, it is 4.41, apologies. It's the bottom bullet point of that page. It says, it starts and then goes on to the next page, the provision of multifunctional spaces that can be used by all ages and other space such as roof, terrace or indoor spaces where these are safe, convenient and accessible, what is the potential flexible use to meet the needs of all age groups. So the provision of multifunctional spaces related to which Mr. Ringer said should be free would be in line with the approach that we had taken if we do double count, because those spaces would be free. There would be no charge to be using the communal amenity space. The reference to school facilities is something slightly different. And I take you to paragraph 3.26 and then paragraph 4.43 of that of the SPG.
Yep, 3.26.
Sorry. Apologies, I've lost my space again.
I think that's page 44, isn't it? Sorry, page 42
sorry,
of the PDF.
yeah, apologies. Page 42, PDF page 42. This was referenced yesterday, but I'll just read part of that. School facilities and school playing fields can provide an important contribution to high quality play spaces for a range of community activities. Where possible, children should be allowed access to them outside of school hours. Maximum use of schools after school hours or at weekends can contribute to reducing deficiencies of play provision, providing children with a greater choice of play activities, respond to working parents. If I take you then to page to paragraph 4.43.
Yep.
Sorry.
Which is page 73 of the PDF.
Yeah, PDF.
Yep.
And it's the bottom of that page. It then says initiatives to encourage the opening of shared use of on-site or nearby social infrastructure such as school playground or sports facilities, community centres or swimming pools to local residents should be actively pursued. In cases where schools permit use of their grounds, ways could be sought for developers to provide support to achieve this, particularly where such uses are identified in the play strategy and local circumstances support this provision. This could be considered a contribution to off-site provision. I go back to the top of that paragraph. School playgrounds, sports facilities, community centres and swimming pools would all be locations where a payment would normally be expected. So they would not be free to use. They would be a payment, albeit it may be discounted, there may be discounted rates, etc. But they would be facilities separate from the multifunctional use and the paragraph that Mr. Ringer referred to.
There is a community use agreement in relation to the multi-use games area, which is the subject of the section 106, I believe.
Yeah.
Do you consider that that's relevant, the availability of that outside school hours is relevant to an assessment of the overall provision of the appeal scheme in terms of amenity space?
Yes, because that community use agreement also identifies the opportunity for priority groups. So a group such as Gurdwara or residents of the development or another priority group can be identified with a priority for bookings, but also a priority perhaps for discounted rates. In relation to the rates, there was a reference in Mr. Ringer's that they were unacceptable. However, assessing the similar out-of-school hours facilities for Heathland School, which is the largest secondary school about 1,200 metres to the south of us, that has payments of nearly 4 times the amount for £89 for a Muga, £40, I believe, or maybe between 20 and £40 for a classroom. So the costs are significantly higher than those set out in the community use agreement. And that is one of the local schools that provide out-of-hours school facilities.
But finally, on this topic, Mr. Tickle, let's assume you're still looking for that space, 114 square meters of 12 plus play space off-site and 790 square meters of communal space off-site. The debate, so far as Mr. Ring is concerned, not the other council officers, has been whether there's sufficient open space available that's accessible. In essence, that's the debate, isn't it, Mr. Tickle?
It is, and I think in that regard, the draft open space study, which was referenced in Mr. Ringer's evidence, is extremely useful. That open space study, actually, when I first identified it, I thought it was just a background document to the emerging plan, but in fact, it is actually what used to be in old money a PPG 17 open space assessment, but is now an audit of open space, which is recommended in paragraph 98 of the MPPF and also recommended in policy S4, the London plan. And that draft open space study has assessed the opportunities for open space within within Hounslow, particularly in relation to the appeal site. Well, not particularly in relation to the appeal site, but it does pick up the appeal site and the context of the appeal site. It identifies a number of different categories, local parks, and we went through the accessibility distances.
I think we can summarize, because it's in your ST5, the updated version. You provided the distances there to the various facilities. Is that right?
I did, yes.
And the closest one being Inwood Park, and there's a debate about whether it's 790 or 810 meters. Do you recall that?
I do, but in relation to that is a local park. In relation to the distance as a local park, the accessibility distance is 1,200 meters. So that would be within the 1200 metres. Lambton Park, which is also a local park, which is actually outside of the south central area, which Mr. Ringer was referring to. It's in the north central area, but actually it is also within 1200 metres. In fact, it's a lot closer than the 1080 I've referenced, because in fact it's a lot in easier ways would be to walk past the tube station here and into the park, which I've done, and that's about 950 metres. So it's actually closer than identified on ST5. There is also a small amenity space, which is one of the amenity green spaces, which is within 600 metres. But I wouldn't put an awful lot of weight to that space. It's quite a small space, which is probably useful for people walking the dog. So those Lambton Park and Inwood Park would be the two parks within Hounslow, which would be within local parks, which would be within 1200 metres. There are two other parks, Murray Park, which is in London Borough of Richmond, which is within 1200 metres, and the Hounslow Heath open space. This is a large green open space which fronts onto Hanworth
Thank
Road.
you. I think all of this was
Yep.
covered, wasn't it, with
Yeah,
Mr.
that's
Ringer?
fine.
So I probably
Okay,
don't need to
fine.
hear it again.
So,
Thanks.
Mr. Tickle, drawing the threads together, insofar as the full amount of space not provided on site, do you consider that should be a reason for refusal in this case, having regard to what's available in and around the area?
No, I think based on double counting that we'd have no shortfall of play space.
Well, even if one doesn't double count and assumes there is a shortfall.
There is sufficient local park provision, natural green space provision, amenity green space provision. There is sufficient play provision for over 12s, because the accessibility distance is 1200 metres to that, and that means Murray Park, Inwood Park, and Hounslow Heath would also be accessible.
And the inspector's going to do the walk, I think, to
Yes, to
Inwood
Inwood
Park
Park.
himself, which you plotted.
I've also done
with-
the walks to Murray Park, Hounslow Heath, and Lambton Park.
Thank you. Right, Mr. Tickle, then keen to finish the evidence in chief, but just finally, the planning benefits of the scheme versus the planning balance benefits versus harms. The number of harms have been identified by others in terms of those reasons for refusal. You've identified in your proof the planning benefits, and I just want your view in short, without rehearsing them all again here, because we can see them set out, what your advice to the inspector is on how the balance should be struck.
I think there is great weight that can be given to a large number of the provisions of the scheme, particularly the provision of a school and the MPPF, the provision of new homes, particularly affordable homes, provision of the opportunity for community facilities to be shared with the wider area, the provision of a sustainable scheme, the use of brownfield land. All of those speak closely to the objectives of the government in the MPPF and the requirements of the London Plan about sustainable development and optimising brownfield land. And I think there is any limited harm that has been identified within the scheme, or it has been recognised within the scheme, is greatly outweighed by the planning balance and the planning benefits of this scheme, including any mitigation that has been added through conditions, obligations. Yeah.
Thank you very much.
Right, okay, thank you for that. We'll take a short break then at this point and then come back to deal with cross-examination. So we'll adjourn until 3:15, please. And please, and let's hear the council's cross-examination, please.
Thank you, sir. Good afternoon, Mr. Tickle.
Good afternoon, Ms. Tarple.
Mr. Tickle, I have a time estimate for 2 hours. I'm really going to try and keep to it, and I think that's going to be partly a collaborative effort. I will try and do my part by making the questions, I hope, clear and as succinct as I can. I'll be very grateful if you could also assist in your part by giving me clear answers to the questions I ask, qualified as necessary, but starting with the clear answer.
Okay.
Thank you very much. In your 30 or so years of experience, would I be right to assume you've appeared at a fair number of inquiries?
Yes, I have.
Thank you. And can we agree it's an unremarkable aspect of the planning process that democratically elected members sometimes disagree with the advice of their officers?
It's a common occurrence, yes.
Thank you. And democratic accountability is an important part of the English planning system?
It is, but clearly also the advice of professional officers based on planning advice and planning policy, national, strategic and local plan policy is important. And
Yeah.
sometimes the decisions made at democratic level do not always reflect that advice.
Well, the planning system is set up in England in the way it is, with officers advising and members deciding, yes?
It is, yes.
And it's right for the inspector to afford considerable weight to the views of members tasked with determining an application.
Based on planning policy and any other material considerations in line with Section 38, yes.
Yep. And it's also an unremarkable feature that different officers will sometimes hold different views on matters that involve the exercise of planning judgment.
It is. I would say yes, but clarify that it's unusual that to go to a planning committee, there is usually accord between officers that application is now in accordance with the development plan in order to be able to be recommended for approval.
Well, not every officer of the council will be involved in the production of an officer's report in a particular case, will they?
No, the case officer, usually a principal planner, and often the head of planning. In this case, Matthew Rees was involved in the establishment of the committee report and the presentation to the planning committee.
I understand that, but the point I'm making is that it's an unremarkable feature that different planning professionals may reach different views on matters which involve the exercise of judgment. Would you agree?
Yes, I did. I think I said yes, actually.
Thank you. And as to the views of previous officers, it's fair to say, isn't it, that evidence that has been tested through cross-examination is generally likely to attract greater weight than that which has not been tested?
Yes, it would be, yes.
As to the approach to the determination of this appeal, we're agreed that the development plan is the starting point. Yes?
Yeah, in line with Section 38, of course.
Thank
yes.
you. And there's no suggestion from you that it's out of date or should attract anything other than full weight?
No, the London plan and the local plan are the development plan documents, and they both carry a similar weight, although the London plan is more up to date, and therefore where there is any disagreement between policies, probably one way of saying it, the London plan would take precedent.
Right, they're both up-to-date policies or development plans, and they both attract full weight in the determination of this appeal. Is that right?
Yes.
Thank you.
But where, as I said before, where plan policy is in the London plan would differ from the policy in the local plan. The local plan was adopted in 2015. The London plan was adopted in 2021.
Okay. And it's important for the inspector to identify all relevant policies and to assess the scheme against them.
As noted in ST1 and ST14, I've assessed all relevant policies.
Is the answer to that question then yes?
Yes.
Thank you. And it's only by going through that process that he'll discharge his statutory duty?
Correct.
And it's right then for Mr. Ringer to draw to his attention all policies he considers to be relevant to assist him in discharging that duty?
It is, but clearly the planning authority in determining a planning application and assessing that would have, as noted in Article 35, in determining the application positively or negatively, would have determined all of the relevant policies and identified them in the decision notice.
Well, it's the role of members to identify the issues that they consider warrant refusal, and it's the role of officers to assist them with policies that are relevant to those issues, yes?
It is, yes.
Okay. And if a previous officer had inadvertently included an irrelevant policy or omitted a relevant policy, it wouldn't be right for Mr. Ringer to perpetuate that error in his evidence to this inspector, would it?
In terms of relevant policy,
Yes.
yes, you're correct, but to clarify, that would need to be going to the heart of the determination process at the committee.
Well, I'm not sure I follow that, but I think we're
Yeah.
agreed that
Yeah.
if an officer had inadvertently admitted an irrelevant policy, it wouldn't be right for Mr. Ringer to perpetuate that error. And the reason for that is because that would potentially lead this inspector into legal error if he wasn't advised of all relevant policies. Yep,
That's correct, and as set out in my ST1 and ST14.
thank you. Can we also agree that sometimes there'll be adverse impacts from a development that don't themselves justify refusal, but it's still right that such adverse impacts should be considered in the overall planning balance?
They should be considered in the planning balance, but if they're not impacts that are so sufficient as to warrant refusal, then they would not be reasons for refusal.
No, but they should still be weighed in the planning balance. All adverse impacts and all benefits.
All positive and negative aspects of the scheme weigh into planning balance, which is identified in my conclusion.
Thank you. And in some cases, there'll be policies that pull in different directions, some weighing in favour and some against a proposal. Yeah?
It's very rare for any scheme to be wholly in accordance with every single policy. Yes.
Okay, yes. And in that scenario, the inspector has to consider all aspects, some compliance, some conflict, and come to a view overall as to accordance with the plan.
That is correct, yes.
Okay. Thank you. And planning isn't a numbers game, is it? So it wouldn't be right for the inspector to say, well, it accords with 15, and it only conflicts with 3. So that in itself means accordance with the development plan. That's not how the planning system works, is it?
As identified, it is. And
it is.
It's yes, and I will clarify that as identified in my ST1 and ST14, we've assessed the relevant policies, including policies which carry great weight, including the principle for schools development.
Sorry, I'm just trying to be clear. So my point to you is planning is not a numbers game. So the inspector wouldn't say, well, say there are 18 policies in a plan, it complies with 15, it doesn't comply with 3. So on the mathematical calculation, it's in accordance with the development plan. That would not be the right approach, would it?
Where there was significant divergence from policy, that would be correct. But if the sheer weight of the number of policies that the scheme would be in approval with, I think there would be a numbers game to a certain extent of that.
Okay, so if a scheme complied with all aspects of a development plan, bar, say, a greenbelt policy,
Yes.
in your view, would that scheme comply with the development plan read as a whole?
If the divergence with the greenbelt policy was so sufficient as to warrant a refusal, that could be a case for refusal. Yes.
Okay, so even though there was only conflict with one policy in that scenario, and compliance with the lot
it would have to be, as I said before, it would have to be a significant divergence.
Will it be a conflict with one policy?
Yes.
Right. So you accept that in that scenario, a scheme would not be in accordance with the development plan read as a whole, even if there were only one aspect of policy conflict.
I think that would be a very rare occasion for that, because I think you would, again, going back to planning balance, it would depend on both the planning policies and other material considerations that would weigh towards both.
I understand that, but that's the second stage, because the first stage for the inspector is to identify whether a scheme accords with the development plan read as a whole.
Yes.
Yeah.
Yes,
And we're in that stage, aren't we? Before
are.
you come on to weighing other material considerations. Now, I appreciate that you say the scheme accords with the agent of change principle, but can we agree that if the appeal scheme did not comply with policies giving effect to that principle, it couldn't be said to accord with the development plan read as a whole?
No, no. I again, it goes to the planning balance of all of the other policies that are including the weight given to community infrastructure, the affordable housing provision, and sustainable development. All of those would weigh towards a positive decision, and it would be a planning balance argument.
Okay.
It wouldn't be that if you were not in accordance with D13, it is therefore a mandatory refusal. That's
No,
not
I'm not.
correct.
I'm not asking about mandatory refusal. You do understand, don't you, Mr. Tickle, that there are two stages. The first is, does the scheme accord with the development plan read as a whole? And if the inspector doesn't carry out that exercise, he will fall into legal error. And once you've determined whether it accords or otherwise, then you go on to consider whether there are material considerations which justify a departure from the plan.
Yes.
Okay, so we're in the first stage of that analysis, accordance or otherwise with the development plan.
Yes.
I hear what you say, that there are a number of other benefits, but I'm just at the first stage, accordance with the development plan.
Yes.
Can we agree that if the appeal scheme does not accord with the agent of change principle as expressed in D13, D14 and EQ5, that it couldn't be said to accord with the development plan read as a whole? That doesn't mean necessarily permission refused, but at the first stage, it would not accord with the development plan read as a whole.
No, because as I said before, there are situations where most schemes will have some divergence from policy, and when read as a whole means the whole document, all of the policies read as a whole. If you're not in compliance with one policy, that doesn't mean the development plan read as a whole that you're still not in accordance with that.
But it depends on the importance of the policy, doesn't it?
You mentioned Greenbelt policy before, yes.
Yeah. And the agent of change principle is a fundamental aspect of the development plan, isn't it? It's the means by which the mayor and the council seek to balance the benefits of new development against the need to protect existing ones.
It's one of a number of key policies in the London plan, yes.
Okay. So
including the provision of affordable homes.
Sure.
Including the provision of new schools.
Yeah. So it is a key policy. You accept that? Yes.
It's a key policy, yes.
Okay.
I'm happy to agree that. Yes.
Thank you. And you haven't identified any appeal decision or example where a scheme has been found to breach the agent of change principle, but nonetheless comply with the development plan read as a whole?
I didn't provide any appeal.
No. And Part E of Policy D13, it's core document 10.1.16 if you want to look at it.
So just before I've got up D13, D14. Is there any other particular things I need to bring forward?
There will be many, but I don't think it's going to be beneficial to identify them now. So
I've got D13.
Thank you very much. Part E of D13 makes specific provision that boroughs shouldn't normally permit development proposals that haven't clearly demonstrated how noise and other nuisances will be mitigated and managed. Do you see that?
Yes.
Pretty clear direction, isn't it, as to the importance of ensuring that noise is appropriately mitigated and managed?
As it said, it should not normally permit development proposals. There may be situations where there are other planning benefits which overcome the harm. Let's put it that way.
Well, there may, but we're just in the development plan, the first stage of this process first, and there's a clear direction, isn't there, in Part E of D13 as to the importance of this policy to the development plan as a whole.
It sets out that boroughs should not normally permit development proposals, but there will be situations where there could be non-compliance with D13, and it's supported. Just to say we are wholly in compliance with D13.
I understand your position on that. I'm exploring the position in the event that you're wrong about that. Now, we agree that D13, 14 and EQ5 are all relevant to the agent of change principle and the issue of noise impacts generally, do we?
Yes, we do, yes.
And in your proof at paragraph 4.5.17, this is pages 26 to 27, you distill the agent of change principle enshrined in those policies to 4 specific areas: location, assessment. Sorry, it's pages 26 to 27 of your proof.
Yes, I've got those, yeah.
Thank you. para 4.5.17. So you distill the agent of change principle enshrined in those policies to 4 areas: location, assessment, design and layout, and mitigation. So can we agree that in order to comply with the agent of change principle, a scheme would have to comply with all of those aspects?
It would have to assess this, would have to be assessed against those criteria, whether
Yeah.
it's the design, it would not necessarily have to meet all of them, as long as, for example, mitigation overcame a concern over design.
Sorry, this is your summary of the fundamental aspects
Yes,
of the
yeah.
agent of change principle. Is
Yeah.
that right?
It is, yes.
Okay. And so in order to comply with the agent of change principle, these are the fundamental ingredients that a scheme would have to comply with.
In my view, yes.
Yes. Thank you. So location then. Now you make the point on page 29, para 4.5.30,
Yes.
that the appeal site was allocated for mixed-use development in full knowledge of the adjacent Gurdwara.
I do, yes.
Thank you. You haven't heard the council suggest in its evidence to this inquiry that the appeal site is incapable of development for housing in a school compatibly with the use of the Gurdwara, have you?
No, I haven't, no. And on that basis, it would be a suitable location for a school and residential.
And just because a site is allocated for development doesn't absolve a developer from complying with other aspects of the development plan, such as design or noise policy, in a full application such as this one, does it?
No, but looking at location is the first assessment of whether a site is suitable for noise sensitive use, and that is wholly, as I mentioned in examination sheet, that is a wholly appropriate site for residential and a school, which are both noise sensitive uses.
Yes, and the fact that it's allocated for development doesn't dictate the layout or obviate the need to comply with other development plan policies. Agreed?
Agreed. There isn't, as long as you're meeting the site allocation, that is one land use requirement. Yes.
Now, the second fundamental aspect of the agent of change principle that you identify is the need to undertake a detailed assessment of the noise impacts of existing uses. Yep.
Yes.
Can we agree that a noise assessment should be carefully tailored to local circumstances and should capture and assess the particular characteristics of noise affecting the area?
We can, yes.
One of the noise sources affecting the appeal site is noise from the Nagara. The noise experts have agreed that it has particular characteristics. Can we agree that it was plainly an aspect of the existing noise environment that warranted assessment?
The scheme assessed the characteristics of not just the Gurdwara, but a number of different noise.
I understand that, but could you
assessments.
answer my question, please? Noise from the Nagara was plainly an aspect of the existing acoustic environment that warranted assessment.
When the noise assessments were undertaken, the playing of the Nagara was not present.
I'll come on to that, Mr. Tickle, in a moment. Can we agree that noise from the Nagara is plainly an aspect of the acoustic environment that warranted assessment?
It would have warranted assessment if it was being played at the time when an assessment was being undertaken. Yes.
Okay, and that's because it's, as Mr. Leach describes it in his rebuttal, paragraph 2.10, the noise from the Nagara drum is significant. That's his word. And he accepted your recall in cross-examination that it's a major noise source. Do you recall that?
I believe he said it was a significant noise source.
He said in his written evidence it was significant, and he said in cross-examination it was a major noise source.
Sorry, you're expecting an answer?
Yes.
I didn't hear that, but I will
Okay.
take it on. Yeah.
Okay, sure. You accept, though, that the noise from the Nagara is a relevant consideration for this inspector?
Yes, it's been the subject of considerable discussion.
And the Gurdwara, members of the Gurdwara told members of the appellant team about the use of the Nagara, as Mr. Adan confirmed in his unchallenged evidence. Do you recall that?
I believe that's what Mr. Vidal said, yes.
Now, the first engagement between the appellant team and the Gurdwara was in October 2020. And thereafter, there were 3 further meetings before the application was submitted. Is that right?
That's correct, yes.
No one from the appellant team ever asked to go and assess the noise from the Nagara or to witness any of the events held in the external areas.
I understand that the events were not being undertaken because of lockdown at the time.
Well, the Gurdwara reopened in July of 2021. We have that in Mr. Adan's proof at paragraph 7.2.1, following which there was a meeting with the appellant team in August. That's in the statement of community involvement. So still some months before the planning application was submitted in October. And again, no one from the appellant team asked to go and carry out any noise assessment or to witness, for example, the monthly Gatka in that meeting.
No, they didn't.
No.
But the noise environment around the site, which included aviation noise, the noise from Hanworth Road, the potential noise aspects from Thompson Road properties, and any noise that was being undertaken from the Gurdwara was being assessed.
Well, we've agreed that noise assessments have to be tailored to local circumstances. They have to take into account the characteristics of noise, and that noise from the Nagara, you said, Mr. Leach, accepted as significant. Yes?
Yes.
So the fact that other noise impacts may have been assessed doesn't relieve the appellant from the duty to assess the noise impact from this source, does it?
The noise assessment undertook an assessment of the day-to-day impacts of noise around the site, including aviation noise, which is the most significant. The assessment didn't pick up the Gatka because it is a relatively infrequent event. It wouldn't have picked up the Nagara Khatan or the Nishan Sahib flag raising ceremonies because neither of those took place until November, at which point Mr. Leach did actually undertake a survey.
You've accepted that the noise from the Nagara is relevant for the inspector. It's obviously part of the acoustic environment that affects the appeal site. There was the
on an irregular basis.
On an irregular basis, well, once a month, we can
for 1 hour once a month.
We can deal with that in submissions. Mr. Leach, could I ask you to have a look at core document 2.12?
Mr. Tickle.
No, could I ask you to have a
Mr. Tickle.
Could I ask you to have a look at Mr. Leach's document in core document 2.12?
I was only correcting you because you called him Mr. Leach.
I was saying Mr. Leach has assessed.
Ms. Taffer, just want to raise at this point, I'm
Yes,
sure
sir.
you're going to guess what I'm going to say.
I am going to guess what you're going to say, sir.
Given the concession by your witness and by the Gurdwara that the outcome is the outcome of assessment doesn't rely on the process having been followed to the letter, I hope we're not going to be spending too significant amount of time looking over process.
Well, I'm exploring Mr. Tickle's evidence, and he has identified what he considers to be 4 key aspects of the agent of change principle, to which a scheme would have to comply in order to be in accordance with those.
I understand. It's just in case it's of any interest to you, what my thoughts are on that matter.
So can I just clarify something as well? You said there that the Gurdwara had conceded on that point, but I'm pretty sure we didn't.
You did, I asked Mr. Robinson about that.
The same point was put to both witnesses.
Well, Mr. Robinson doesn't believe that he conceded that point. He's sat next to me and has made that point himself. We'll go back and look at the note.
Please do, because I did ask him. I said I was repeating myself on that occasion about the outcome being the relevant. And I put it, if the scheme is acceptable, then you wouldn't refuse planning permission on that basis, and he agreed.
So can I just mention something here, sir? You have several times interrupted my questioning of various witnesses when we've been dealing with process matters. And I would just like to put down a marker that process is an aspect heavily embedded in the development plan. And it's not an arid technical dispute. It's fundamental, as Mr. Tickle has just accepted, to compliance or otherwise with those policies. And I will certainly be closing on that basis. And in those circumstances, I think it would be wrong of me not to explore these matters. And I think it would be inappropriate for my exploration of those issues to be curtailed. It may be that you're not interested, sir, but in my submission you should be, because that's what the policy requires.
Right. I'm not suggesting in any way that these matters aren't important or aren't things that I'm going to consider. What I'm saying is I've heard a lot about it so far, and we've spent a significant amount of time on it, and I've got the point, is what I'm telling you. So by all means, if you want to explore this, do, but I'm just suggesting that it might not need to be in the level of depth that I'm otherwise expecting it might be.
Understood. When you say in your proof, paragraph 4.5.23, for example, page 28, that the appellant's design team have been cognizant of the relationship with the Gurdwara from the outset, they plainly weren't cognizant of the significant noise produced by the Nagara from the outset, because neither Mr. Leach nor Mr. Mannering knew about it before the application was submitted. Is that fair?
We were cognizant of the Gurdwara as a large faith organisation and a large faith establishment, which would have a variety of ceremonies,
I understand
marriages,
that,
funerals,
Mr. Tickle.
all of that. All of the noise events would have been aware. We weren't perhaps not aware of the Nagara from the outset, but once that the presence of Nagara was made clear to us through the representations on the representations during the pre-application stage and at planning committee, then the then post-planning application, the assessment of the Nagara was undertaken, and as probably we will come to, the outcome rather than the process is that there is no significant adverse effect.
We'll come on to that.
Upon from the GATCA on the internal conditions or the balcony conditions of Block A.
Well, the matters that you've just raised do not reflect the evidence that Mr. Mannering gave us to hit the extent of his understanding when he was designing the scheme, but I can deal with that in submissions. When you say then at paragraph 4.5.32 that the use of the car park for ceremonial events generating varied noise levels has always been acknowledged and fully considered, are you able to point us to any part of the application documents, the design and access statement, the planning statement, the statement of community involvement, which recognise the use of that area for ceremonial events?
We identified it as part of the Gurdwara temple.
Can you answer my question? Is there any part of the application documents that recognises the use of that area for ceremonial events?
I can't at this stage. Apologies. I would have to go through all of the reams of planning application documents to identify that. But I'm not aware that it does. But
not aware.
But I would need to research that, and I can't say for definite.
Okay.
Because there is a lot of information, as you know.
The third fundamental aspect of the agent of change principle then that you identify is minimising conflicts between noise generating sources and noise sensitive developments through design and layout. Yeah?
That's correct, yes.
The approach then is necessarily a stage one. First, you assess the existing noise generating uses, and then you use that information to inform the design and layout to respond appropriately. Is that fair?
I think I mentioned this in examination chief. I think there is a holistic part of that. I think there isn't. It goes assessment, design, mitigation. As I mentioned before, mitigation comes in for aircraft noise straight away. There's no design.
Well, sure, because you can't design a scheme in this location that avoids the aircraft noise, but that's not the same for all noise sources, is it, Mr. Tickle?
That's what I'm trying to say. That actually there is therefore a tailored approach to these aspects. There would be some assessment, there would be some design, there may be reassessment, there may be mitigation, there may be redesign. There is a holistic process that goes on through that. I don't think it's a sequential approach.
It's not a sequential approach. Okay.
Yes. In terms of good, I think the principles of good design would say that it shouldn't be a sequential approach.
They would or wouldn't?
Shouldn't.
They shouldn't.
So sorry, they should say So I get my teeth back in. Sorry, Mr.
That's okay.
The principles of good design would indicate that it should be an approach where you are always seeking to respond to the context, changes in the scheme, further information that comes forward.
No, I understand all of that, but it's plain, isn't it, from the policy framework that design and separation, or separation through design and layout, are to be preferred to noise insulation or interventions in the building envelope. That's plain, isn't it?
Where possible.
Where possible. And in order to show that it's not possible, one would have to go through that process, look at design iterations, and indicated that in fact it wasn't possible in this scenario, consistent with sustainable development, to separate in that way.
Yes,
is that fair? Yes.
Yes, we went through, as Mr. Mannering explained in great depth, significant iterations to the scheme, 6 pre-application meetings, and there was a design evolution that took place.
But Mr. Tickle, none of that was informed by the significant noise from the Nagara. And Mr. Mannering confirmed that once he had become aware of that, he has not revisited the design at any stage since then.
That's because the scheme is acceptable in design, in noise terms.
That doesn't demonstrate that it is not possible to mitigate and manage noise through design and layout rather than interventions in the building envelope. That process hasn't been undertaken, has it?
Yes, it has been.
It hasn't in respect to the noise from the Nagara.
It has been undertaken.
Show me the design iteration then that considers whether it's possible to deliver a comparable number of residential units on the site with appropriate design and layout that separates Block A from the noise source at the Nagara.
Block A is separated from the noise from the Gurdwara, as are Blocks B from Hanworth Road and Blocks C from the other noise source, which is the Thompson Road properties. The assessment of separation has to go hand in hand with good design and other objectives of the scheme in terms of achieving good quality amenity space, good quality privacy. All of those aspects are part of the design process.
Mr. Tickle,
and
yes.
Therefore the separation distance was assessed, but therefore it was taken in balance where possible. And when it was assessed in noise terms, the conditions were acceptable.
Mr. Tickle, when things have to be looked at in a balanced way, that requires you to consider all relevant aspects. Yes?
Yes.
Okay. Noise from the Nagara was not considered before the design was fixed, and Mr. Mannering confirmed he has never looked at the design of the buildings since the appellant became aware of that noise. So that is a factor that has not been weighed in the balance in designing the layout and orientation of the appeal scheme.
When Mr. Leach undertook the assessment of Nagara, it was identified that there was no need to change the design because the noise levels were satisfactory.
Relying on triple glazing, which was proposed to respond to the Gurdwara's noise impacts.
Which is part of a design process where you, as I mentioned before, holistically take into consideration mitigation and design.
Can I ask you to turn up core document 10.1.17?
So which document is that, Mr.
It's policy D14 of the London plan.
Sorry, my mouse is deciding to be...
That's okay.
Yes, I have that now. Yeah.
Thank you. Part 5 of that policy, A5,
Yes.
tells us that development proposals should manage noise by separating new noise-sensitive development from major noise sources through use of distance screening, layout, orientation, etc., in preference to sole reliance on sound insulation. Is that a relevant policy for the inspector to consider?
Yes, and that's a policy that we took into consideration.
Okay.
Because
So where is
sorry,
the evidence? Where is the evidence, please, of the efforts to separate the noise-sensitive development of Block A from the major noise source at the Nagara? Where is that evidence?
the design access statement
Design and
demonstrated
access, okay.
the assessment of noise-sensitive development from a number of noise sources through the scheme. We're not just assessing the design for the Gurdwara. There's a lot of focus on the Gurdwara, but there are other noise-sensitive aspects of the scheme. Hanworth Road, for example, is far noisier than the Gurdwara, and the assessment of that still has located units onto Hanworth Road, and that the reason for that is because the separation distance is up to a certain point, and then we have to look at the principles of good design.
Mr.
And-
Tickle, I'm not interested in the impact of the noise from Hanworth Road, so I'm going to stop you there because that's not the matter I'm asking you questions
But
about.
it's part of a good design process.
Okay, well, great. You've carried out a good design in respect of the noise from Hanworth Road.
And
No one's
Gurdwara- and the
disputing that.
Gurdwara,
No,
we
not on the
separated with-
Gurdwara, because there hasn't been any consideration of that, Mr. Tickle.
Just let him. You've just
No,
cutting
I'm
him
not
off.
going to let him answer questions that I haven't asked. Can I please
He's not
ask
interested in the
you,
answers.
when policy talks about mitigating and minimising noise impacts, for example, D13, D14, can we agree that means as far as reasonably practicable?
Sorry, could you just repeat that
Sure.
question? Sorry,
Where policy, for example, D13 and 14,
Yeah.
talks about mitigating and minimising noise impacts, that should be interpreted to mean as far as reasonably practicable.
to get to an acceptable level, yes.
Yeah.
I mean, you could keep going nth degree.
Yeah,
theoretically.
and that applies whether the noise impact is significant or at some level below significant, doesn't it?
In terms of policy D14 or D13?
Both.
Policy D14, paragraph A3 says mitigating and minimising the existing and potential adverse
Yeah.
impacts of noise from within as a result and vicinity of new development without placing unreasonable restrictions
Yeah.
on existing.
So
it's unreasonable restrictions.
Yeah, my question was,
Yeah.
the policy requires noise impacts to be mitigated and minimised, even if they're at a level below significant. Can we agree that's right?
The policy is in paragraph 1 says avoid significant adverse
Yes, I
impacts.
know what that
and then
says.
paragraph, sorry, I was just about to
Yeah.
to agree with you. Policy paragraph 3 says mitigating and minimising potential and adverse impacts of noise. So there would have to be a potential adverse impact of noise for
Right.
there
So-
to be
so
a mitigation.
Could I ask you then to answer my question, that the duty to mitigate and minimise noise impacts applies to noise levels that are below significant?
Depend.
Just a yes or no answer would be helpful if you
well,
could, Mr.
it's
Tickle.
not. I don't think it's a yes or no answer because
It's not
I
a
mean,
yes or no.
any noise. If you treated any noise as being an issue, then that noise could be a pen dropping. But
I'm
could
just
be,
asking,
Yeah.
is that requirement?
Let him answer. If you're asking, you keep on cutting him off. He said, and in the middle of his answer, if it were any noise, it could be a pin dropping. If you want to hear the rest of the answer, let him speak. If you don't ask the question.
It says existing and potential adverse. So there is an assessment of adverse, where that is in terms of the significant amount of evidence we had on noise. I'm not clear, but there has to be a threshold somewhere. It can't just be any noise.
Okay. Can you turn up the noise policy statement for England, please? Core document 9.3.
Yes.
PDF page 9.
Oh, sorry. I'm there, Ms. Topple.
The first aim of the noise policy statement for England is to avoid significant adverse impacts on health and quality of life. Yep.
Yes, yes,
The second aim of the noise policy statement for England is to mitigate and minimise adverse impacts on health and quality of life. Yes?
yes, yes.
So even adverse impacts that fall below the threshold of significance should be mitigated and minimised. Yes?
In relation to this noise policy, yes.
Okay, well, you're not asking the inspector to apply something else, are you? I mean, this is the noise policy statement
No,
for
and
England.
and this was subject to quite
Right.
a lot of detailed discussion.
For
in the
sure,
noise
but I haven't
evidence,
explored
yeah.
it with you, and it's a relevant policy. Can I ask you please to look at the, well, actually, can I ask you just to look at Mr. Leach's proof of evidence, which is core document 14.3.1.
Okay, I am there.
Thank you. Page 10. He reproduces here the noise exposure table from the PPG on noise.
Sorry. Oh, sorry. Is this
It's Mr. Leach's
sorry, yeah,
proof.
sorry, page. I thought you meant PDF page. Sorry.
Oh, no, I've
Yeah,
only
yeah,
got it in
yeah.
hard copy. 10.
It's page 14, PDF page 14, I think.
Okay, do you see that he reproduces that noise exposure table from the PPG?
Yes.
And that recognises, so at the bottom, there's a threshold of significant observed adverse effect level. And above that, there's a threshold. Page 10 of Mr. Leach's proof. So significant observed adverse effect level at the bottom. Do you see that? Well, the bottom two categories fall under that heading.
So we're talking about lowest observed adverse effect and significant observed.
Yeah. So there's significant, and that's the bottom two rows. And above that, there's lowest observed adverse effect level, which is described as present and intrusive.
Yes.
Yes. Okay. Mitigate and reduce to a minimum. So that's even where it falls below the significance threshold.
Yes.
Okay. And can I ask you then just to look at the PPG on noise itself?
Sorry, can I just may I just bring your attention to paragraph 4.5 of Mr. Leach's proof, which says where the noise level from proposed developments is between the, I'm going to say LOL and SOL,
Yeah.
hopefully everyone understands.
Yeah.
The NPSE states all reasonable steps should be taken to mitigate and minimise adverse effects on health and quality and life while taking into account the guiding principles of sustainable development. This does not mean that such adverse effects cannot occur.
Yeah, we've just looked at that in the
Yeah.
noise policy statement for England. Can you turn up the PPG, please? Core document 9.5. Core document 9.5, the PPG on noise, PDF page 2.
Yep, I'm there.
How can noise impacts be determined? Do you see that? That subheading at the
Yes,
towards the
I've
bottom.
got.
Thank you.
Sorry, it's just changed page. Okay.
Sorry, have you got that?
I have got it.
Okay, thank you. And it says plan making and decision making need to take account of the acoustic environment and should, and doing so, consider first whether or not a significant adverse effect is occurring or likely. Second, whether or not an adverse effect is occurring or likely to occur. So this guidance makes it clear that it's not just significant noise impacts that the inspector need to concern himself with. He'll also need to consider whether there are adverse effects occurring.
Yeah, but it also says, and it's an and whether or not a good standard of amenity can be achieved.
Yeah. And if we just turn over onto PDF page 3, do you see the subheading, what are observed effect levels?
Yes.
So significant observed effect is where the level of noise exposure above which significant adverse effects on health and quality of life occur.
Mhm.
The lowest, so that's the LOL, I
The
think
LOL,
we're calling
yes.
it, the LOL. That's the level of noise exposure above which adverse effects on health and quality of life can be detected. Yes?
Yes.
So even effects which Mr. Strawn would categorise as insignificant, i.e. below the threshold for significance, are known to result in adverse effects to health and quality of life. Yes?
They can have adverse
Yes.
effects. It doesn't mean they
Yes.
will have adverse effects.
Okay.
And just to say that Mr. Leach's evidence, and that was supported by Mr. Scrivener, suggested that there was no significant effect upon the noise levels to Block A.
Right. Well, we'll come on to that. But this explains that even at lowest observed effect levels, so below Sol, effects on health and quality of life can be detected. Yeah.
It was, but also I believe that Mr. Scrivener also confirmed that in relation to the three major events, that the Sol or LOL categories would not be applicable because of the infrequent nature of those.
Okay, we're just exploring matters of policy and guidance at the moment and what they show. So
I'm just, at some point, we're going to have to recognise the difference between the noise evidence and the policy evidence.
well, this is policy.
Hold on a second. We had this debate in relation to the noise evidence. Sol and LOL then begged the question of what the relevant levels should be for LOL and Sol. And that then introduces what guidance do you apply? And then we had the whole debate about BS 8233.
Well, I'm not having that debate with Mr. Tickle. So I'm sticking to the policy and guidance framework.
Hold on. That's why we asked Mr. Scrivener the questions about the effects of the Nagara, both in relation to LOL and Sol, as measured through BS 8233. We've been through all of this. He agreed there is no even LOL effect from playing the Nagara on the Block A. And for the three events where levels are above LOL, he agreed that no, like firework nights, there isn't any requirement to achieve any particular level. So
that's all understood, Mr. Strom. I think we're just looking into the policy context rather than seeking to get into the detailed noise evidence. So
okay, but so at some point we have the questions have to be relevant to the evidence that's already been given, and the evidence is clear. And this is all about noise policy and levels. They're meaningless without attributing a value.
So if I just come in here, and obviously the position is slightly different in relation to the matters that were accepted by Mr. Duncan, and if it's of any assistance, the questions that Ms. Tafur is putting in relation to policy here, obviously I'm not intending to repeat, and if she doesn't put them, I will have to put them. So frankly, we might as well go through them now, since she's already well underway.
Can I
just one moment? Sorry, did you want to say something at the back? Right. Okay. We'll make sure that the microphones are close to us. Thank you.
Can I ask you, please, to turn up again policy D13, core document 10.1.16, and you may as well have up D14 as well, which is the next one, 10.1.17.
I have D13 and D14.
Thank you. Yeah. And this is the issue I want to explore with you is whether D13 only relates to significant effects. Now, Mr. Leach accepted that it didn't just relate to significant effects, but I want to ask for your view on it, please. Now, a moment ago in Evidence in Chief, you said that the policy itself referred to the MPPF. That's not actually correct, is it?
Apologies. No, it's apologies. No, it doesn't reference the MPPF. However, it does reference obviously agent of change principles, which are themselves replicated in the MPPF. Okay. So I do apologise for that.
That's fine. And policy D14.
Sorry, it does. Apologies. It does say the agent of change principles. It does say the MPPF. It's paragraph 3.13.3, which is the accompanying supporting text.
Yeah, that's not the policy, is it?
But it provides guidance on how the policy is to be interpreted.
Sure, but it can't change the meaning of the policy words.
No. I will remember that with other points.
Okay. D14 then, because you pointed to this when you were talking about whether D13 only related to significant effects. impacts.
Yeah.
D14, A1 talks about avoiding significant adverse noise impacts. And A2 is a separate requirement that development proposal should reflect the agent of change. So dealing here with two separate issues, one, significant adverse impacts, and two, the agent of change. Yes?
I agree, although,
Okay.
as I said in examination in chief, I would find it surprising that a policy related for D13 on agent of change was produced it very differently from the paragraph 187, and also that the significant adverse effects which are referenced in D14 would be different to the test, should we say, in D13. So I accept there is no reference to significance, but I would find that may have been drafting, or there may have been another reason for that. But I cannot understand why there wouldn't be reference to significance, because it's in the NPPF.
What part B of policy D13 talks about is noise and other nuisance generating uses. Yeah?
Yes.
Okay. And there's no fixed level of noise that would cause a statutory nuisance, is there?
Sorry, apologies. I said, could you say that again, Ms.
Yeah,
Toff?
sure.
Apologies. I
There's
just was reading
no
the
there's
policy.
no noise threshold above which a statutory nuisance can be said to occur.
I'm not aware of one. No.
Okay.
No.
And what a statutory nuisance is in noise terms, it's noise emitted from premises so as to be prejudicial to health or a nuisance. That's what the Environmental Protection Act tells us, isn't it?
I don't have the text in front of me, but I will take it as read.
Okay, take my word for it, and that can be checked. So noise emitted from a premises so as to be prejudicial to health or a nuisance. Now, we know from the PPG that noise levels below SOL can have adverse effects on health and quality of life, don't we? Because we've looked at that a moment ago.
They can. They don't
can.
always have to. No.
They can. Okay, so
and they can be mitigated.
Right. Okay. So noise levels below significant can have adverse effects on health and quality of life, and so noise levels below significant can therefore be prejudicial to health.
And can be mitigated.
Yeah. Okay. Well, sure, but as a matter of principle.
I'm sorry. I'm just referencing what the wording of the LOL said. So,
right.
Yeah.
Okay. Well, query whether they have been mitigated, but the point of principle is that noise levels below significant can be prejudicial to health. Are we agreed on that?
In terms of the wording, yes. Yeah.
Okay. So that means D13 must be concerned with impacts, even if they don't reach the significance threshold, because such impacts are capable of being prejudicial to health and so causing a nuisance. That must be right.
Could you repeat the question again? Apologies, I was just looking at the policy again.
D13 must be concerned with impacts, even if they don't reach the threshold of significance, because such impacts are capable of being prejudicial to health and so constituting a nuisance.
Were the assessment as considered them to be so, then yes, they could be, but they could also be, as I have said before, that effect could be mitigated.
No, I understand that, Mr. Tickle, but what we're trying to do here is we're trying to understand what the policy is directed towards. And it talks about nuisance generating noise. Nuisance, or that means noise that's prejudicial to health. And we're agreed, I think, having looked at the PPG, that noise can be prejudicial to health even if it doesn't reach the significant threshold. So far, so good?
At a point, yes.
Yes.
But to reiterate the point, not all noise between SOL and LOL would be an adverse effect.
No,
and in line with paragraph C of D13, it says new noise and other noise nuisance generating development proposed close to residential or other noise sensitive uses should put in place measures to mitigate and manage any noise impacts for neighbouring residents and businesses. So therefore, the mitigation and management of that noise is a part of the way of addressing where there may be an adverse effect.
What we're trying to understand here is the scope of policy D13. And I think you said in your evidence in chief that policy D13 only relates to noise that passes the threshold of significance. But I think we're now agreed that that can't be right because it's concerned with impacts that are prejudicial to health, which can arise at a level below significant. Is that a fair summary of the position
I
we've
think
reached?
that, yes, I accept that. I accept,
Okay.
yeah. Subject to all the clarifications, but I'm not going to go through that.
In your evidence, you don't offer any view on what might be an unreasonable restriction on the Gurdwara, and I'd just like to explore that with you, if I may. The Nagara is agreed to be capable of producing certain sound power levels, and it's agreed that the level will depend varying on the style and vigour effort of the player. That's in the noise addendum statement of common ground.
The agreement between Mr. Scrivener and Mr. Leach is at 106 dB.
Well, let's turn up the noise statement of common ground, core document 8.13. I think it's 8.13. Let me know when you're there.
Is this the one that's dated 7th of August?
Yes.
This is prior to the evidence given by Mr. Scrivener at the inquiry.
Yeah, I don't understand either Mr. Scrivener or, well, I certainly don't understand Mr. Leach to have reneged on his agreement in this statement of common ground. So paragraph 2.14.
Yes, the sound power level of the Gurdwara and Nagara drum is between 106 dB, which is Mr. Leach's assessment, and at the time 115 dB, which was Mr. Scrivener's assessment. However, I understood that Mr. Scrivener, in cross-examination, accepted the 106 dB.
Well, I think it was what the evidence was, what the best evidence was the matter that was explored with Mr. Scrivener, and on the particular occasions that it was measured. But I certainly don't understand. In fact, I think it was put to him in cross-examination to Mr. Leach that it is capable, the Nagara is capable of producing a sound power level between those two figures. And para 2.15, this was also put to him and agreed. The level depends on the playing style, effort of the drummer and duration. Okay, we can deal with that in closing submissions if there's any dispute on that. But can I just explore with you, please? The noise from the Nagara isn't controlled through a sound system, is it?
No, it's a natural sound. Yeah.
And it was suggested by Mr. Strawn in some of his cross-examination that it wouldn't be unreasonable to restrict the noise to a sound power level of 106 dB. But can I just ask, it's right to say that there's no obvious means by which a drummer would be able to know the level he was playing at or to ensure that he didn't exceed 106 dB, is there?
You could install a sound the words are completely gone on.
Sound monitoring equipment?
Sound monitoring equipment, thank you. Which are present in clubs and other places for noise levels. But I think that would be inappropriate. I think the assessment carried out by Mr. Leach was that 106 dB was a robust assessment of the maximum level of the Nagara based on the assessment that he had undertaken. However, I'm straying massively into noise evidence, and I can't really sort of.
That's fine.
Yeah.
As to what he said, I can deal with that. What I'm trying to explore with you is what would and wouldn't be an unreasonable restriction. Okay.
Yeah.
So can we agree that it wouldn't be reasonable to expect the Gurdwara to install noise monitoring equipment to ensure that a player kept below 106 dB? I think you've just said you accepted that would be inappropriate.
I think it would be inappropriate given the existing. I do note that there was in the original planning permission, which is my ST. Apologies. my ST12 in rebuttal. Sorry, apologies. Which is my exhibit to my rebuttal, that there were actually suggested restrictions on the playing of music
Yeah,
in the phase 2, which is where the courtyard is.
right, inside.
No, it doesn't say that. It doesn't say phase. It doesn't say inside. It says
Right,
within
it says
within
in the premises, within the premises, and it was an application for a building, was it not?
and a courtyard, yes, and parking.
Right, so
within that courtyard, I would
okay,
I
well,
would consider premises not to mean inside a building. I would
all right.
say.
Well, let's leave that side. You've accepted it wouldn't be appropriate, so let's
But
leave it
there
at
are
that.
no, sorry, but there is in that permission, they applied a restriction on the hours of operation of the playing of music.
Right. Okay. Okay.
And
So
it also says no amplified or other music shall be played in the premises outside of the following hours. So there was a condition applied by the council in relation to a consideration of noise.
okay.
And a permission which goes back to 2001, I think.
Okay, well, we're dealing with the position as it currently stands.
Yes.
And if there's been operations in breach of that permission, that condition since 2001, let's deal with the actual scenario.
But it's not an unreasonable condition then.
Right. Oh, okay, so sorry, let me just be clear. You say it would be reasonable to restrict the times at which the Nagara were played at the Gurdwara. Is that your position?
No, what I'm
Right,
saying is
okay.
the council applied a condition.
Mr. Stickle, I understand what you're saying about what the council did in 2001. I am exploring with you what would be an unreasonable or reasonable restriction on the Gurdwara now. So let's stick with that, please. And bearing in mind the time, let's stick with that.
Conditions are applicable. Sorry, apologies, Ms. Toffel. Conditions continue to be applicable. They don't fall away.
Wait,
and therefore, if it was a reasonable condition in 2000, why is it an unreasonable condition in 2023?
I'm sorry, Mr. Tickle. You are aware that if there's operations in breach of a condition, they do acquire immunity?
There's no evidence that it's been in breach.
Well, yes, there is.
What's the breach?
Well, there's evidence that the courtyard area has been used for the playing of music and the operation of and the carrying out of
Oh, is that what-
ceremonies.
I thought you were talking
for
about
more
the
than
sound
20 years.
levels of 106 dB. Can
No.
I just remind you, Mr. Ferb, your witness agreed sound power. This is why we're going over. This is turning into a sort of re-examination of witness through cross-examination of Stickle. He agreed a sound power level was the right sound power level to use based on the evidence, and secondly, it would be unreasonable to play it at a louder level because it would be prejudicial to the health of the player, the children, and the congregation. And therefore, if it were to be played louder on a regular basis, it would be entirely reasonable to restrict it. And not only that, a good thing. And I know
Thank
that.
you, Mr.
And I
Strong.
know that
Thank you.
because I read the cross-examination notes last night to write my closing submissions. So why are we having this debate?
Because Mr. Tickle is discussing with me what would be a reasonable or unreasonable restriction, and he has just said that it would not be appropriate, in his view, to expect the Gurdwara to install noise monitoring equipment to ensure they did not exceed a sound power level of 106. That would not, in his opinion, be appropriate. So let's think about what an environmental health team would be likely to do, if not that, if not expect them to monitor the sound power level.
And so just again, and if this point isn't dealt with Ms. Tafur, it's going to have to be dealt with me anyway.
Okay, well, as long as we're not seeking to undo answers that we've had from a noise witness already, which is, I don't think, what you're trying to do, then let's just carry on, please.
Thank you, sir. So, given the difficulties with actually monitoring the noise and ensuring that a sound power level would be kept at 106 or below, it's right that any reasonable environmental health team would take account of those difficulties. And if they were to serve an abatement notice, they're unlikely to impose a restriction of 106 dB, given the difficulties that the Gurdwara would face in complying with any such restrictions. Is that fair?
I think that is correct. Yes, I think it would be difficult to enforce.
It would be,
that
and
in terms of a condition. But
thank you. And can I just, on that non-compliance with an abatement notice would expose the Gurdwara to criminal sanctions, wouldn't it? And that's something that the environmental health team would take into account in deciding on what restrictions to impose.
My understanding is that given the levels of the Nagara that Mr. Leach has identified and which your witness agreed, in my view, there would be no need and be no reason for enforcement to take place.
All right. Well, let's just explore in the scenario where there were complaints and an environmental health team were considering an abatement notice. So I've got your point on establishing a sound power level. Do you think it's fair to say that rather than doing that, if there were a statutory nuisance, the environmental health team would be more likely to respond with restrictions on the number of events that could involve the Nagara, the time of the events, duration and location of those events?
It's theoretically possible, but I don't believe there would be any need for those restrictions.
I understand that. And contrary to what my learned friend has accused me of, I don't want to go back over the noise evidence. I just want to understand what would be a likely response in the event that an abatement notice were served, which I understand you say you don't think is likely.
Yes.
Okay.
Can I just say, if you know the answer to these questions and you're qualified to answer them, then by all means do. But can we remember also that this isn't an environmental health officer that we're dealing with?
No, I do understand, sir, but unreasonable restrictions and what they're likely to be is what I'm
we're
trying to
talking about
explore.
noise abatement notices, but
Well, yeah, I mean that's what results from a nuisance, a noise abatement notice where there's a statutory nuisance. So we're looking at the type of restrictions that might be imposed and whether they would be reasonable or otherwise. Okay.
Yes.
Can we agree that it wouldn't be reasonable to expect the Gurdwara to limit the number of times they played the Nagara or the location or duration to less than that which they currently operate? That wouldn't be reasonable.
I think the community use agreement between the development and the Gurdwara, which is part of the 106, would be looking at the discussions between residents and the Gurdwara. If there were any concerns, firstly, those could be addressed. As I've identified, there would be clear information with any moving impact of what the noise from the Gurdwara is, the likely events, the timings of those events, when they would happen.
Mr. Tickle, can I just be clear? Is it your view that it would be reasonable to expect the Gurdwara to limit the number of times it used the Nagara, the duration, the frequency?
In what? Sorry, these questions. What is the proposition being put? What is the breach that's being identified? When in circumstances where I've already agreed with Mr. Scrivener, no one could reasonably complain about the playing of the Gatka, the Nagara of the Gatka from Block A. I asked him this in terms. Could someone reasonably make a complaint? Answer, no. What is the circumstance being put as to when this complaint is made and an abatement notice being served?
So I'll make my submissions on the noise evidence in my closing submissions. The questions I'm seeking to discuss with Mr. Tickle are just about unreasonable restrictions, because there's a policy requirement which relates to that. I want to understand his view of what would be a reasonable and or unreasonable restriction.
No, you have to identify a noise event that's resulting in the unreasonable restriction. And that's why I'm asking, what is the scenario, bearing in mind what I've agreed with Mr. Scrivener?
Yeah, on the basis of BS 8233. He never conceded that 4142 should not be applied.
No, that's not right.
So what scenario are we discussing? Putting aside whatever the noise levels might be, simply that there might be a complaint from somebody.
I am discussing the circumstance in which there are complaints and an abatement notice is served because there's noise that at a level prejudicial to health.
Mr. Strawn,
Come on.
it's
Come
going it's
on.
going to be a very long evening if we're going to continue in this way. Let's just allow Mr. Furr, please, to continue with her questions, and it may not make sense to you, but that's not necessarily what needs.
Yeah.
It doesn't necessarily need to at this point.
And I can only repeat that I am going to be taking a point about significant levels arising, because we obviously do have a different sound pressure at the sound power level. And so again, if these points aren't put by Ms. Taffer, I will have to put them anyway. So we might as well just go through them.
Can I just, Mr. Tickle, leaving aside the community use agreement, can I just ask for your view? Would it be, so we know currently there's GATCA every month. There are the ceremonial events 3 times a year.
Yes.
Would it, in your view, be reasonable to expect the Gurdwara to restrict those activities in terms of how often they were carried out, how long they took, or the location at which they took place within the Gurdwara estate? Would that be a reasonable or unreasonable restriction?
I think it would, in terms of the GATCA, there is no, as we've.
I'm not asking about what the actual noise impacts are. I'm just asking, do you think it would be reasonable for the Gurdwara to be expected to curtail its current activities?
No, I don't.
No, thank you very much. Okay, now, reason for refusal 2, I'm going to leave the impacts on the Gurdwara to Ms. Clutton to deal with to avoid repetition. There's some, okay, on
Can
the
I just
interest.
give me 2 seconds? I need to close about 300 documents.
Yes, of course. Go ahead.
So would you be referencing SC5, SC4?
Possibly. I can't actually recall.
I'm just
Have to wait and see
I'm
when we
closing
get
things
there.
at the moment. I'm going a bit figure happy at the moment. I'm fine now.
Okay, thank you. I'm just looking through things I can skip over in the interests of time. Suburban versus urban. I think you and Mr. Ringer both agree that the housing SPG distances shouldn't be applied rigidly. Can we agree that defining the setting of the character of an area involves elements of professional judgment, as explained in the housing SPG?
It's clearly, whilst the housing SPG sets benchmarks, then each determining authority would have obviously placed professional judgment on that. Yes.
Thank you very much. The inspector is going to carry out his own site visit. I'm going to leave it to him to form a judgment, having regard to the evidence both of you and Mr. Ringer.
Thank you.
In terms of the precedents you produce at ST2 as to separation distances.
Do you want me to go to those?
Yes.
Okay, I'm there.
Thank you. Albany House first. The minimum separation distance, I think, in that case was 13.7 metres. Is that right?
Yes, I think it is. Yeah, it is.
Okay. And that was between blocks in the new development rather than distances between existing buildings and the new development?
It is window to window distances within the development. As I explained in examination in chief, there is no differentiation in policy S4. It just says habitable window to window distance.
Okay, come back to that. And is it right to say in that case that there, where there was that pinch point of 13.7 metres, that was a window facing a wall with no windows?
I mean, the 13.7 is taken to a wall with that window, but if you moved the arrow a little bit to the north, you'd come to a balcony with a big window.
Okay.
So it would be 13, probably 14 metres.
14 metres, okay. And can I ask you to turn up the officer's report that dealt with this Albany House Police, which I think you have at Appendix ST10?
Oh, No, I think I've got, that's ST11, I think.
Okay, let me just get
ST12,
ST11.
ST10 is Mandeville House,
Okay,
I think.
thank you.
I
I'm
hope it's
sure you're
right.
right.
Oh,
Yeah,
am I
okay,
right?
so you're right. ST11, thank
Manderson
you.
House, sorry. It's, yes, but
ST11.
ST11, yeah.
Thank you. So can you see, can you turn to PDF page 66?
Just bear with me a second.
Do you know what paragraph number it is? Because I've got a hard copy.
Sure,
of this
it's 8.271.
one. Thank you.
Sorry, I should have used the search function. Yes, I'm there. It's the bottom of that page. Yes.
Bottom of that page, do you see there's a subheading impact on neighbours?
Yes.
Yep. Okay. And then when we look at Outlook and privacy, paragraph 8.270 refers to the housing SPG distances,
Yes.
but says recognises they shouldn't be applied rigidly.
Yes.
8.271 explains that the closest residential neighbours are Albany Road and Market Terrace. Do you see that in the first sentence?
Yes.
And the second sentence explains that the frontage has been set back from the site boundary to create a minimum distance of 18 metres between Market Terrace and Albany Road
Yes.
to meet the recommended separation between habitable windows. So closest distance to existing neighbours, 18 metres. Yes?
To existing neighbours.
Yes, to
Yes.
existing neighbours. Okay.
As I explained to Miss,
I've heard what you said
yeah.
a moment ago. I'm going to
Yeah.
explore that with you now. The difference with neighbouring, with existing properties and new development is that residents moving into a new development won't have an existing level of privacy to be protected, will they?
There would have been an existing level of privacy for an existing resident. However, that's not referenced in the policy.
Right.
The policy is habitable window to habitable window. It doesn't differentiate between existing and proposed.
Okay. And residents moving into a new development will be aware of the internal relationship and be able to weigh up how they feel about that?
As we explained in examination in chief, that's not always the case where residents are coming in to perhaps social rented.
Right. Well, I understand that your scheme has placed most of the social rented schemes in blocks C and D, but we don't know anything.
D, it's in D.
Mostly in block D,
Yeah.
but we don't know anything about the circumstance of this case and whether they've placed the affordable units in those pinch points, do we?
No, but nor
Right.
does it say, nor does it go
No.
into that detail in
It doesn't.
in this.
Yeah.
committee
And
report.
existing residents who have a level of privacy already existent that is worthy of appropriate protection, they would simply be having these distances imposed on them, wouldn't they? They'd have no choice about whether they could accept them.
Yes.
Okay.
For want of a better word, yes.
And it's right to note that this officer's report deals separately with internal separation distances between the development and separation distances to existing neighbours.
I believe it does, yes.
Okay. And just on that point, it's right to say in every one of the examples that you cite, the distances relate to distances within the development.
They do, yes.
Okay.
Yes.
And in every example that you cite, officers dealt separately with distances to existing neighbours.
That's because the format of the report deals
Right.
with existing relationships and proposed relationships.
So the answer is yes.
Yes.
Okay. And in every single one of the examples you cite, the officers referred to the 18 to 21 metres as a useful yardstick in considering separation distances.
They did, yes.
And in every single example you cite, distances between the development and existing residents were 18 metres or above.
Because of the nature of those particular developments, yes.
Right.
Yeah.
Okay. Yes. Okay.
I mean, again, you would have to look at the it would be a very significant exercise to assess the design approach that had been taken on each particular site, the sensitivities, and the proximity to residential properties. It's like other issues mentioned earlier, it's not a one size fits all.
No, I understand, but you've
Yeah.
drawn these to the inspector's attention because you say they're relevant examples, and yet you don't draw to his attention that in every single one of these examples, distances between the development and existing neighbours were 18 metres or above. But that is a relevant
I did
factor,
bring
isn't
it
it?
to its attention. It's
Where?
it's in both of the committee reports, which I append as proof.
Okay, where is it in the Manson Road Committee report? I think you've included a previous committee report for Manson Road that doesn't include that. And there's nowhere in your evidence that you draw that to his attention.
Sorry, can we go to Manson?
Yeah.
Yeah.
ST10.
This is the. Can I just point out that this is there was an issue with ST10, which I.
All right. Well, the version in the core documents, even in the latest core document link,
Yeah.
does not include the points about separation distances. Let's not have that as a diversion. The point is, even in the high street example, which was a town centre location, so central rather than urban under the Mayor's Housing SPG, the distance to existing properties was addressed separately and was in excess of 20 metres. Is that right?
I believe so. Yes.
Yeah. Okay.
But I go back to the point.
Thank
There is
you.
no in policy, which you were very specific on earlier on noise. In policy terms, there is no differentiation
Understood.
between habitable windows to existing and habitable windows to proposed.
Context. Blocks C and D are in the northern part of the appeal site. Can we agree that the context around that part of the site is relevant when considering separation distances?
Yes, context is important in
Okay.
terms of, but also the again overarching objectives of delivering sustainable development.
Yeah. London Plan Policy D3 requires developments to respond to their context.
Yes.
And Local Plan Policy CC2 requires developments to respond meaningfully and sensitively to the site and to the grain and layout of surrounding buildings.
Sorry, can you give me the reference to
Yeah,
that?
it's
please,
core
sir?
document 11.1.8.
Which part of
CC2 Part K. So core document 11.1.8.
Yes. Yeah.
CC2 Part K
Yes.
requires developments to respond meaningfully and sensitively to their site and to the grain and layout of surrounding buildings.
That's correct. Yes.
The Housing Design Standards LPG, please. That's core document 10.2.15.
Yes, I'm there.
Thank you. Standard A.1.1, which is on PDF page 8, hard copy page 5. Design proposals should respond to the characteristics of a site by demonstrating how they respond to character and legibility and local patterns of buildings.
Yes, correct.
Thank you. Can we agree that the part of the relevant context for blocks C and D includes Perkin Close?
That is part of the existing urban context,
Thank you.
including Thompson Road properties, the Gurdwara, and properties down to the south of the site as well. Yes.
Okay.
Yeah.
But can we agree that the development to the north is the most relevant context for the northern part of the appeal site?
It is, yes.
Yeah. Okay. Could we just have a look then, please, at the plan at core document 16.8?
So 16.8, did you say?
Yes,
sorry.
these are the agreed separation distances.
I'm there, yep.
So at Perkin Close itself, which immediately abuts the northern part of the appeal site, we see that the distances between the facades of buildings are between 18.5 and 27.4 metres.
Yes, they are.
Yeah.
Yeah.
Okay.
It's the nature of that particular typology, but yes, I
Okay.
accept that, yeah.
Relevant aspect of the existing context for the appeal scheme to respect and respond to? Would you agree?
It's a relevant aspect to be taken into consideration. There are clearly a much wider context of typologies in the area. You wouldn't take the immediate context, and also the housing SPG 2016 suggests that you need to look at emerging context as well as proposed context.
Okay. My question was, is it a relevant aspect of the existing context for the appeal scheme to respect and respond to? Do you
Yes,
agree?
it is. It
Yes.
is. It is part of the existing context. We should
Thank
take into
you.
account. Yes.
Thank you. And prevailing separation distances are part of the context that should be appropriately responded to.
They are. Clearly, there's a lot of separation distances there, which I'm sure the inspector will visit, possibly unaccompanied.
Yeah.
But I'm not going to go into any. I don't think it's worth us going into any detail on
Okay.
those.
Can
There are clearly areas where there are much smaller separation distances, like areas where clearly much larger separation
Okay.
distances. It's a very wide variety of context.
The distances here measured are between building facade to building facade, aren't they, rather than habitable window to habitable window? They're not quite as nuanced as window
They're
to
just
window.
taken off the ordnance survey, so no idea of window position
Yeah.
would be.
So they're facade to facade.
Yeah.
And the smallest separation distance facade to facade is, I think, it's either 9.1 or 9.3. That's Cross Lances Road. Do you see that
Yes,
on
it
the
is,
other
yeah,
side?
yeah.
Okay. We don't, unless you're able to assist with when those properties were built, I don't have any information on that. Do you, Mr. Tickle?
From memory, they appear to be early 20th century buildings, I would
Right.
guess.
Okay. And there's a public thoroughfare separating those properties, a road?
Cross Lancers Road, yes.
Yeah. Okay. Do you agree that where there's already a road between buildings, that there are different considerations in terms of separation distances because privacy is already affected to a degree because the public have access?
I think that's true of the ground floor. I'm not sure that's necessarily true of upper floors because there would still be the expectation of privacy across that space.
Okay. The amenity space at Perkin Close, please. Can we agree that there are amenity spaces both to...
Can I just close that plan? Have you finished?
Yeah.
Yeah, thank you.
Amenity spaces to the south of Block C and to the east, and that all of that communal space is available and appropriate for use by those residents?
Sorry, when you say Block C,
Sorry,
did you mean
sorry,
north?
my mistake. I don't mean Block C at all. I mean
19,
12 to 28. I've forgotten
13
the-
to 28.
13 to 28, Perkin Close.
Yeah. There is the area to the south. I mean, this is something that we will certainly visit in terms of the site visit. The part of that area to the south of 13 to 28 is effectively what we call surplus land associated with the car park. There's a bit of green space there. It's not really usable as amenity space. There is then a fence line which I think is possibly visible on the ST15 plan, and then there is an area of amenity between the fence and 13 to 28, albeit that the principal amenity space for 13 to 28 is to the east of that building.
Okay, I'll ask the inspector to have a look at that on site and the extent to which
site visit to be,
and the extent to which the southern area is usable.
Yeah.
Those communal areas, can we agree that they're meant to be semi-private spaces?
They are semi-private. They're not private.
No, I didn't know.
Yeah, no.
Okay.
I'm agreeing with it. They are
Okay.
semi-private in terms of only the residents of that block would have access to those spaces.
Okay. And a degree of overlooking from within a development, I think we agree, is good to promote natural surveillance, engender a sense of ownership, and make areas feel safe. Yeah?
Yes,
Okay.
you can have good overlooking and you can have
Okay.
bad overlooking.
Can we agree that privacy in external spaces is also an important consideration?
Yes, it's important to provide external amenity spaces, and I'm sure we'll come on to that in reason for refusal.
No, I said privacy in external spaces is also an important consideration.
There are secured by design principles actually, which would counter that. I think actually in the I think it's one of the LPGs actually references that one of the, I mean, it's also the shared amenity space that Mr. Ringer included on his document, highlighted that overlooking to amenity spaces is actually a good thing. It's not always a privacy thing. It's actually important for security and for just well-being.
Can you turn up the National Design Guide core document 9.11?
Okay, I'm there.
Bear with me while I get there. Sorry, let me just get the right reference. Okay, paragraph 129, which is on page 39.
Yep.
Okay.
That is the one with that one that starts H2, well related.
That's right.
To external amenity in public spaces. Yeah.
Yeah. So the third sentence there says, the second sentence, all private and shared external spaces should be high quality, etc. Amenity spaces have a reasonable degree of privacy. Do you see that?
Yes, I do.
Okay, so recognizing that privacy of amenity spaces, even shared external spaces, is a factor worthy of consideration.
I do, yes.
Okay, and then para 131 on the next page.
Yes.
This talks about, I think this is a point you were making, and we can see in the final sentence, shared amenity spaces, they're well overlooked and all of the residents who share them can access them easily. Yeah?
Yes, I think that's the point. That was actually the paragraph I think I was
that's the one
reaching
you're
for
of.
earlier. Yeah.
Okay, so can we agree that there's the need for community spaces to be well overlooked is not incompatible with the need for them to have a reasonable degree of privacy?
I think I said before that there's good overlooking and bad overlooking.
Good overlooking and bad overlooking. Yeah. Okay. And can I just on that point just ask you to look at CD 10.2.15, which is the Housing Design Standards SPG.
10.2.15.
Yeah.
What page?
It is, let me give you the paragraph number, 3.1.6, I think.
This page.
It is
12.
Page 12. Yeah, so 3.1.6, the second sentence, it explains that while overlooking provides useful security, it can also feel intrusive to those seeking a calm retreat. Okay, so can we agree that bearing in mind there's no incompatibility with the need for a reasonable degree of overlooking on the one hand and the needs for a reasonable degree of privacy on the other, that one way to strike an appropriate balance would be to ensure that amenity spaces are overlooked by the community they serve and who have an invested interest in them, to promote a sense of ownership, but also protected from intrusive overlooking by others. That would be a way to square those two considerations, isn't it? Wouldn't it?
I'm not sure it specifically says that the communities that use them
If you're looking for a specific bit that says it should be overlooked by the development but not overlooked by neighbouring developments, I'm not suggesting there is such a thing.
Yeah,
what I'm saying is,
I actually went back to the National Design Guide just to see if it could provide some more clarity. It doesn't really.
no,
I think it's the degree of overlooking, the number of the amount of that overlooking, and whether people would feel uncomfortable because of the extent of being overlooked from another development.
Understood.
Yeah.
Do you have any sympathy with the residents of Perkin Close who have raised some concerns about the impacts of the development on their privacy and perception of privacy?
I always have respect for the neighbours when we're doing developments, because their comments are important to us, and that's why we seek to, in all designs that we're involved with and working with architects and other urban consultants, seek to minimise as much as possible the impact to residents. And this is one example where that minimisation of impact has been very successful in terms of overlooking. We have a very small number of bedroom windows which serve a dual aspect flat, which are principally overlooking, for the in purpose of 13 to 28, a car park, and therefore they are not affecting the sense of amenity and shared amenity space that 13 to 28 enjoys in that particular part of the development. There is an oblique.
Yeah, I know what the actual.
reference.
I know what the actual arrangement is.
Yeah.
I understand that.
Are we talking in terms of 29 to 44? There is a similar one, but there's even fewer windows there.
Yeah. Okay. There's a dispute as to the actual impacts and their acceptability. I think, Mr. Tickle, is it fair to say, rather than going through the relevant policies, is it fair to say that the position the inspector comes to on conflict or compliance with those policies will largely depend on where he falls on the acceptability of what's proposed?
I agree. I think that the design, but I think you have to take into consideration that design process has sought to minimise to a very significant degree the impact in terms of overlooking, to an extent that we have quite a large facade.
Mr. Tickle, I am so sorry to cut you short. I understand what your position is.
Okay.
And I rather than going to all the relevant policies that with Mr. Ringer says there's conflict, you say there's compliance, I think that comes down to where the inspector falls on the extent to which local context has been respected, the extent to which the distances are acceptable. Would you agree that that's fair?
Yeah, I think that will be down to the inspector's
judgment on the actual
judgment,
substantive.
and subject to a consideration that was raised, I think, in cross-examination with Mr. Ringer, that there may be further mitigation that the inspector may consider, albeit whether we don't feel it's necessary.
Can I ask you just to help me, please, with paragraph 4.6.38 of your proof, which is on page 44?
4.6.38. Yes, I'm there.
Page 44.
Yep.
Final sentence. You're talking about daylight and sunlight here.
Mm-hmm.
And you say, I don't consider there to be any adverse effect, daylight and sunlight effect, that is, that weighs against the proposal. And you consider it's appropriate in this context. But it's the first part I'm just trying to understand. Can you help me? Do you mean that there are no adverse daylight and sunlight impacts at all on Perkin Close? Or do you mean there are some, but they shouldn't be weighed against the proposal?
I think that was the evidence that Mr. Kidd gave as well, that there is identified to be some effects, some significance in terms of the impact or effect on the windows to Perkin Close, particularly.
I understand what his evidence was,
Yeah,
but I'm
but
just,
I think
what,
you
I
need
just
to-
want to know
you
what
need
you
to-
mean here. That's really what I'm just trying to explore. No adverse impacts, or there are some, but they don't need to be weighed. If you could just help with that.
Mr. Kidd identified in his proof, and it's part of the statement of common ground on daylight, that there are adverse effects in relation to the measurement that is undertaken through daylight in terms of losses. However, those windows, in respect of 13 to 28, those effects are to secondary windows, which, including non-habitable rooms and kitchens, for which there is no test required, and the secondary windows to the living room, which already enjoy incredibly good light from the east and the west. So in that sense, the 13 to 28, I don't consider that there is any significant adverse effects.
So my question was, do you mean here there are any adverse effect that weighs against the proposal? So it's either there's no adverse impact, or there is, but it shouldn't weigh against the proposal. That's all I'm trying to understand. Which of those you mean?
In terms of dirt sunlight and how it is measured, there is an adverse effect. It is set out in Mr.
Understood.
What Mr. Kidd has said,
I'm asking what you say there.
you need to assess the purpose, what the window is where that effect is happening, and will it have an impact on the person living in that property? And the answer is very categorically no.
Okay, so back to your own evidence. You were adverse impact, but you don't think they should be weighed in planning balance. Well, it's not set out, but you don't think they should be weighed in planning balance. This is the only place that's the only place where I've raised it. Okay, understood. There are adverse impacts that should be weighed in planning balance. Your position. Okay, amenity and play space. I'm not going to take any. Quantum of amenity space. I'm not going to say any time at all, and whether it's 902 or 915 square meters of provision. In either case, there's a shortfall either of 806 square meters of communal amenity space or 493 square meters in your case, and that. Right, well, I'm dealing with your figures, and I just want to understand the difference between 806 and 793. I think Ms. 93, I think Mr. Ring includes an underprovision of either 46% and councils, in your case of 47%, against the policy requirements. Okay, can I just deal with this point that you raised about the double counting, where you say, well, you've only just become aware of this when Mr. Ringer gave his evidence yesterday. Can you just take out your proof of evidence, please? And turn to, let me just get it up electronically. Paragraph 7.4.7.20, I think. That's page 51. That's page 51.
Yeah.
So you say you're discussing communal external space. You say, as you note in your reference below, the council has recently accepted a number of projects that the area of communal amenity space can include play space. So you've included those. You see that? Yeah. Of your proof, page 51.
Yes, I do.
Sure. So you say you're aware of a number of cases where the council has counted communal amenity spaces to include play space.
That's correct.
And I think then at 4.745. Page 57. You refer to a number of recent precedents where you say the council was that a financial confirmation should be made based on a shortfall of 793 square metres.
Yes, that's the requirement. Less private amenity space is 1708.
Yeah.
With our 915, and this is without the play space, there is a shortfall of 793 square metres.
Okay. And you considered that was appropriate quantum of the shortfall, and that a contribution reflecting that shortfall should be secured in a 106 agreement.
That was both my view and it is my view. It's also the officer who wrote the planning committee.
Okay. And you accept that that contribution would be still compliant?
There is a still compliance, which I think we've agreed between the parties. Yeah.
Agreed. Okay.
Well, no, we didn't agree it. Actually, the council just issued it. But
Okay,
yes.
well, that's why I'm asking you. Do you accept that contribution to be still compliant?
Yes, it's set out in the
Yeah,
councils.
understood. Yeah, yes.
And
yes.
it also reflects the contribution that's been made on a number of other schemes as well.
Okay. And the contribution towards the shortfall in play space, that is based on a shortfall of what figure?
3/8. It's based on a shortfall of 107, although there is
Okay.
some debate with Mr. Ringer. I think he's-
Sure, that's okay. It's a few meters.
we can say, yeah,
Okay.
between friends. Yeah.
Okay. And the contribution then is reflective of a shortfall of 107 square meters. Is that right?
That's correct. Yes.
Okay. And do you accept that is still compliant?
I believe so. Yes.
Okay,
Yeah,
thank
yeah.
you.
In line with other schemes which the council has approved, with a similar place-based contribution.
Okay. The offsite contribution, could you turn up, please, core document 10.2.3?
Which document?
Yeah, that is the play SPG.
Okay.
And could you please turn within that to PDF page 72, it's paragraph 4.38.
Yes.
Okay. Sorry, it's core document 10.2.3, paragraph 4.38 on PDF page 72. So this is talking about where provision for play space should be located, and it explains that the mayor will expect provision to be made on site in new development and regeneration schemes wherever possible.
Yes, wherever possible. Yeah.
Yeah, wherever possible.
Subject to other design considerations. Yeah.
Sure.
In line with what the other examples have demonstrated.
And paragraph 4.40 makes it clear that it's about kind of part way down. Improvements to existing, it's about the third or fourth line of that paragraph. Improvements to existing play facilities or appropriate financial contributions secured by legal agreement may be acceptable where it can be demonstrated that there are planning constraints and that it fully satisfies the need. Okay, so can we agree that the preference is for on-site provision of play, and it's only where there are planning constraints that mean it's not practicable to deliver on-site that one should look to off-site contributions?
That is the hierarchy that's set out in the SPG.
Okay.
I have to say, from personal experience, it is extremely common that off-site provision is provided, particularly for 12 plus.
Okay, and that same paragraph, I think it is 4.40, sorry, explains that distance is a key barrier to children's play.
Yes, it does. Yeah.
Okay.
Yeah.
Fine. And when looking at off-site provision, one should use actual walking distances, and one should take account of barriers to movement.
That's correct. Yes.
Okay. And the SPG identifies what it considers to be appropriate distances to such facilities on PDF page 61.
It sets benchmarks.
Benchmarks, yeah. So what it considers to be appropriate benchmarks for the different age groups.
That is it sets out London. So which page was 68, 61?
It's PDF 61.
Yeah.
Yeah, so these are thresholds that will have been informed by what the mayor considers to be appropriate walking distances for children.
Yes, but I'll come on to another point in that in a moment.
Okay. Fine. Can I just, in considering, so distance is one thing, but we see at paragraph 4.10 of this document, so just above that table we
Yes.
were looking at, barriers to movement should also be considered, like traffic, roads with speeds in excess of 20 miles an hour. Hanworth Road is a heavily trafficked road. I think you described it in evidence in chief as incredibly busy. Do you stand by that description?
Yes, it is very busy, and it's
Okay.
an arterial route. Yes.
Okay, and that's relevant in considering the appropriate distance and routes towards Inwood Park, where your contribution is proposed.
If there was unsafe ability to cross that route, and there was difficulty in relation to walking that road, yes, there would be some concerns possibly about the use of that road, but there isn't, because it's got safe crossings.
Okay, well, we'll leave that to the inspector to determine. In terms of amenity space for adults, can we agree that that should also be conveniently located for residents of the development?
There's no standard set out in the London plan for that. There is standards for the distances to parks, which I can come on to.
Yeah, I'm just asking, do you
but there
agree it
isn't-
should be conveniently located? That was the question.
Conveniently located is a very wide ranging. Like what we should be looking at, of course, is the open space strategy which the council has produced, which sets out what it considers to be appropriate distances.
I'm happy to look at that, but I would just like your view on whether it would be appropriate for green and open spaces to be conveniently located for the residents of the development.
That is the findings of the open space strategy, so I would agree with that, yes.
Okay, and that's what policy D3 of the London plan says, doesn't it, part 8?
It does, yes.
Right, okay. And Mr. Ringer's rebuttal proof, please, core document 14.18.
Just bear with me a second. I'm just I'm there now. Yeah.
Okay. It's PDF page 9 at paragraph 2.26.
2.26. Yes, I'm there.
Yeah,
Yes.
he sets out a table from it's table 8.1 from the London plan, which is incorporated into policy G4. But we're going here because we don't actually have G4, I think, amongst the core documents. So we'll just look at it here.
Well, apologies for that. We should have had that.
Yeah, that's okay. I think you confirmed in your evidence in chief that Inwood Park was a local park.
Inwood Park is a local park for the purposes of the London plan. Yes.
Okay, and so what this table suggests is that local parks should be within a distance of 400 metres to the homes they're intended to serve.
It does. It also notes that District Park should be within 1.2 kilometres,
Yeah.
and Metropolitan Park should be within 3.2 kilometres.
Yeah.
Hounslow Heath is both a metropolitan park and a district park, which is set out in the open space strategy at the back of the document. And that, on that basis, we're within both of those thresholds.
Right. Okay. Inwood Park, which is where you're proposing to make the contribution, because that presumably is where you anticipate residents from the appeal scheme will recreate. So it's a contribution to serve their needs. That's beyond the walking distance that the mayor would expect to a local park.
That's the benchmark that is set out in this document for local parks, but we are within the threshold for district and metropolitan parks.
Right.
And in that basis, maybe we shouldn't be paying a contribution.
Right. Okay. Are you now seeking to suggest that the contribution is not SIL compliant, that you just
Well, no, I mean, the
confirmed
contribution, maybe the
was?
contribution
Right.
should be to Hounslow Heath.
Right. Okay. Okay.
And I just need to go back to the point that this is based on the London Plan
Yeah.
standards. The GLA SPG very specifically, right at the start of the document, if I can take you to paragraph 2.20,
Yeah.
very clearly says it is recommended that boroughs develop benchmark standards in the context of their play and open space strategies, taking into account their local circumstances.
Right.
And that is exactly what the open space strategy is.
Oh,
It has set a benchmark standard for the council, not a London-wide standard, which of course will accommodate many different types of typology, and therefore the standard that is applied for local parks, which is 1,200 metres, would count for Inwood Park.
So can I just ask, is this the draft open space report that you're referring to now, which is the one that you said in your rebuttal proof should be attributed only very little weight?
I was wrong in that regard because as I said in examination in chief, I considered it to be an examination document. When I read it in detail, I realised that it's an open space strategy in line with the old PPG 17 open space strategy.
Right.
And
okay.
it is in line with, sorry, let me finish, paragraph 98 of the MPPF, which requires boroughs to assess their open space audits,
Okay.
and policy S4, the London Plan, which says very similar wording. So that is what the status of that document is. I think that document actually has reasonable weight because it's a document that's been produced in line with national policy, local London policy, and wholly in line with the SPG, which also says in paragraph 2.20 you should develop your own benchmark standards.
Understand, Mr. Tickle. So you hadn't read it carefully when you wrote your rebuttal proof, and you've now changed your position.
I've changed the weight that can be given to it. I haven't changed my position.
Understood. So I'm just looking at the time. I think I'm within 2 minutes of my time estimate, and I'm just going to see what I can just skip over so as not to exceed in any significant way.
I'm happy to quite continue, sir. So I'm happy to continue. So, yeah.
I'm sure the inspector is keen for me to keep as close to my time estimate as I can. Thank you, Mr. Tickle.
I'm glad you're so keen, though,
Yeah.
Mr. Tickle.
Okay.
That's a fixed grin, sir.
Just so I'm not taking every point. I'm just a couple of points on the planning balance, please. In your proof of evidence, you say twice that the planning statement on schools development is central to the appeal scheme. You use that at paragraph 4.2.15 and 6.1.2 of your proof of evidence, don't you?
Yes, I do. Yes.
Yes. The planning statement for schools development was not mentioned in the planning statement accompanying the application?
No, it wasn't.
Okay. It was not mentioned in your statement of case for this appeal?
No, the MPPF great weight position was, but it wasn't referenced in the statement of case, nor was it referenced in the committee report.
No. Well, your 4.2.16 of your proof, page 15. Let me know when you're there.
I'm there, yes.
Okay. You seem to be, in the final sentence of this, criticising the officer's report for failing to mention the planning policy statement for schools development, which you yourself failed to mention in the planning statement and statement of case.
The officer, I am not determining the application.
Right.
As you very clearly set out at the start of this cross-examination, it is down to the committee. It's a democratic decision by the committee, and therefore officers must provide to their members all relevant evidence. Whether it was or wasn't referenced in the planning statement was an omission on our behalf, but that doesn't mean that the officers shouldn't have been diligent in picking that up.
I see. So you hadn't provided all relevant evidence. Do you feel now, looking back, that you misled the planning committee?
No,
No.
no, not
Okay.
at all.
No. No. And that's because the presumption in the planning policy statement
I
for
didn't
school,
write the officer's report.
and that's because the presumption in that policy statement should be applied as expressed in the MPPF. That's what the policy statement says, yes?
It does, yes.
Okay. And as expressed in the MPPF must be a reference to paragraph 95 of the MPPF?
Yes, it's the great weight that must be given to
Yes.
schools development. Yeah.
Yes. And the officer's report did cite paragraph 95 of the MPPF at paragraph 8.3 of the officer's report? Yes?
Yes, they did, yes. But they
Right.
didn't reference it in the conclusion.
Right. Okay. Well, fine. So members were clearly advised of the importance and the significance of the school delivery in accordance with national policy.
Yes, sorry.
Okay. And Mr. Ringer acknowledges the policy support in paragraph 95 of the MPPF, doesn't he?
In his proof?
Yeah.
Yes, he does. Yes.
And he attributes great weight to that benefit.
He does in his planning balance. Yes, he does.
Okay. Thank you. Can I just be clear on this? In the circumstance of this particular appeal, I appreciate that we differ on the agent of change principle and whether the scheme accords.
Mhm.
If we're right about that issue and the scheme doesn't accord with the agent of change principle, can I just be clear from you whether your advice to the inspector is nonetheless that permission should be granted?
If in the circumstances, the theoretical circumstances,
Yeah.
because
Sure. I'm in the scenario that you don't agree with. I accept that there's
Yes.
conflict with agent of change principle. I fully appreciate that you say there is no conflict with that
there is
principle.
no conflict.
So in the scenario, though, that there is, the inspector finds there is a conflict with the agent of change principle, I just want to understand, please, is your advice to the inspector that he should nonetheless allow the appeal?
I would say that in terms of the overall planning balance, looking at all of the development plan as a whole, and we've skipped over the provision of affordable homes, we've skipped over highly sustainable development, we've skipped over the use of brownfield land, which are all themselves got presumptions within the MPPF, or the significant weight should be given to those. And I think that on balance, yes, I would say that if there was a non-compliance with D13 and paragraph 187, that it would still carry on planning balance would still be acceptable. It would depend as well as to the extent of non-compliance, what you're describing as non-compliance with the policy.
Okay,
well.
can I just clarify just one thing there? You said non-compliance with D13 and 187 of the MPPF. I think we've agreed, haven't we, that D13, D14 and EQ5 are all relevant to the agent of change principle?
They are, but
Okay,
but EQ5 doesn't specifically reference agent of change.
Okay, fine. My question then is, if the inspector finds there's conflict with D13, D14 and EQ5, does your position remain the same? You would still advise that permission should be granted?
I think that we'd need to look at all of the evidence. But
I mean,
I
having regard to
believe
all
it's
the
a
evidence.
theoretical position,
Well,
and I think that we are getting to the bounds of what could be considered acceptable to say.
Well, Mr. Tickle, I hope it's not too difficult for you to weigh up all the evidence that is before the inquiry that you've heard and to give the inspector just your advice.
But my advice is that we are in accordance with D13, D14 and EQ5.
I understand.
And therefore, the theoretical position is not relevant.
Are you not able to contemplate a counterfactual scenario, Mr. Tickle? Is it not possible for you to say, all right, that's my position, but if I'm wrong about that, I think X or Y?
I'm happy to go down that route.
Okay, thank you.
If you want us to go to a counterfactual position, but I'm not sure how much it's adding to the inquiry.
All right. Well, indulge me. If there's a conflict with those policies, please, is it nonetheless your advice to the inspector that the appeal scheme should be allowed?
I think It would be an on-balance decision
Yeah, and your view would be?
that it should be allowed.
Right. So I think I'm 6 minutes over my time estimate and I have no further questions. Thank you, Mr.
Thank
Tickle.
you, Mr. Tufnell.
Right, okay, thank you for that. We'll finish there for today. Obviously, that's the first part of the cross-examination, and there'll be some cross-examination from the Gurdwara tomorrow. So, Mr. Tickle, I'm afraid you'll have to have a night without speaking to anybody. Tomorrow, we're going to finish with Mr. Tickle, and then we've got conditions, obligations, and closing submission. So we've got quite a lot to get through.
So I don't think I'll look at Mr. Ringer. I don't think that the conditions session and the 106 session should be a long one, hopefully.
And it's fair to say that the time estimates for closings are usually a little more accurate because they don't involve any unknown quantities.
Yes. Okay, well, one way or another, we're going to sit here until it's done. So, so fine. I don't think that we're going to need to spend too much time with conditions and planning obligations, but I do have some comments about conditions in particular, and obviously I'll want to be taken through the obligations and what is being secured.
But I suppose, can I just suggest it might be sensible for the council to ensure that we've got hard copies of both the conditions and section 106 available for that session tomorrow?
Yes, please, that would be helpful.
For the appellant, yeah.
Okay, right. Any matters to raise then before we adjourn? Right, and is everybody available for 9:30? Yes. Good. Right. Thank you then. We'll adjourn until 9:30 tomorrow.